Good morning, everybody. Welcome back. Happy hump day. It's not even hump day because it's our last full day of the trial this week. Just a half day tomorrow, and then we get a long Memorial Day weekend. I'm not good at having the holiday schedule in my head. They sneak up on me. I don't see them coming. And so I'd kind of forgotten that that's why, like, that's coming up. I don't know what I was thinking about half day Thursday and Friday. Like, why is that happening? But then Jeff reminded me, oh, Monday's Memorial Day. And then of course it all made sense. We got to have plenty of time to get down to the Cape, to the beach houses, have our our warm up. Got to make sure we're really in shape for the festivities of the weekend. So then it all became clear. We have a lot of time off after tomorrow, and that then got me thinking about where the case is going to be. What's the jury going to be sitting there left with as they go into a long period of course, not being sequestered, but not getting any new information. Just if you think about the case at all, nothing to think about except what has happened up to that point, and just humans being what they are. Likely gonna remember the most recent thing you heard, maybe the first thing you heard. And I gotta wonder how that's gonna be sitting with them. I did see Christina Rex has confirmed, I guess. She's reporting that today the reason why Christina Hanley is not coming back is because they are taking a witness out of order. And so it seems very likely to me this is Jud Welcher. We're going to get Jud Welcher today. So he's the accident reconstructionist. Apparently, also an executive with Aperture. Forget his exact role, but one of the high level guys. And so I do wonder. I do wonder to what extent he's going to be asked or expected to take responsibility for Mr. Burgess and the problems with the qualification inflation. How exactly that might go. See, a lot of folks have dug into Aperture a fair amount, looking into background information and stuff like that. Quite a large company, 80 to 100 experts. That's a large company. Apparently, at least one of the old Massachusetts State Police accident reconstructionists has gone and worked for them. So somebody characterized it as a home for retired cops. It's where retired cops go to supplement their pensions. Go get that very generous public pension, and then get a little on the side with some expert testimony, just using what you learned as a cop. Nobody ever needs expert lawyers and like legal commentary, appellate process. Like what's the matter here? So if that is the case, today should be very insightful, and it makes sense to me if I'm the prosecutor and I'm structuring the case, and I'm claiming to have the facts, science, and data on my side. Then that should be where I'd want to leave it. I'd want to leave it there, which it makes breaking up the bumper sprinkles a little bit, maybe just more unfortunate. Not what I would have wanted. But if I'm taking the trade-off between what's the last thing that they hear right before they go to the defense case versus what's the last thing they hear before they sit with it for several days while we have a holiday and there's nothing else new coming in, maybe the priority is getting it in before that break. So should be insightful, because we have heard quite a bit about Dr. Welcher and his theory, but it's all secondhand. It's just being reported to us through the court process. We haven't seen his PowerPoint for ourselves, but we have seen certain parts of his slides. And of course, we just went through a process of, Shannon Burgess kind of impeaching Jud Welcher with the clock. And I have to tell you, I'm still not satisfied with this clock situation, because I'm still wondering what happened to the Waze clock. His syncing of John O'Keefe's phone to the SUV clock was based on the navigation data that we already know came through Waze. And we learned in the last trial, Waze runs on a monotonic clock. It's a separate clock from what runs on the phone display system. And because of that, there was an offset, and it was fairly significant. It was somewhere in the ballpark of 2.5 to 3 minutes. It was a fairly decent offset, and that meant if the Waze clock was what governed the location data, then all the events kind of got shifted back in time by about 3 minutes. And then that changed all of these key events. You know, when the 3-point turn took place, for example, all of these things like that, it would shift the time frame fairly significantly. And so I'm just wondering if this is still to come, if this is something that these experts missed, if it's just off the table now, if there was a mistake in that. It originated from Richard Green in the first trial. It was in his report. Or is it still coming? Because I feel like hints have been dropped, particularly during the cross-examination of Ian Whiffen, where they took time to have the state's expert identify the fact that there are multiple clocks, some monotonic, what that means, how they operate differently than the system clock. So it seems like that seed has been planted, but it hasn't gone anywhere at this point. And so if that happened and we shift Shannon Burgess's testimony, if his navigation data is pulled from Waze and there's an offset because of that, then that would do a couple of things. Number one, you would have the power off event, the power on and power off events. Those would both have to be shifted by about 3 minutes. So he's reported the power off as 12:42. But if the Waze offsets it, seems like that would have to shift back to more like 12:39, 12:38. The key one, though, being the point of that 3-point turn. So if the 3-point turn started at, wait, hang on, that's the second one. I want to find the 3-point turn time and not the so-called collision, the backing event. $12:23.58. $12:23.58. If we have to adjust that for Waze, now our time is shifted backward again, and we're at 12:20, 12:21, somewhere in that ballpark when she does the 3-point turn. And so all of this then would shift the timeline of those events in relation to the health data, because John's health data is picked up on the internal, the display phone, the iPhone display phone. I don't know if I'm making any sense or if this is just extremely confusing, but trying to make sense of the timeline in this case is really one of the most challenging things about it, I think. Here's the thing. if we're shifting the 3-point turn back in time to roughly, say, 1220, that 3-point turn, if that happened up on Cedar Crest before making the turn onto Fairview and then getting to the front of the house, they're not very far. It's not going to take very long to get to the house from this point on the map. A minute, maybe, if that. And so you'd have them arriving out front of 24 Fairview, roughly, 1221, somewhere in that ballpark. And then what do we have? We have on John O'Keefe's iPhone at 12:21:10 is when you have the 80 steps. So that's why I'm really curious about the Waze clock and if and how that's going to fit into any of this, because it changes the picture of what actually unfolded based on the data that we have. We don't have to get into, John's steps mean that he was in the car and therefore, was picked up because the car was going over hills or taking turns or things like that. It would mean the car has arrived at 34 Fairview and then there are steps. So it's just it's a residue from the last trial that has been hanging out there. I remain intrigued by it, suspicious that we're going to hear about it because there've been just enough seeds planted. But it's also like we're dependent on the defense to put this all together for us. What we've seen kind of repeatedly from the prosecution and their witnesses is that ambiguity is better. They don't want things to be too precise. They don't want to be too nailed down to any one thing because then it can be debunked. Then it can be disproven. But if you keep your options open about, hey, what is the range of the correlation between these two clocks? Stuff like that. If the time of the backing event doesn't necessarily mean that's when the backing happened, it's just when the data was recorded, then you build yourself a whole bunch of wiggle room to not have to show us real specifically, here is what happened when, here is the big picture, here's how all this stuff reconciles. The prosecution seems to be expecting us to do that work ourselves. And that's not a good approach when you have the burden of proof. To me, this is just screaming red flags that, of course, you don't actually have the facts, science, and data. If you did, you would systematically and clearly lay them out for the jury. You would explain the significance of all of them. You would show how they relate to each other. You would do all that work for them. You just make it easy. Make it easy, and then you can spoon feed it. So the fact that they haven't done that, to me, it's a big red flag that they don't have the facts, science, and data on their side because they're not trying to make it clearer. They're trying to make it more complicated and harder to understand. So we're really going to be dependent on the defense to tie this together and show us how does this support your theory of the case. Because if they don't do that, I don't know that the jury is going to know what to do with all this data. I really don't. And it's an unfortunate way to conduct a trial like this, where so much hinges on this technical information in how we interpret it. Whether there was even a collision at all seems to reside in this data. The defense has the incentive to kind of take the throw up your hands approach. Hey, if you don't know, blame the prosecution for that. It's not that the defense has a burden of proof, but that is just risky. It's just risky that if the jury defaults to, well, if there's data, then the prosecution wouldn't be showing us data if the data didn't show she was guilty, something like that. You just don't know what they're going to do with it. You just don't know. So you got to make it as clear and as simple as possible. So I really hope that's coming. And I I would expect and I would anticipate and hope that cross-examination of Jud Welcher would make it clear where they're going with that. That part of the cross-examination would be about showing us, where is your analysis going to differ from the defense analysis? Where are the key points of disagreement here, so that we can really isolate what are the different implications of the defense's interpretation versus the prosecution's interpretation. So I'm hoping we'll get that today. If I'm the prosecutor and I want the jury to have something to sit and chew on before they go into an extended break, and I think my expert is going to have a claim to fact, science, and data, then yeah, that might be where I want to leave them to sit. But if the defense has a good argument about why their interpretation of the data is wrong, then that could be a real miscalculation. It could be a real miscalculation to leave the jury to sit with that. So potentially fair amount at stake over the next day and a half. I wanted to share, I go and find stuff on X sometimes real quick while we're still waiting for the court. Oh, my girl, Brandi Churchwell, man, she went to town on this taillight. She went to absolute town on this taillight. And, I've seen people do reconstructions like this before. There was a similar one that was floating around last year. It's a very helpful visual, I think, because you can see kind of the clusters of things. Like, what are the odds? What are the odds that this taillight hits hits an arm, supposedly an elbow or whatever. It shatters, it sprays all over the lawn. And yet the collection pattern is so consistent. Like, people are always finding chunks of the same piece of taillight at the same time. Somehow all of the pieces of taillight are found, right next to each other. And they're not like randomly distributed. They're not they're revealed by the snow in the same kind of pattern. It just seems a little hard to believe, doesn't it? Like, why did CERT find these two pieces right there and not I don't know, one of the ones closer to the top, like Proctor found on February the 18th? Like, why would it be so consistent with how this taillight shattered and then was rediscovered? It seems very, very hard to believe. Seems very hard to believe that the only piece that's missing is this angled part right up at the top. It happens to look like, if you look at that still photo from the dash cam on the morning of 8:30 in the morning on the 29th, taillight's covered with snow. Can't see exactly what's going on with it, but it does look like there might be some kind of defect with it. But it appears to be right in this area where this part is missing. And all of that happens to be what's not recovered. It's very coincidental. It just seems very coincidental. All of these pieces found just by Proctor. Then these little ones over on the other side. But all these pieces, that whole side of the taillight, nothing found until February 8th, February 11th, February 18th. Proctor out on his own. No documentation of any of it. No photographing of any of it. No real chain of custody of any of it. Because it's not booked into evidence until some point later. Gets into the lab on March 14th or something like that. It just seems like a lot to buy, doesn't it? All these pieces just happen to go to one part of the lawn where it took the longest for the snow to melt. Remember, after February the 4th, the snow is almost gone. It's raining by February the 4th. By February the 10th, when Buchanan is back out there, Buchanan is saying about the only snow that's left at this point is what's left of the piles. But remember, CERT moved those piles and they carefully sifted it layer by layer. So all of those piles would be snow that CERT had already shoveled and moved. And CERT didn't go on the grass. Like, yeah, these stories are just kind of all over the place. So I wanted to share that just because I for one, I remain fascinated with this tail light. I think the tail light is there's a nice little breakdown of all the kind of source pieces. You know, I have looked at this reconstructed tail light so many times, and whoever is able to go through here and stare at this and match it up with these individual shapes of these pieces, you guys have way better eyes than I do. Like, there's no way, absolutely no way that I can look at that reconstructed tail light and see, like, oh yeah, here's this piece over there. Here's this piece over there. So some good work here from Brandi, our girl Brandi. This is her thing, man. I don't know if you're following. If you're not following Brandi, not listening to her coverage, man, she's a very detail oriented person. Really like the work that she does. Another one like our Sleuthy Goosey, who's just really good at organizing information, making sense of it, showing how it relates to other pieces of information and stuff. So really enjoyed this work from Brandi. Go check her out if you haven't. Guys, there's so many good creators. So many good creators on this case. A lot of good people to watch and check out. The other piece, though, that I was interested in, Brandi hasn't gotten into it, but maybe she will. Maybe I can put a bug in her ear. Maybe word can get back. Brandi, help us with the missing pieces. Show us which one of these pieces, if you're able to go through and match up which of these items here, these individual items ended up in this tail light, then you can also show us which ones didn't. Please. Please show us which pieces did not end up back in the tail light, because that's something I want to see. You know, if there's like big pieces not ending up in the tail light, that seems significant. It seems significant. Where did it come from? Which ones when? That's part of the information I think is critical, because if CERT, for example, is out there finding plastic that's taillight plastic, but it doesn't match this taillight, then what the hell is it doing out there? In the street, okay, in the street, I get it. There's debris in the street. I have no idea what the street cleaning schedule, if any, is in the residential neighborhoods of Canton. So I can conceive there might be broken taillight from some other incident out there. It could last for a long time. Not out of the realm of possibility. But then once we start going back for these other searches, the stuff on the lawn. Yeah, what's non-matching taillight doing up there on the Albert's lawn? That seems a little bit harder to explain to me. Seems a little bit harder to explain. I mean, it doesn't look like a neglected lawn, you know, kind of boneyard that gets old junky cars and weeds growing up and stuff like that. It's not that kind of lawn. It looks like a decently well-maintained lawn. So a bunch of taillight plastic all over your lawn. From what, when, what's it doing there? How come you didn't go clean it up earlier? I don't know, guys. I just have I have a lot of questions about that. And the taillight seems to me to be one of the key issues in this case. It's one of the reason I'm fascinated by it is because If Karen Reid was framed, this is where it happened. This was it. I mean, some of it is the scurrying and telling stories and stuff like that. The information that was passed around, and how you can see the movement of the I hit him, and the evolution of the I hit him, and stuff like that. How that spread once it was initially conceived, sometime after January the 29th. So I mean, you have that, but that's just talk. That's just talk. Actually pinning it on the girl, so to speak, that kind of frame up, that's in the tail light. That's going to those cert searches on January the 29th. And there's just not really a good way to get around it. That if they found taillight on the lawn, that either means it's Karen's, and they found Karen's taillight on the lawn. That either means there was something that caused Karen's taillight to be left there sometime before 5 p.m. on January the 29th. There was some kind of event with Karen's car, or the taillight pieces were taken there. I don't know, guys. I don't know. What else do we have? What else do we have today? Still thinking about that decision to kind of break off Christina Hanley in the middle of her bumper sprinkle testimony. Not quite sure what I think about that. That was Judge Canoni initiated, right? She got us out like 20 minutes early yesterday, almost half an hour early yesterday. In the middle of the direct testimony of Christina Hanley is just starting to explain that she did a visual examination comparing the pieces of glass that were found on Karen Reid's bumper in the sallyport on February the 1st with the glass tumbler that was found out at the scene where John's body had been lying on January the 29th. And visually, there was no match. She was just starting to get into her microscopic examination, her instrumental examination, which is where it got interesting in the last trial, because it's not the same glass. It's you have different molecular qualities, different. I don't even know. I don't even know what the right description is. They don't match. It's not the same material. But the jury hasn't heard that yet. She was literally like a minute away, maybe, from that point in her testimony leading up to that. And we're going to cut it off right before we get to that point. So I'm not sure what I think about that. Number one, it means, of course, now she's going to have to come back, and then that testimony is going to be, it's going to be brought out. Like, you can't avoid it just by deferring it. News to the Commonwealth: deferring, putting it off, procrastinating does not make the bad facts go away. It's still a very bad fact for the Commonwealth. But it means the jury's not sitting with it over the long weekend, right? That's part of it. I'm also picturing what this is going to look like when we come back. And we have Lally. We have Lally. And granted, while Lally is like a new man this year, he's just he's transformed. He's on like a wellness. Lally is really kind of feeling himself a little bit more these days. Perhaps watching Hank flail has done some good for him. But he's still Lally, still very repetitive. Got to ask all the same questions about the proficiency testing and the lab accreditation and the cleaning the benches in between, like all the preliminary kinds of things we've heard from every single lab witness so far. That's because Lally is going to ask every single one to repeat all of that. A lot of repetition with Lally. So I can envision that when we get back with Christina Hanley, we're going to have to kind of get back into that Lally lull. We're going to spend some time recapping what we already heard. We're not just going to pick up. So you were talking about your microscopic examination of the glass, the pieces in the bumper compared to the tumbler, and tell us about that inspection and what did you conclude from that? No, that would be, we're right there. We're ready to get going for the day. We're paying attention. That would not be Lally's style. We're going to have to spend a while reminding ourselves, getting reoriented, with what's already done. And just given the kind of droning and repetitive nature of that, it does tend to put you in a little bit of a lull. So he's going to lull us into that new information about, on a chemical level, these materials do not match. This is different glass on the bumper than was found at the scene. And so it's another piece of the Karen Reed was framed. Another piece of the Karen Reed was framed. Probably not as strong a piece. Probably not as strong a piece of evidence because we already know that the car, the SUV, was sitting there in the CPD sallyport, basically unguarded, uncovered. The cameras don't work, so it's not like there's any security that comes from the surveillance. So, you can't rule out, oh gosh, it's different glass. Somebody broke a glass in the sallyport. Somebody dropped their bottle of, I don't know, Sobe drink or whatever. I don't know. What do people drink in glass bottles these days? Do people even drink out of glass bottles these days? We're not in the Snapple era anymore, so I don't know. It's just some explanation like that. Where it just happened to be there, happened to end up there, totally inadvertent. But then, the lab people show up and they're examining it, and of course they mistake it for evidence. But it's all just all perfectly innocent. It's not, but so much of this case is about deniability, plausible deniability, and how much can you engage in shenanigans and then disclaim that you were engaging in any kind of shenanigans at all, kind of like with your resume. It's totally cool to have a degree that you don't have on your resume listed as pending for like a decade. Because you have plausible deniability, you never actually claimed it in a court of law. You never actually claimed it in a court of law. So all plausible deniability. So, they could come up with some explanation for why there's, unmatching glass 3 days later on the bumper in sallyport. It's not quite as strong a showing of the frame up, I think, as the tail light because of that. But it's still not good. Where did this glass come from? And I think that's where the defense has a potential opportunity to be able to throw that back on the Commonwealth. You have the burden of proof. You're the one that needs to explain the evidence, show how it's consistent with your theory. And we have no theory of this glass. We never got one in the first trial. It just kind of gets elicited and then it gets forgotten and gets dropped. Just bring it in the middle and kind of bury it. Never mention it again. And for some lawyers, ignoring the bad facts is a strategy. I've never found it to be a very good strategy, a very effective strategy, especially because if your opponent knows what the bad facts are, they're going to be highlighting those. And so you better have figured out a way to explain them, or you got a pretty high chance of losing your case. You got to have a way to mitigate the bad facts, or this may be a case that you have no business bringing to trial. So the defense can maybe throw that back around on the Commonwealth You've given us no explanation for where this glass came from and how it ended up on Karen's bumper. It doesn't match anything at the scene. It's just a mystery material that appeared kind of out of nowhere while the car was in the Canton Police Department sallyport. It's not good. Not a good fact for the Commonwealth. That's why we call it the bumper sprinkle. It's just a little sprinkle. And another approach the defense could take to kind of highlight that. I don't know if you do it, but to the extent your defense is about the investigation and the failures of the investigation and the questions raised by the investigation that are not put to rest by the evidence at trial, you got to be very careful. You got to find a good way to kind of work through some kinds of issues or topics or implications or whatever. But one of the instructions that the jury gets is, hey, even if you think she probably did it, that's not enough. That's not enough. Has to be proof beyond a reasonable doubt. And the issue with a bad investigation, particularly a corrupt investigation, and one of the reasons why it's so damaging is because let's imagine for a second Karen Reid had done it. Let's imagine she had done it. You can lay it squarely at the feet of the investigators that there are problems with being able to prove that because they didn't secure their chain of custody. They didn't properly document their evidence. They didn't use proper evidence handling techniques. And look, lo and behold, kind of looks like somebody maybe took a little bit of initiative to try to just add a little something to make it make the case that much stronger. This is probably, the kind of thing it's probably what got OJ off. It's probably what got OJ off is the fact that they found blood. They found blood of Nicole and I think Ron, I think both of them. The car, OJ's house, outside. But the problem is some of that blood had anticoagulant in it. And human blood doesn't normally have anticoagulant in it. When human blood has anticoagulant in it, it's because it's been put in a tube where there is anticoagulant. So it raised serious questions about the source of that evidence and how it came to be found at the scene. And it ends up looking like a situation where you already had pretty good evidence against the guy, but you just needed to go and try to make it a little bit stronger. You just needed to try to put that final nail in the coffin. And so you bent the rules to do it. And congratulations, because of that, you may have very well blown up the case. I think they have the potential to make that sort of point with something like the bumper sprinkles. You have Michael Proctor in his group text already saying he's giving away the game. Homeowner's not going to get any shit. Going to pin it on the girl. Just took it upon yourself to add a little bit, just try to make it a little bit stronger. Of course, you're still a good guy because you have the best intentions. Remember, we often have a virtue ethics mindset in criminal justice. A lot of the participants have a virtue ethics mindset in criminal justice. Virtue ethics is goes back to Aristotle, and it's this idea that what is good? Well, good is what a virtuous person does. It's kind of self-defining, right? If a person of virtue does it, then obviously it would be good because by nature of being a virtuous person, you would do good things. And so people get this idea, well, if I'm a good guy, what I do is good. So if I'm on the right team, I'm a white hat person, What I do is good. You're on the bad guy team. You wear the black hat. What you do is bad. So I'm on the good guy team. If I'm planting pieces of taillight and sprinkling glass on the bumper, it's good. It's for a good reason. It's justified. It's because of the righteousness of my cause and so forth.
All right, could I see counsel at sidebar, please?
Went straight to sidebar. A lot of that type of mentality shows up in criminal justice. I'm a good guy, therefore what I do is good. You're a bad guy, therefore what you do is bad. A lot of just essentializing of people. He's a cop. He's testifying, therefore he's telling the truth. God, that presumption. Can't even tell you. Can't even tell you how many times you run into that presumption in court. Having an evidentiary hearing or something like that. You got a cop who's not real strictly wedded to the truth, but it really doesn't matter because the judge is going to find him credible anyway. Why? Because he's a cop. Because he's a cop, and your client, your defendant may have a different recollection. Your client's recollection may even be substantiated by other clients or other evidence, but I can tell you it is more often, in my personal experience, all the cases I've read, that the judge will find your client is the one that lacks credibility, not the cop. And often no real good reason for that other than just, who's wearing what hat? Yours is the guy that stands accused, so he does bad things. So he's lying. He's making it up. I don't care if he's got a witness. I don't care if the cop's explanation doesn't really make a lot of sense. The cop is the cop. Therefore, he's only doing good things and we're going to find him credible. Very common mindset in criminal justice. And so that can be internalized too. You get that reinforcement enough from other people, from the outside, from the other folks that you work with, other members of your club, so to speak. It's pretty easy to internalize that. I'm a good guy. Therefore, I don't have the burden of proving my virtue through my conduct, through my ethical behavior and my integrity. I just am a good guy. And therefore what I do is good. So it's a distorted, of course, take on Aristotle, but Aristotle's whole point is like to be virtuous. You have like this feedback mechanism. The good conduct, the virtuous conduct makes you a virtuous person. Being a virtuous person makes you engage in virtuous conduct. So it's like a feedback loop. But a lot of people twist that a little bit. They look at the one direction. I'm a good guy, therefore I engage in only good acts. But don't look at whether you are in fact a good guy, judging you by the quality of your actions. Well, a little bit of a late start today. Not sure what we're needing to deal with here right now. See if I got anything else that's come up that would be good to share. Not
All right, so let's bring the jurors in, please.
The jars. There's a nice Massachusetts accent. The jurors is the jars. That almost feels a little mid-Atlantic, a little the jars. Daily fight prefers jurors. Jurors is fun. Jurors is fun. That's good in Southern. Jurors. Oh, okay, guys. I'll just tell you. People like to see boxing stuff. You know, the people like to see the trees. People like to see boxing and stuff like that. I posted a few things, but I don't post boxing very often. And one of the reason why is you have to learn to breathe when you punch. And so you see it real common in the amateurs. Because you got to keep your teeth closed too, right? You got to keep your jaw closed, so it's like a ch kind of sound. But you get real tired and you start making sounds, and so it sounds like I'm saying like Jew if I work really hard. Jew.
Good morning, jurors.
I can't put that up, guys. I can't post that in this era.
An
It's
issue
not gonna
has
happen.
come to my attention that is going to make it necessary that I talk to each one of you individually over at Sidebar with counsel. So that process.
There's been an
So
issue.
I'm going to don't speculate as to what I'm going to talk to you about. Please, when you go back to the deliberation room, talk about anything but this case, and I'll see each of you individually. And the process may take. The cameras will be shut off.
There's a juror issue.
No filming. All right, send you back and we'll get back. Thank you very much.
Okay.
All right, now I'll see counsel.
Now she'll see counsel. Don't know why the fan's off today. Okay, well, what does this mean? It means that there is some issue that may taint the jury. It likely has to do with information or comments, some type of behavior that a juror is engaging in. The reason why you need to question all the jurors individually is because you need to see if the other jurors have been affected by whatever the issue is. If it's something like outside information, somebody has gone and researched, somebody has driven by, the scene, somebody has looked stuff up on the internet, then you have to find out who else heard it, who else knows about it. Are they going to be able to put it aside? That type of thing. If it's something like a juror has been engaging in some type of misconduct, making comments. I mean, we heard some of this from the last trial, right? That was the complaint that I think it was juror number 4 had brought to the court, that there was another juror who was just making comments about negative comments about the defendant and the defense case and stuff like that in the presence of the other jurors. So juror number 4 brought it to Judge Cannoni's attention, and somehow that turned into juror number 4 is the one who engaged in misconduct because wasn't forthcoming about discussing it with the other jurors. Anyway, things like that can happen. And so if you have a juror like that one that they were complaining about in the first place, in the first trial, then yeah, you might have to question the other jurors to see who's heard it. Do they know about it? Can they confirm it or not? Probably less concerned about has it influenced you or had an effect on you or anything like that, but often just comes down to, can you substantiate if this happened or not? There's been an accusation and a denial. So we got to ask everybody. We need to make an evidentiary record of what the situation is. So those are the possibilities that jump to my mind. Probably not the entire universe of things that could be going wrong, but when you're talking to the entire jury, it does indicate there's some issue with either information seep, exposure to something that's improper, or because you need to make an evidentiary record of whether something happened or not. So I guess we are going to have a little bit of a wait. So I'm going to go ahead and start looking at your comments and questions, guys. See where you guys are at. But does your mom deny it? Sure. So have we heard anything truly damning for the defense? Am I missing something? It's going to depend at this point. The two damning things I think they have at this point, the taillight pieces that CERT found, that's damning. You know, the defense has to have a way to manage that, to explain that. They may be able to just rely on the lack of proper documentation and chain of custody. We went to all this trouble to put Connor Keefe on the stand to testify. Yes, it was Tully that photographed the items, and I was the one who bagged them. And here are the pieces that we found, and so forth. And yet, strangely enough, Connor Keefe's name is not on the bag. His initials are not on the bag. He's nowhere on the bag to be found. He's not the one that sealed the bag. He didn't do it immediately. So there's a little bit of a gap there. Maybe that's all that the defense will rely on. Could have been a thing to point out in cross too, but really didn't, Mr. Keefe, you just opened this evidence bag. You just identified these pieces of plastic as the ones that you bagged during the search. You described your bagging process as, you put it in the bag, you take the bag back to the police department, you seal it, you put it in temporary evidence. Whose initials are these on that bag? These are not your initials, and this is dated February the 4th. That's not the date that you collected these items. Just point out that discrepancy in the bag. But it didn't happen. So, I mean, the CERT taillight pieces, they're not good for Karen. They're not good for Karen. So defense has to have some explanation for that. We know what it is. We know their explanation is those taillight pieces were planted. Part of the pin it on the girl. So we know that's what their theory is, but have they landed that yet? Not real clear to me. Not real clear to me one way or the other. And then as far as the vehicle data goes, it's this braking event. Or this not braking, this backing up event. That's the piece they have that, I mean, I guess if you want to believe that there was a vehicle accident, you can look at that and point to that and say, yeah, this shows that there was some type of incident right around the time when we're expecting, under the Commonwealth's theory, some kind of interaction between Karen's car and John. So is it just a coincidence that this event occurred right around the time where we're trying to establish a vehicle collision? A juror that wants to convict can probably look at that. Again, is there mitigation of that? Yeah, I think there's mitigation of that. Spent a lot of time at the top here just talking about the issue with the clock from the last trial and the Waze clock. Do they even have the right clock and the right timeline? Still some work to be done on that, potentially. There's no black box data, right? This is all coming from infotainment. There's no black box data. Surely they know a massive amount about the safety systems in a 2021 Lexus LX 570. I mean, this is a very advanced car. It's a luxury car. It's going to have what was state-of-the-art safety technology back in 2020 when this car is being manufactured. So yeah, I'm going to expect a lot of sensors, a lot of detection, a lot of different types of information that can be picked up. The braking system, the steering system, potentially the engine, engine rev, engine RPMs, that kind of thing, sudden acceleration. I mean, I don't even know what else goes in like a car safety system. I expect a lot on this vehicle. So that's a lot of potential sources to be able to confirm, hey, if there's a collision, you would think it would be picked up on a state-of-the-art vehicle safety system, but it's not in any black box data at all. It's just a backing maneuver that the infotainment system picked up. So potentially room to make some make some hay out of that, for the defense. But it depends on what they have and what kind of prep they've done, what type of independent research they're going to be able to present to substantiate that had there been this type of collision, you would expect it would show up on those. I come back to this exemplar testing that Aperture supposedly did, on Karen's car. I have a hard time seeing how that's not, you wouldn't be just recreating what you think the event was and seeing how it shows up on the data. Like, wouldn't that be like step one? You would recreate the events that you think took place, like the 3-point turn, like the backing into the arm, the rapid acceleration and so forth. You would do that and you would see how it shows up in the vehicle data. And if it shows up in the vehicle data the same way that it shows up on Karen's car, then you've got a really good case. Seems like you've got some data that shows this is how the car records this type of incident. Maybe that's what Dr. Welcher is going to tell us about. I really don't know. All we got was this vague, they did testing on an exemplar from Shannon Burgess. So, those are kind of my quick takes on what's damaging so far. Karen's clips, the clips. I think if you want to find her guilty, if you're inclined to be suspicious of her and think, oh, she probably did do something, she's sitting there accused, they didn't just make that up out of thin air. You could look at some of those clips and see them as potentially not helpful. Potentially not helpful. So, I mean, truly damning for the defense. No, there's no smoking gun in this case. There never has been. There's never been a smoking gun. If there were, that it would be front and center. And the Commonwealth wouldn't really need to present a whole lot else. You would just have the smoking gun. If it was on the ring camera across the street, we'd be done. But it's not. So it's all circumstantial. And that means, how damning it is depends on how strong of an inference can we draw from this particular fact. And that's where the defense's job is to highlight, okay, here's a fact. Infotainment system recorded a backing event, but here's why you can't draw a very strong inference from it. Backing event in and of itself doesn't really mean anything. It records a lot of those, even when there's no collision. The collision should show up in the black box. By the way, your time frame is way off, anything like that. I think is going to help undermine that. But it just depends on your perspective, guys, and the bias. We all have bias. What's your bias that you brought into that courtroom? Are you inclined to be suspicious of Karen because she's sitting in that defense table? Or are you inclined to give her the benefit of the doubt and, require the Commonwealth to overcome your skepticism? And those are going to give you very different perspectives on the evidence that's been presented. Riri 911 question. Thank you for your coverage. The defense nullified SB, in my opinion, but I am wondering what a juror might have taken away to support the Commonwealth. I think it comes down to the braking maneuver. If they buy his analysis that there was a 3-point turn and then ended up at Fairview, and then roughly 7 minutes later there is this sudden, or not break, I keep saying braking, but it's a backup. the backup maneuver, if they buy that, then they're going to be thinking about what caused that backing maneuver? Why would you do that? What caused it to be registered on the infotainment system? And then what's the data associated with that backing maneuver? We haven't gotten into any of that yet. That's probably going to come from Welcher. I think we know from the last trial that this was the, accelerating over, I think, 20, up to 24 miles an hour. I want to say it was over about a 6-second period. And then there was a rapid deceleration. And in the last trial, what we talked about was, there's a lot of fresh snow on the ground. And so it's not uncommon to have bad traction. You spin your wheels, when you're trying to get moving. Is that a potential explanation for this type of data being recorded? I don't know if I had a 2021 Lexus LX 570 exemplar to just test out. I might test that out. Might check that. See if I can rule out that kind of explanation for why this is recorded on the infotainment system, but not showing up in any kind of black box. If I got to spin my wheels because of poor traction, how's that going to show up? I don't know. Just putting that out there. But I think the bottom line is that if the jury buys this timeline and this general sort of sequence of events, then we have a backing maneuver of some kind outside of 34 Fairview. Commonwealth is saying happens to correspond with when John's phone stops moving. So it just depends on, is this a coincidence? Does the timeline work? But that's what we got from Shannon Burgess's testimony. If you put aside his personal history, credibility types of problems, and just, the data, go with the data. The data is the data. All we have at this point is his interpretation of it. So we don't really know. We have a little bit of a preview of what some of the challenges are from Matt DeSogra, but at this point, that's really the only version of events we have. So that, I think, is what comes out. It's the backing maneuver combined with the sudden, lack of movement in John's phone. John's phone coming to rest and never doing anything else again. Andrea McBurnett, did you catch Hank asking Burgess if he was trained in cell phone hacking? He replied no, but it is listed. Your thoughts? I did catch that, certification. It could just be a certification that he's let lapse. I mean, a lot of these, you got to re-up periodically to maintain the certification. It's all just part of, ostensibly, of course, it's you have to keep up with all the newest versions and the new information and what the tools are doing now and what new information they can parse and stuff like that. It is very important to be cutting edge with this type of expertise. But a little of it is also like, it's guild-ish, you gotta protect the guild and just, require people to signal their guild membership by maintaining these certifications and stuff like that. You don't necessarily go to like overall, maybe very specific competencies, but like general overall competencies, may not change a lot without significant changes in technology. So anyway, I think a likely explanation is it's just a certification he had, but he's let it lapse for whatever reason. It didn't strike me as a huge problem, but potentially just another little oversight as far as not going out of his way to keep his resume, his CV, really up to date. Honey Kid, Burgess trying to line up their timelines like me in 1997, trying to match up Dark Side of the Moon and Wizard of Oz. Those were the days, man. Those were the days. Yep, I remember doing that. I remember doing that. It was all right. It was all right. There was really only like a couple moments. I forget exactly how you lined it up. There was a whole like formula. You had to wait until a certain point on the screen or whatever, and then you started it. And then there were these sinking points, and the only one I really remember being like the ooh wow sinking point was when the Wicked Witch of the West first appears on her bike. Um, but yeah, those were the days. They do. They got to find just right to make it look like these things fit together when they are in all likelihood completely independent. This is nothing but a spurious correlation. Teddy Bear 1287. Green opined that Waze could have been using only the monotonic clock. That's why the stairs climbed was not while driving. It depends on whether you believe the stairs were due to driving or not. Yeah, I mean, I remember very clearly because we had Green's testimony. He showed us the report that he had gotten. I think it was from the Axiom report, but it might have been one of the other tools. I just can't remember, but it showed the different clocks, and his whole testimony had been there was an update to the software that now showed you this new information, the different clock types and stuff like that. And so it shows waves on the monotonic clock. It shows like what the offset is of that clock. And so that's what all of that was based on. And so the effect of it, if you applied that as the defense was arguing you should, it meant that, yeah, John is, we don't have to explain John taking steps and climbing stairs as, the iPhone is picking up activity while John is sitting in a car, because it shifts the timeline enough that they would have already arrived at 34 Fairview when those steps start to take place. So it was a way of reconciling the different pieces of information. Whether that makes sense or not, probably again depends on your perspective. What's the easiest explanation for why there are steps on John's phone? Because he took steps. That's the simplest explanation. Is it impossible that it registered steps because he was riding in a car? I mean, I guess not, but I don't know. I don't know. I'm not an expert. It just seems unlikely to me. That doesn't seem like very good health technology if it's that imprecise about what it's picking up and labeling as health activity. So, yeah, it was a way of reconciling those particular issues. Matthew Austin, I don't understand how the times are adjusted. I get that you compare when the phone and the car recorded the same event, but then how do you determine the correct time? It would be easier to imagine a simultaneous event. This is part of the problem from my perspective with what the Commonwealth is doing here with this adjustment. If you take a simultaneous event like a clap, and that clap is recorded on my camera, and that clap, the sound of it is also recorded on my microphone. Okay, then I can go in and look at where I have a visual. I can like look at the sound associated with my video. See the waves, the peaks, and things like that. I can look at the frame on the camera where my hand is like this. The clap is happening. I can find that peak in the sound, and I can make sure that those match up. And then that's how I know there's none of that annoying lag in my video, where your lips are moving, but the sound is somewhere else and they aren't lined up. And so it's weird looking. It's all bizarro world with that. Had that issue with when I was running the DSLR system. So we'd have to go in and correct that. And that's how we would do it. So when you have an instantaneous point like that, you can see, oh, here it is on this measurement. Here it is on this other measurement. So we can just bring them into alignment with each other. It's the same time. And now everything else, if it took us, if we had to offset this one by a second and a half, then we know that time frame has shifted a second and a half to get to that alignment. The reason why this is such a challenge in this case is because we don't have a an instantaneous event when we're talking about a 3-point turn. It's an activity that takes place over time. And we also don't have a specific point where a 3-point turn has happened. Like, when do you define the 3-point turn? We don't know. We don't know that. I mean, I don't know that even just conceptually in general. Philosophers could debate that for centuries. When is the 3-point turn a thing? The ontology of the 3-point turn. When does it exist? Does it exist when you start the reverse? Does it only exist when you start the heading back the other direction? I don't know. I don't know. But then you also have that complicated by the fact that we have no idea what the Lexis identifies as a 3-point turn. We just know the Lexis gathered some data and the Lexis decided some of this data indicates 3-point turn. But what data, when, what points? So it's very unlike the situation where I have a video of a clap and the sound of a clap, and I can visually look at these things and align them. They're simultaneous events. I don't have to guess about when the clap is occurring or what the clap even is. It's that. But with the 3-point turn, we have this amorphous event that we are trying to tie to this amorphous data. That's I think why it's confusing. Because it's fine in principle, that you would do this. You would find the event and sync it up across the two different clock systems. But when you don't have a fixed event, you're trying to compare clouds, and at what point are they at the same point? We have no idea. So I think that's probably why it's a little bit confusing in this case. Kate, and when did Ryan Nagel say he saw them? Ryan Nagel said he saw them about 2:30, right? He said he saw them about 2:30 or 12:30. But we know that that's incorrect. There's the text message from Julie Nagel back and forth with him that we had from the first trial. We know it's more in the ballpark of like 12:21. He texts here. Ryan Nagel texted here. I'll check that. I always like to check things against Sleuthy Goosey's timeline. 12:15. I take it back. 12:15 from the grand. That's from the grand jury testimony. Ryan Nagel arrives at 34 Fairview to pick up Julie Nagel with his friend. 12:15, according to that timeline. Let me see. Let me see if somebody has got the timeline with the text message. Have to see. Ryan Nagel texted Julie Nagel that he was outside. That's at 12:23. That's at 12:23. So, we got some conflicting data. But as far as this trial goes, I believe the jury heard 12:30, and I'm not sure that they have any other information at this point to potentially question that. Time Cop, starring Van Damme as Higgins. I haven't watched Time Cop. Gotta tell you, not the biggest Claude Van Damme fan, Jean-Claude Van Damme, but I'll take your word for it. He seems like that would be an upgrade for Higgins, just personally. My Mini 67, the heroic hair. Andrea, don't get into the weeds with the timeline. As an old engineer, there's only one way of assessing data. Keep it simple, stupid. John O'Keefe was not hit by a car. I think this is a very tempting perspective because at the end of the day, we have John O'Keefe's injuries and John O'Keefe's lack of injuries that you would expect from being hit by a car. And he has injuries that can't be explained by being hit by a car, that look an awful lot like being in a fight. He's got blood patterns on his clothes that look an awful lot like being in a fight. And I think this is very legitimate. You could keep it that simple if you want to, and it does make sense. All I'm really trying to do is look at this how a juror might be inclined to look at it. What are they going to do with this evidence? What are the different ways that they can interpret it? A juror might not want to keep it simple. They may not want to keep it simple. We saw it, saw it in the last trial. Listen to juror Ronnie talk about it, how they were there kind of trying to figure out what happened, trying to solve it themselves, see what they could make out of the testimony. And even though that isn't the juror's job, so to speak, very normal for them to do that because they want to make the right decision. They want to not let a guilty person go free. They want to not convict an innocent person. So they want to be pretty sure about what they think happened. So I don't know if the juror is going to do this. I think this is very logical, good advice, but I don't know if this is what the jury is going to do. And if anything, we know the Commonwealth is going to kind of discourage them from keeping it simple. Here's why we have the new accident reconstructionists and the different theory and all of that. 3.5 years later, we have a different timeline. We're on like the third timeline. Keeping it simple doesn't benefit the Commonwealth, so they're going to make it difficult to do that. They're going to try to throw up a lot of stuff that is suggestive or that just implies a bad inference against Karen. And we just don't know what the juror is going to do with it. To me, I'm in 100% agreement. The John is the story of this case. That's what got me interested in this case. Seeing John, really, they're saying that was a car accident because this guy looks beat up. And then waiting through that entire first trial to explain to me how was this guy hit by a car and not beat up, and we never got there. For me, it really was that simple. I mean, I remember when they're showing his clothes on the stand, and I'm like, that's it, I'm done. Okay, this pattern of blood stain, I've seen this so many times in the ring. Seen it so many times. Drips down your front, down your pants, onto the top of your shoe. That is an upright person who is bleeding from their face, bleeding from their head. For me, it is that simple. I just don't know if it will be for the jury. Sandy B, Matt McCabe company invested in Aperture in 2024. It's on Jen Starr's website. I've seen some people going into this. I don't know if it's the same Matt McCabe or not. I don't know. I can't really confirm this one way or another, but I do see that folks have been doing some digging into that. I did see that I can't remember his name now, but Matt Klain, Andrew Klain, I think was his name. One of the former MSP accident reconstructionists, retired, now working for Aperture. So I did see there's some overlap there. Michelle, talking about the seconds Karen might have been at 34 Fairview seems insane since none of his injuries are consistent with being hit by a car. It would be good to keep it that simple, wouldn't it? Maybe there's a way to try this case that keeps it that simple and keeps it that focused. It just means you're really gambling on nobody hanging their hat on the Commonwealth putting all this data out there. You would be basically dismissing this data, minimizing the data. It doesn't really matter because at the end of the day, John wasn't hit by a car. We'll see what Welcher's explanation is, right? Welcher is ultimately the one with the burden to show us how John O'Keefe was hit by a car, how these injuries were produced, how that is consistent with the damage to the car. How is that consistent with where he was found on the grass? How is that consistent with the taillight pieces and the tumbler? He's going to have to propose a mechanism. I'll wait and hear it. I'm skeptical. I don't expect a complete explanation that accounts for everything, like, the vertical blood dripping down his front. How he gets hit, only on the elbow because there's no bruising anywhere else. The bumper couldn't have hit him, right? The bumper hit him. He's going to have at the very least a big old bruise, somewhere probably on his thigh or something. Nothing like that. So he's just hit on the elbow. That is not your center of mass. So how does that cause you to end up over there, up by the flagpole? I don't know. I'm skeptical, but I'll give him a hearing. And I think, that's to be expected. They're going to come up with an explanation. And so there is that risk. If the jury is suspicious of Karen, they think she probably did something. There's too many coincidences here. All you got to do, all the Commonwealth has to do is give them something to hang their hat on, to be able to say, look, okay, it wasn't conventional, but yeah, he was hit by a car. And their expert showed it. So it's just a big gamble to leave these other pieces on the table. I know, I'm with you. I don't think there was a car accident here. I think his body tells the story, but you just don't know what the jury's going to make of it. Summertime, did Emmy find any plastic in the cuts on John O'Keefe's arm? None that was ever reported. Nothing that's ever been documented like that. No plastic in the cuts on his arm. No blood on the taillight pieces either. So how there was this breaking of the barrier of the skin and no transfer, I think is very difficult to explain as well. HRH Princess Chelsea, my Subaru won't allow me to hit a bush. The Lexus has the same system. Why isn't? And you're addressing this. Yeah, so I don't know what the situation is with the safety system. Like I would expect a 2021 Lexus would have had like the most cutting edge safety system at that time. That means we were protected from impacts from all sides. We have sensors from all sides. We have automatic backup. We got the mirrors everywhere. We got the cameras everywhere. We got alert systems. We got all of that kind of thing. Maybe we will hear about it. Maybe the reason we haven't heard about it yet is because it's not beneficial to the Commonwealth. So we expect to hear about it when we get to Karen's case. Maybe. I don't know. To me, the safety system is really important because, yeah, that's where you expect, if there is an incident that implicates people's safety, that's where you'd expect it to be recorded. Not in the infotainment, the sound and the nav system. You don't expect it there. Like a fine wine, it's Higgins's Jameson tumbler that he keeps at this station. I mean, who knows what it is? Who knows what it is? The bumper sprinkles. It's not the tumbler that was found with John. We know that. So where in the Commonwealth's theory is it accounted for Karen ending up with other glass on her bumper? Was there another collision? Was there some incident in the sallyport that went unreported? Don't know. Commonwealth's never tried to explain. Why don't these bumper sprinkles match the glass that was found over there by John? Especially given their whole theory. Quite a coincidence that when you're alleging he's hit in the arm holding a cocktail glass and projected out into the lawn and it breaks the cocktail glass and he ends up He ends up deceased out there, and she ends up with glass on her bumper. It's quite a coincidence she ends up with glass on her bumper when you've alleged this type of crash, this mechanism. But it turns out the glass isn't the tumbler. Doesn't look real good. Pirate 2031, what do you think about Burgess saying yesterday that Hank told him to send the report? That makes the per my request being copied even more ridiculous. Yeah, I mean, maybe. Hank told him to send the report the day before. The per your request, if we're reading that sentence as a whole, the per your request is the request for additional analysis. Per your request, I have performed the additional analysis. I have considered the following items, whatever that exact language was, but it was per your request, I have done the additional analysis. So it's not per your request, I'm sending you this report of this information that I independently decided to go look at because I realized there was a problem. Of course, it doesn't say anything like that. Was Hank hoping he might change that? He might tweak it? I don't know. I doubt it. He doesn't seem to be worried that Judge might have some grave concerns about his claim to have been completely surprised on May the 8th and received it out of the blue. In her mind, this is probably all very consistent. Probably all very consistent. But I don't buy the I don't buy the cut and paste. I don't buy the cut and paste. That's not how you write letters, for one thing. You would use an existing one as a template. It's not a cut and paste. You would use a template, and then you would go and delete what's already there, and then you would put in, what's relevant for this particular case. And so if there's some stuff that carries over that's common between these letters, you have the same like disclaimer in it or something like that all the time, you wouldn't eliminate that. But why would you just not eliminate per your request as you requested, whatever it started off as? To me, that doesn't make a lot of sense. Erica, I work in this field. Firms like Aperture always verify all education, starting with high school, and certifications before hiring. PhD Welcher, EVP since 1992, would never skip this. It's not an oversight, it's deliberate, in my opinion. Interesting. Very good information. Good to know. It makes sense. That's your job, to proffer experts. People are trusting you to have gone through and sorted and selected and verified. If you just go to them and you need to hire an expert and they give you somebody unqualified, this firm is not going to last. So it makes absolute sense that they would do that. I mean, it's hard for me to imagine, why would you hire a digital forensic engineer or a digital forensic examiner just based on them saying they know how to do it, just based on them putting on a resume, that they have certain skills. You just take it on faith. I mean, what is the vetting process? I do wonder if that's going to come up with Welcher. EVP, I don't know what to make of that or not. Vice president is really not the most impressive executive title. Doesn't necessarily mean you've got a lot of authority or a lot of oversight. Sometimes it can just mean you have the most time in, you have seniority, more or less. I don't know how significant the EVP title is, but it does put him with the executives. And so you would expect him maybe to at least know. How do you go through and vet people? It's not like academic fraud has never been heard of before. So yeah, it makes sense to me. You'd go through and verify as much as you can just to be sure. Good information, Erica. Very interesting. Andrea McBurnett, are discussions at Sidebar recorded? Yes, they are. Sidebar discussions are always recorded. They should be part of the public record, certainly by the end of trial. Very limited circumstances where there would be information brought out in the trial process that is not public information that we don't have a right to see, because we have a right to monitor how the courts are carrying out the people's business. Courts are there to do justice for us. We get to evaluate how they're doing. So if they're at the sidebar and they're, talking about the jurors by name or something like that, we're not necessarily entitled to know the jurors' names, but that doesn't mean we don't get to see the sidebar. It should just mean you go in and redact the juror's name. We get to see everything except for the very specific things that we can't. And that's how it's supposed to be done. So yeah, they're recorded, they're transcribed, they are very much part of the record, and they should be part of the public record. Guy Mitchell, look at tail light when on tow. I see more red. Guys, the camera views of the tail light are they're like an ink blot test, is my perspective. It's like an ink blot test. You see what you want to see. If you want to see a broken tail light with white light shining through, you'll see that. If you want to see a tail light that looks identical to what the tail light does on the other side and red where there is not supposed to be red if the tail light is broken, you will see that. I know for me, looking at the car going out of John's driveway, it looks to me like there's red everywhere there is supposed to be red, particularly over to the side when the tail light is on a corner. And so when we see the busted taillight in the Canton Sallyport garage, the damage goes around that corner. It's a big red piece that goes around the corner over to the side. So there should be some missing red over there on the side under the Commonwealth theory, and yet there is red over there on the side. So I think that's just the problem. The problem with these taillight videos, low light surveillance, low definition, low quality, pixelated, etc. They're not made for capturing the details of how the light appears in the dark, which is not what these cameras are for. So you don't get the level of detail that you would need to do a like pixel by pixel examination of where there's light and where there isn't. Eliminate all of that distortion and stuff like that. So I see them as kind of ink blots. They're independently not particularly helpful. Whatever you want to see in them, you will. Law and Lumber. Hey, Rob, usually only one thing that causes unknown delay and immediate sidebar. Called it, lol. Odds on who reported the issue. Yeah, I guess you called it. If you were calling a jury issue at the beginning of the day. I didn't call a jury issue because I'm not, I'm very accustomed to Bev being late, and I am accustomed to starting off immediately with the sidebar. So I don't know. I didn't call this one, Rob. You were ahead of me on the uptick there. But odds on who reported the issue, the fact that they're questioning the entire jury, does that perhaps implicate a juror reported the issue? I think it might. I think it might. We have to ask the entire jury, either because we need to verify if there was like an incident or something like that. We need to get everybody's recollection of what took place, or there's been some kind of taint introduction of impermissible material into the jury room, and we need to know who knows about it. Those are the most common scenarios I can think of off the top of my head. You don't need to go talk to the entire jury if somebody is just sick. You don't need to talk to the entire jury if somebody remembers, oh, I didn't recognize that name when it first came up on the witness list, but as soon as Christina Hanley got on the stand, I remembered she was my best friend in grade school, something like that. Those things do happen during trial. They do happen, but it doesn't require you. You don't have to question the entire jury for that. So when you have to question the entire jury, it's a pretty limited set of circumstances, and so that's where I'm coming down. That's what I think is likely. Either some kind of taint, some kind of information that shouldn't be in the jury room has been brought in, or there's been some type of misconduct and or allegation of misconduct, and the judge needs to explore whether it happened or not. Julie Andrews, is it typical to have so many jury issues? The bigger the jury and the longer the trial, the more likely that you are going to have these issues. Unfortunately, I'd like to say it's rare. I'd like to say that jurors diligently follow the rules and stuff like that. But I don't know. It seems to me like that may not be a good assumption. It just seems like this tends to be a problem that comes up a lot. Saw it in the Ghislaine Maxwell trial, right? The juror that had lied about their personal history to get on the jury. Saw it with Murdoch, allegations of the stuff the jury was not necessarily supposed to be considering and stuff like that. One of my very first trials, we had this issue. It was I don't remember which number it was. It was way back in the day, maybe second or third trial. I don't remember. But we had an issue where the jury convicted my client, and then I don't even remember how it got reported. If somebody called in to the defense and or what exactly it was, but somehow we found out that one of the jurors had gone home that night and done a whole bunch of legal research and brought it into the jury room. Here's what the statutes say. Here's this and that and the other. So we had to go through this process. You go in and in our case, we just sent the investigator out to talk to the other jurors and evaluate, get their take on, did this happen? Was this brought into the jury room? Confirmed that it was. So we get a new trial. Love to say it doesn't happen, but it kind of seems like it happens with some frequency. I think the real question is how well does the rate of catching them line up with the rate of it happening? Because if we catch them this many times, how many times is it going on and it's just not being caught? I got to wonder about that. You can see an argument both ways. Just in general, you'd kind of always expect that your catch rate is not going to be 100%. On the other hand, you do have a little bit of a prisoner's dilemma problem. Somebody's bringing bad information into the jury room. You're really gambling that those other 11 jurors are not going to mention it to the court, that they're going to all be on board with it. None of them is a real stickler for the rules and is going to report you. Maybe sometimes the gamble pays off. I don't know. So I think just in general, longer trial, more jurors, the more risk that you're going to have stuff happen. Erica, in no world is it permitted to list a degree program that you are working towards and have not obtained. Not in our business. Dr. Welcher knows this. See, this makes a lot of sense to me too, because it's not horseshoes, okay? Almost got a degree is not having the degree. It's not having the degree. So almost is not a qualification. Especially when you're talking about something with a BS, with like a BS, a Bachelor of Science, because what does almost even mean? If almost is, I completed all of the degree requirements, but I don't know, didn't show up for my thesis defense, that's almost. But I took a few classes for a semester and I flunked out, that's almost too. Like both of those are, you didn't get the BS. And there's just no, there's no meaningful distinction between those. You didn't get the degree. That's why the line is drawn at you have the degree or you don't have the degree, because we're not going to sort out, are you sort of qualified because you took some classes, and distinguish you from the guy who did everything but defend his thesis, but still didn't get the degree. You know, we draw the line that you have the degree or you don't. You met the qualifications or you didn't. And part of what that's testing is your ability to follow the rules, follow the instructions, govern yourself accordingly. You know, these are what the rules are and what you have to do. And you're good at doing that or you're not. And that's got a little bit of carryover to something like, you know, working in a lab, working as an expert with data. Because you're going to follow the rules that, you know, the data and the analysis, the method requires you to follow, or you're not going to. So it's kind of an important skill, an important qualifier from that standpoint. Your ability to do what you need to do to achieve the objective of obtaining the credential. Makes sense, Erica. DD Gris 77. Andrea, so here they do separate witnesses. Lol. Ironic. The witness sequestration is pretty much a norm in most trials. Like, it's not required. They can waive it. Any party can waive it. If both parties waive it, then the witnesses can sit in the courtroom. And it does happen. You know, it just depends on who the witnesses are, how complex the issue is, all that kind of stuff. It does get waived sometimes. Not that often, but it does. So it's not required, but it is just kind of the norm. It's kind of routine. It's kind of expected. If one party asks for it, you're more than likely gonna get it. But the experts are routinely exempted from that because you're more helpful to the jury if you're able to take in what's going on in the trial, what is the other side saying, how do I respond to that? If you hear what the jury heard, you're in a much better position to be able to answer what issues, what questions may have come out as a result of that testimony. If you're just kept in the dark, you don't really know what's important or what's significant. You're disconnected from what the jury's already thinking. So it's more helpful to do it that way. But clearly we are not in this case. We are also exempting the experts. That is not the norm, but also not against the rules. Warrior, 2 minutes before her announcement, I was watching Peg look at the jurors and whisper about them. Could she complain and cause this questioning? Interesting. You know, I really hadn't thought about this aspect of it, because we don't have solid information. We just kind of have rumor. But we have seen, okay, Paul got moved into the back row. Paul used to sit in the front row all the time. Now Paul got moved into the back row. Rumor is that it has to do with his behavior, his expressions, the staring down of Karen and so forth. But that's not substantiated. You know, that's as far as I can tell, that is rumor. Maybe something to do with the reactions. We have seen reactions. I mean, we just got a pan yesterday, a pan of the camera over to the family sitting in the jury box while Shannon Burgess is being cross-examined, and there's big eye rolls and stuff. I can't say it's not related to that. If there's some kind of complaint, I'm wondering if it would be the complaint going this direction from the family about the jury, or would it be the jury about the family? I don't know. It's a possibility. I don't think we can say it's not this. I don't think we can rule that out. But I doubt we will find anything out until the trial is over, just because of the gag order. I don't think we're going to be able to find out unless the judge tells us there's been, some kind of issue. Feral AF, in my opinion, JM picked up taillight in JO Drive and dropped at 34, then deleted the ring footage on John O'Keefe's phone later. I've thought about this too. The fact that Karen's car was over there at One Meadows. According to Jen's testimony, she already knew about the broken taillight. Karen told her about it. Karen showed it to her. So she had that prior knowledge. There's that missing. Apparently now maybe a few pieces of missing footage from the ring camera. We know for sure that the time that Karen and Jen and Carrie left One Meadows Ave that morning, that video is gone. We know that when Karen later the afternoon, 12:30ish, 1 o'clock or so, when she went back and got her car and left One Meadows and drove to Dighton, that footage is also missing. But the house was unattended. It was empty from the time that the welfare check got there until the members of the O'Keefe family started showing up. I don't think we have a time frame for that. Again, it should all be on the video. It should be something that could be reconstructed if it's there. But so, yeah, we would expect there's a period of time where Karen's car is sitting there in the driveway and it's unattended. The whole house is unattended. Anybody who wanted to could go in and get those taillight pieces, find them in the driveway or whatever, and go leave them on the front lawn. It's a maybe. It's a maybe that could have happened. If she went back, so Karen's statement in the clip in one of the documentaries, I can't even remember now whether it got played or not. I think it did, where she talks about leaving, going outside the One Meadows with Jen and with Carrie, and she shows them the tail light and it's cracked, and she picks a couple of pieces out and drops them in the driveway. So if that is correct, then, Jen would know, hey, here are these pieces there. We could just go back and retrieve them, use that to pin it on the girl, to set it up. I guess the question I would have is, given where the defect appears to be on that body cam or that dash cam video and that screenshot, and given the pieces that were never recovered from the tail light, to me, what makes sense is that that's the part of the tail light that she cracked at One Meadows, that rectangle that was never recovered. And that's why they never found that plastic, because that plastic is there at One Meadows. And, the rest of the red was all that there was available to break off and go plant over at 34 Fairview by the time, the car is in their possession. So if Jen had gone to recover plastic from One Meadows Ave and plant it at 34 Fairview because, Karen had picked the pieces out to show her and whatever, it seems to me like that would be the clear pieces, the ones that never got recovered. But would there be anything stopping Jen from going over to One Meadows and, breaking off the bottom red part, which is, remember, look at, I got to bring it back up. Look at Brandi's chart, so to speak, of where did my bookmarks go? I had it bookmarked. And now, there it is. Look at where those pieces are, guys. I'm a little big on this. Oops, that's not what I was looking for. Get me off to the side. The first pieces that Cert found are right there, underneath the broken part. So, can somebody go by and just grab that and rip it off, drop it at 34 Fairview? Yeah, they could. Is it Jen? I don't know. But it does seem possible. Can't say it didn't happen. If we had the entire ring footage and we knew what was missing, it would help us evaluate possibilities like this and potentially rule them out. Jack Mirius Tactheratrix. Judge is speaking to each juror individually. Yeah, the individual questioning is what suggests that there is something. I mean, it affects the entire jury, whatever the issue is. And so outside information, faces made, I mean, whatever. Some type of improper contact. I don't know. But a need to question each juror individually tells us that it's whatever the issue is potentially affects the entire jury. So it's not just somebody got sick, somebody had a personal emergency, somebody had healthcare issue emerge. It's not that. It's something more significant than that. Just Mimi Sue, interesting timing for a jury issue when the Commonwealth is failing. They flail for a while, so we need to throw out the jury and get a new one. Risky strategy to do that. If you provoke a mistrial as the Commonwealth, then that mistrial is not necessarily manifestly necessary. So that would be a very risky thing to do, but I don't know, weren't we just about to get to the grand finale, the pyrotechnics show of the facts, science, and data that Mr. Brennan told us we were getting in opening? The facts, science, and data are on his side, remember, and the whole I hit him is just a sideshow. It's just corroboration, which is why we've heard the I hit him 500 gazillion times and are only now in week 5 finally starting to hear about facts, science, and data. Maybe the Burgess dud threw off the whole pyrotechnics show. Could be. Crochet it ain't so. I like your mug. Where is it from? This mug was a gift. It's a Starbucks mug. Look at that. It's a nice Indiana mug. It's got all the little things on it. The Indy car, of course, it's got the Indy car up there. Just a nice little scenery, but this is just a Starbucks mug. This is a gift somebody gave me over there at Delphi, and I really enjoy it. It's a very nice mug, and so glad you enjoy it too. And I appreciated that gift very much. Alaris Pilot. Did you see the video of Bev seeming to signal to the prosecution to object during Shannon's testimony? If so, what are your thoughts? I did see that. I've mentioned it. I don't really see anything that screams to me as, there's like, there's some kind of communication method that's been worked out between these people and they're sending signals back and forth to control how the trial is going to be handled. I don't see that. What I do see is kind of like a shared perception, an inside joke kind of situation. When I watched it, what it looked to me was like, they're listening to what's happening. They're paying attention to what's happening. Alessi is cross-examining this witness. They're anticipating already where it's going and what the problem is. They've had multiple sidebar conversations, about how these types of things are going to go. So what I see is questioning unfolding, and they're both recognizing what's happening, and they're on the same page about it. And so she knows an objection's coming. He objects. It's expected between them. And I don't particularly have a huge problem with that. I think that's kind of normal over the course of the trial, that you get on the same wavelength as the other people. You start to have the same patterns develop. And Bev's reaction to it, she was very smiling. It was funny. She's laughing. She's like gleeful about it. It looks like inside joke stuff to me. that kind of thing gives you pleasure. You share a little funny with somebody else. So in and of itself, that particularly, it doesn't bother me. It doesn't look like, oh, there's, direct signaling, orders being given and taken, nothing like that. That's not how I read it. What troubles me about it is it does look like, you know, Hank Brennan is not somebody I want to be on the same page at. Like, I don't want to vibe with this guy. Like, no, no, that's the problem. The problem is the company you choose to keep and that you choose to have your inside jokes with and stuff like that. Having that type of closeness with that person, that's what bothers me about it. Uh, not that it's like a direct, corruption or something like that, but just if you're giggling with one of the sides to the case, like in and of itself, that's really not ideal. It's not great behavior to be manifesting on the bench by a judge. But the fact also that you chose this guy, the one that just lied to your face about I was completely out of the blue. I was caught by surprise when this report showed up, that type of thing. You've had all these grave concerns about the other side, but this is like your pet. Nah, it doesn't look good. That's what I have an issue with. Harley Quinzel, my kids are in 7th and 9th grade and are now both interested in law. Thanks to you, Andrea. Thanks for how you help us understand the law. Well, thank you so much for that. I appreciate that. I would encourage your kids to give really strong consideration to medicine. Kind of an inside joke, We have to shit on the profession a little bit. Lawyers do. It's kind of in good fun. It's kind of tongue in cheek, but it's also kind of not because it's a difficult job. It's a hard job. It's a lot of work to get through. It's a massive amount of responsibility. It's a lot of just, you know, time pressure. There's different ways to mitigate that. The biggest piece of advice that I give people who are thinking about a career in law is, to the extent you possibly can, unless your goal, and it's a realistic goal, is to end up on the US Supreme Court or something like that, then where you go to law school, it really doesn't matter. It has little to no practical impact on your career options. It'll probably take being a Supreme Court justice off the table, right? Because you pretty much have to go to Harvard or Yale. Very few exceptions to that. And that's the DC club, in general. You want to be the Secretary of State with your legal degree, probably go to Harvard or Yale, that's going to be necessary. But outside of that, or if that's, maybe you want that, but that's, let's be real, not realistic for most people, then it doesn't matter where you go to law school. And so if it doesn't matter where you go to law school, there is really no need to rack up a massive amount of debt to get a law degree. Go to the cheap place. Minimize the debt is the best advice I can give you as somebody who's considering going into law, because it will give you so much more freedom in the profession. It may take you a few tries to land on, here's a practice that resonates with me, that I enjoy doing. It gives me the kind of quality of life that I want to lead. You might have to explore to find that. But if you're coming out of law school and you have $250,000 of debt that you have to pay off, your options are limited. You have a very strong tendency to get stuck at, wherever you are that will pay you enough to be able to service that loan. And then if you hate it, it's too bad, so sad. So there's a lot of burnout, a lot of job dissatisfaction in the law. Debt plays a huge part in that. So to the extent you can free yourself from that type of constraint, then the law can be a fabulous profession. Just fantastic. It can open so many doors, whether you're talking about legal practice or just having the kind of information, the way of thinking about things and seeing the world that can be helpful. You can work for a company in compliance. You don't have to be a legal practitioner. Just a lot of different things you can do with a law degree. So definitely appreciate that. But if your kid's considered medicine, it probably wouldn't be the worst thing in the world either. Mrs. Micmac. Hi from Sydney, Australia. So glad to catch you live at 11 p.m. I love to hear your perspective and thoughts. Much love, XX. Thank you so much for joining us. I appreciate all you folks from Australia who are putting in some very late nights. If you're coming in and watching this live, I mean, I know Australia is a big country and you got a lot of time zones and stuff like that, but on the other side of the world, like we're just getting up for the morning. It's time for you to go to bed. So appreciate those of you, and I hope that you're not letting this interfere with your health. Sleep is critical, guys. Sleep is really critical. We're glad to have you with us, and thanks for joining us. Brandon Guidis. Chances Proctor takes the stand, not for the Commonwealth. I think it's pretty clear the Commonwealth is not going to call him. You can't end on that, and you're right at the end of your case. The time to call Proctor, if you were going to do it, was quite a ways back. Probably around the time, like it was in the first trial, they called Buchanan and then they called Proctor. That would be logical. It's a little more buried in the middle. It's a little bit more coherent with how the structure of your case is being brought out. So he's not getting called by the Commonwealth, but by the defense, I think it's a near certainty. I think it's a near certainty that he gets called. You don't just leave that guy on the table when you have ammo like his text messages. Tell Julie to give the gift to Elizabeth. Ugh. No, you don't leave that on the table. And the only pathway to get that in is to call him. So I think it's a near certainty that the defense calls him. The rural juror, has the Dighton tow truck theory of 11-6-22 been debunked? Not going to lie, I was only half paying attention to the timeline yesterday. So in the first trial, we had an issue because the key cycles were not time stamped. So this event, this 11-6-20, it was 1162. This is a key cycle. It's the power on, power off. And in the first trial, they weren't time stamped. So the way that the right key cycle was identified was by going backwards and identifying events when the car was turned on and off that would have registered a key cycle. So if we have a known, number of times that the car was turned on and off between the time that the collision, would have taken place until, the data was extracted, then we'd be able to go back and identify this is the one that happened in front of 34 Fairview. So in the first trial, the issue with 1162 was it didn't seem to match that because we knew about the key cycle for the testing when the police took it out into the parking lot and did the acceleration and braking test, had to turn the car on and off to do that. We knew about the unloading it from the tow truck. We knew about the loading it on the tow truck. We knew about picking it up from Meadows and driving it to Dighton. We knew about starting it at John's house and driving it to Jen's and then leaving it over at Meadows. So that was 5. That was 5 key cycles that needed to have happened after 34 Fairview. And the math didn't math. It didn't work. So that's how it was debunked, more or less, in the last trial. They just pointed out, look, here's the times it went on and off, and that doesn't get you to 1162. It gets you to one of the other key cycles. But now it sounds like they have timestamps associated with, more or less the same thing. So if they have, time and date stamps from the computer that put this put this key cycle at, 12, 12, I think he said 12:12 to 12:42 or something like that on the 29th, on January the 29th, then it seems like the count is off for some other reason. Either I don't know, maybe not every key cycle is recorded. Maybe there's extra times it was turned on. Like, I don't know. I don't know how that reconciles or if it reconciles. But I think part of the issue here is because they got that additional timestamp information since the first trial. And it seems to be valid, at least in the sense that, like, Matt DeSogra seems to accept it as valid. We're just arguing about how the clocks reconcile. So it seems like there is just perhaps a little bit of more information uh, since it was debunked in the first trial. Lawyer nurse, Andrea, did you see photos I tagged you in posted by Laura Alessi, his daughter? It seems you have boxing and his mind in common in interview, maybe. I did see that. A whole bunch of people tagged me in it. Laura Alessi posted a little side by side of her, her in the ring and Alessi with his boxing gloves up. And I've seen there's, like, I think it was in the documentary, Alessi's doing his shadow boxing. I love a good boxing family, man. Okay, tell me this entire family doesn't know that this man was beat up and thrown on the lawn and was not hit by a car. Of course the entire family knows, dude. They box. If you box, you hang out in boxing gyms, you know what it looks like when somebody gets their face all mashed up by by somebody punching them. You know how their blood drips. Like, I feel like I especially get, like, I see you, Bob Alessi. I see how you knew that Karen is not guilty of this crime, because it's a lot of the same stuff that I saw. So I did see that. I thought that was pretty cool. Hey, we should, have a little free Karen Reed smoker, a little spar sesh, something like that when this is all said and done. I think that would be hella fun. Jennifer Devine, can the court really tell if a juror went online? Is that legal? It's probably not legal for them to be, like, stingraying the jurors, for example, wiretapping them. No, that's generally not going to be legal. But the way that the courts find out is that somebody says something about it, and then it gets reported. The juror goes home and looks up some information online. They come back, they tell somebody on the jury about it, and that person goes and tells the court. That's typically how they find out about it. No, I would not expect that they are, like, monitoring the jurors. I don't know how you would even do that. It would be extremely problematic. So no, I suspect it would be from a report somebody made. James Casatelli, what's something that hasn't happened in this case that surprises you? Seems like almost everything that could happen in a trial has happened in this one. Nobody has had the Perry Mason moment on the stand, right? The Colonel Jessup, that you can't handle the truth. We haven't had that yet. Maybe that will come. Maybe we'll get that. Who knows? But I can't say that I'm particularly expecting that. That tends to be a pretty rare event. Something that hasn't happened in this case that surprises you. I guess my initial kind of reaction to this is that you would think, okay, if this is a frame job, there's no accident. Look at John's body. He was not hit by a car. So this is a frame job. If that's the case, there are so many lies that have to support that. And lies are kind of at the heart of cross-examination and what it's about and what it's targeted to reveal. Looks like they're coming back. And so obviously, a lot. Oops, let me get the right one up. obviously a lot of that has come out, but just kind of only by implication. There hasn't really been a lie that they haven't been able to answer yet. You know, it may not be a credible explanation, but they always have an explanation. The butt dial, you know, they have not been cornered in a lie they can't talk their way out of. And if it is a frame up, there are so many lies that it seems like maybe that
All
should
right,
happen.
so jurors, I still have a couple of questions for you. Were you able to follow the instructions and refrain from doing any independent research or investigation into this case? And we've discussed the other two questions, but I do need to stress for you that it's very, very important that no one discuss this case. Don't let anyone talk to you about the case, no comments about the case. You've seen how hard the lawyers have worked to pull this case together for you, and everybody's given it so much time. So please, let's make sure that we follow that.
Is that a
means
hint?
each other. So with that, I know we're late getting started. We're going to take an abbreviated lunch today, only 30 minutes, and abbreviated breaks. So no morning break. We're going to start now and go till 1. All right, Mr. Brennan, and we're taking a witness out of order. I apologize. We've got a witness here. Sometimes we take witnesses out of order. Ms. Hanley will be back later for the rest of her testimony, but we've got a witness here that we'll call out of order. Thank you. Mr. Brennan, thanks.
Thank you, Your Honor. The Commonwealth calls Dr. Wolf.
Dr. Wolf. This is going to be Dr. Aizik Wolf.
Stand up, step up, face the clerk, raise your right hand.
Not Welcher, the neurologist.
You haven't seen the court and jury in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, doctor.
Good morning.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spell your first name and last name for the court reporter?
Sure. My first name is Aizik, Aizik. It's phonetic. Last name is Wolf, W-O-L-F, like the real thing.
What do you do for
Like
a
the
living?
real
I'm a
thing.
brain surgeon.
Is there a special part of medicine that you study?
Well, my main interest in brain surgery is brain tumors and trigeminal neuralgia. But I also specialize in movement disorders. I do pediatrics and adults.
Are you an active working neurosurgeon?
I am a very active working neurosurgeon. I get up every day at 4:30 in the morning to go to work, 5 days a week. I take call 300 days out of 365 days a year.
Did you work yesterday?
Yes, I did.
What type of work did you do yesterday?
I did 2 brain surgeries yesterday.
Are you working tomorrow?
I have 4 surgeries scheduled for tomorrow, which is why this is a little bit delayed for me, and I have 4 on Friday.
And what type of surgeries do you have tomorrow and Friday?
I have 3 brain tumors, 1 trigeminal neuralgia, and on Friday I have 4 patients with movement disorders.
You're here today as a witness. How much of your practice, how much percent of your income is from being a consultant or a witness for a case?
Probably less than 1%. I don't do this for a living.
I want you to take us through some of your education and background. Could you share with us where you went
education
to
matters
medical
now?
school and where you graduated from?
I went to Yale Medical School. I graduated summa cum laude.
Was that in 1981 that you graduated?
Correct.
After medical school, did you begin internships in medical residency?
I did an internship at Hennepin County Medical Center, which is a trauma center in Minneapolis. I then did 5 years of neurosurgical residency at the University of Minnesota.
And was that in Minnesota?
Correct, in Minneapolis.
Is there something about that hospital that has some specialty?
It was one of the #1 training centers for chairmen in neurosurgery at the time.
Did you, in your residency and in your fellowships, do any work or study in pathology?
During your residency as a neurosurgical resident, you do 6 months in neurology, you do 3 months of neuroradiology, you do 3 months in pathology, which includes autopsies on brains. And then you do rotations through a trauma center as a chief resident, through a VA hospital, and then ultimately at the university hospital for elective cases. We also do 6 months of pediatric neurosurgical residency.
Did you do a fellowship at New York University?
Yeah, at NYU, I did a fellowship before I went to the University of Maryland as a professor in brain transplantation. The interest was in using cells to create dopamine centers in rat brains with the concept of Parkinson's being curable with transplantation.
I'd like you to take us through some of your faculty positions, and so that you can share with us some of the progression of your training and experience. And did you begin at the University of Maryland Hospital?
Yes. In 1987, the University of Maryland recruited me to start their epilepsy surgical program and skull-based program. And then part of our responsibilities as assistant professors was to cover shock trauma.
Could you explain for us what shock trauma means and whether the University of Maryland Hospital was a shock trauma hospital?
So the University of Maryland and shock trauma were actually two separate entities when I started. A man named Cowley had basically developed the concept of the golden hour. So prior to Dr. Cowley, most trauma was just taken locally. That meant as a community hospital, if a patient had been in a motor vehicle accident, they needed an orthopedic surgeon, they had to call the orthopedic surgeon in, could take 15 minutes, could take 3 hours. The same thing for a vascular surgeon, the same thing for a neurosurgeon. Dr. Cowley came up with the concept that you needed a center that was strictly for trauma, and every attending had to be in the hospital 24/7. So that was the concept of shock trauma back in the 80s. When I got there, we were transitioning from a very small center to a 125-bed hospital that was completely committed to trauma.
In that experience, in the years you worked there, did you have an opportunity to treat a number of people with brain injuries?
We treated well over 100 patients a year, a month basically, with brain injuries at shock trauma, along with spinal cord injuries.
Did you perform surgeries in different types of brain trauma and brain injuries?
Yes.
After Maryland in 1993, did you move to Miami Neuroscience Center?
Yes. In 1993, I left academics. I went into private practice in Miami, and I started the Miami Neuroscience Center. We were the first private community hospital to have what's called the Gamma Knife. So we were the 13th in the country, but the only one that was non-university based. And Gamma Knife radiosurgery is using radiation to operate on the brain.
Are you presently the director of the Miami Neuroscience Center at Larkin Hospital?
Yes, I am.
Do you conduct a number of surgeries a year there?
Correct. So I spent 19 years at Doctors Hospital, and then we moved to Larkin Hospital 13 years ago, developing the new radiosurgical unit called ZAP, and also another fancy machine called high-frequency ultrasound to treat the movement disorders.
You've noted that you have a number of professional memberships. I don't want to go through all of them. I'd like to point out a few. Are you a professional member of the American Association of Neurological Surgeons?
Yes.
Are you a member or a fellow American of the College of Surgeons?
Yes.
Are you a member of North American Skull-Based Society?
Yes,
And is that brain related?
it is.
Are you a member of the Society for Neuro-Oncology?
Yes.
Are you a member of over or at least 34 different professional memberships?
Yes.
In your career, have you engaged in research?
Yes.
Has that research focused or centered on brain injury?
Yes, it has.
Is some of your research as a principal investigator for THAM treatment of brain tissue, acidosis in severely head injured patients?
Yes.
Did that research and as a principal investigator help you in your diagnosis and treatment of brain injuries?
It actually was in the treatment of severe head injuries, patients who are unconscious, the concept of trying to relieve the increased intracranial pressure that occurs from the injury and to increase blood flow, thereby increasing oxygen to the brain.
Did you also serve as principal investigator for research for the PEG, SOD, and severe head injury?
Yes.
Could you describe that very briefly?
Basically the same, one of the biggest problems in brain injury is the fact that blood flow ceases to exist as the brain swells up. And so one of the things we try to do is preserve the neurons by making sure that they have enough oxygen and blood flow to them. All these are agents that try to assist that.
I won't go through all of your research and principal investigator roles, but I want to ask you about one more. And that is, did you serve as principal investigator relative to the IRB protocol for brain pathology?
Yes.
And what did that do? What was that about?
It was about looking at what happens after brain injury to blood vessels and tissue as the intracranial pressure increases in the brain.
Have you been part of publications of a number of different books?
Yes.
I won't list parts of all 16 books, but can I point out a few?
Sure.
Were you the author of a book chapter regarding head injury, difficult medical management?
Yes.
Were you the author of a book chapter on pediatric neurosurgical emergencies?
Yes.
Were you the author of a book chapter on complications of head injuries in adults?
Yes.
Were you author of a book chapter, Imaging of Craniocerebral Trauma?
Yes.
Were you
Doctor,
an
is there
author of a
anything
book
about brains you
chapter in
don't
emergency
know?
room assessment of the head injury patient?
Yes.
Would he concede
Were
if
you
there
the author
was?
of a
Would
book
that be a
chapter,
good question?
Intracranial injuries?
Yes.
Would you
I
concede
won't
there's
list or
anything
ask
about
the
brains
other
you
book
don't
chapters that
know?
you've been the author of. Have you been involved in journal articles?
Yes.
I'd like to ask you just about a few of the 70 journal articles that you have published.
Your Honor, objection.
So go ahead and ask the question without a comment, please.
Were you an author of a journal article, Intracranial Pressure in Non-Traumatic Ischemia and Hypoxic Cerebral Insults?
Yes.
Were you the author of a journal article, Post-Traumatic Cerebral Infarction?
Yes.
Were you the author of the journal Fractures of the Clivus?
Yes.
Could you tell me a little bit about that paper?
We used thin cut CT scans to identify fractures of the skull base. Prior to CT scans, it was very difficult to actually identify radiologically a skull fracture with plain x-rays. The idea was to see if we could identify them more clearly. And so we classified them and delineate them in the paper and discuss the outcomes that were relative to those type of injuries.
In the last journal article I'll ask you about, were you the author of a journal article regarding acute traumatic midbrain hemorrhage?
Yes.
Were you the presenter in a number of presentations regarding head injury and brain injury?
Yes.
You've listed 93. I'll ask you just about a few. Were you a presenter in fractures of the clivus, clinical and radiographic features?
Yes.
Am I pronouncing that correctly?
Clivus.
Thank you. Were you the presenter in acute head injury?
Yes.
And a separate presentation, fractures of the clivus, classifications and clinical features?
Yes.
Do you lecture?
Yes.
Do you have peer-reviewed publications?
Yes. That was one of them.
That's not the friendliest look he gives to the jury.
And are you heavily involved in clinical research?
Like he's inspecting
Right now, my
them.
research is more based on radiosurgical techniques and outcomes.
Over your career and your study and your clinical experience, have you treated different types of brain injuries?
Yes.
Are you familiar with a number of different types of brain injuries?
Yes, we still treat them.
Were you asked to review materials relative to this case?
Yes,
And do you recall the materials that you reviewed?
yes.
Could you share with us some of the materials that you reviewed?
I reviewed the chief medical examiner's assessment of the case. I reviewed pictures that I'm assuming the medical examiner took of the autopsy. And I reviewed the report from the forensic pathologist.
And before I ask you about your review of specific materials and your
What about the
opinions
medical
in this
records?
case, is there a benefit to your clinical experience in studying brain injuries as opposed to the experience you had as a fellow simply with pathology?
Well, I think that for the jury to understand, as a clinician understands the process from the time the injury occurs till the patient either leaves the hospital or dies. And it's a process. And as a neurosurgeon, I have a tremendous amount of experience with that, if that's what you're asking me.
Yes. And so, doctor, you reviewed a number of items of information in this case. Did you have an opportunity to review photographs of a laceration to Mr. John O'Keefe's head?
Yes, I did.
With the court's permission, I'm going to ask to display Exhibit 160.
Okay.
Dr. Wolf, I'm going to ask you to take a look at this photograph. Have you seen this photograph before?
Yes.
I want you to
That would be
explain
funny.
to us what you're seeing here and take us through the process of your observations.
Well, what we're seeing is an approximate 1.5 inch laceration with bridging tissue and contusions and abrasions. To us, that's just a classic blunt trauma injury. There's nothing other than just vanilla about it. This is what happens when soft tissue hits a solid ground. The skin tears apart a bit, but not through and through. As you can see, there's the bridging. You can see all the bruising or contusions and just the tear, a little bit serrated along the edges.
Thank you. If you could take that down. Dr. Wolf, as a result of that wound, did you have a chance to further look at information provided to you about the actual inside the skull of Mr. John O'Keefe?
Yes, it was the pictures that I was reviewing showed a non-depressed skull fracture extending linearly through the clivus and into the frontal fossa of Mr. O'Keefe over the orbital roofs. He had fractures along the temporal fossa as well. So it was a classic linear basilar skull fracture.
Is basal skull fracture a
It's
characterization?
basically the base of your skull is what it encompasses. So the opening at the very bottom is what we call the foramen magnum that connects your brainstem to your spinal cord. And then as your brainstem goes up, it goes into the different skull areas that, talk about what we call the cerebral cortexes, your occipital lobe, your temporal lobes over here, and then your frontal lobes.
So can you walk us through what happens when someone incurs this type of injury to the back of the head, how it happens, and what are the next steps for a person?
So what happens is, you fall backwards, and the linear acceleration starts to take you back down with gravity. The skull hits the ground. It gets, in layman's terms, smashed a little bit. And then the brain moves forward as a response to that. And it moves forward because you have cerebral spinal fluid and because you have the deceleration, acceleration again. As it does, your skull, if you were to look inside your skull, it's like mini mountains along your temporal bones and your frontal bones. So the brain is being thrust forward at a fairly good speed, and it's getting bruised. You can think of it as if you took a hammer to your thumb. It's really turning black and blue. Those are the contusions. And so the temporal poles and the frontal poles are getting contusions because of that. At the same time, you have a space called the subarachnoid space. And I'm sure they're going to hear about the subarachnoid hemorrhage. And that space is it's very clear, thin membrane that covers all of your brain and all of your spinal cord. And normally, you really don't see it unless you open up the brain and you're operating. But when you either have a traumatic event like this, where little vessels are pulling apart underneath that membrane, or, for example, the classic, when you have an aneurysm burst, the space that the aneurysm bleeds to is the subarachnoid space. The other thing that occurs in trauma like this is you can get a subdural. So the dura is the membrane that covers the whole brain and also right down your spinal canal. And it's a very thin membrane that looks like very thin leather. And in that space between the brain and the dura can be a lot of veins that go towards a central vein called the sagittal sinus. And if those tear, you have a venous hemorrhage from, which is not arterial, so it's not quick, but that can develop into a subdural as well. If you tear a portion of your brain as well, and you get a little arterial bleeds, that could create a much faster subdural hematoma. And so when you look at the pathology, the autopsy of his brain, you're looking at a subarachnoid hemorrhage, you're looking at a subdural hemorrhage, neither one of them which was huge or would have required surgery, as well as the contusions that I described in his frontal poles, in his temporal poles, and then the original bang, which was in the occipital area. These are all findings that you would see on a CT scan and an MRI scan without requiring an autopsy if he had made it to the emergency room.
I want to take a step
You
back.
catch all that?
At the beginning, you said that this laceration on the back of his head was caused by a fall. Could this be caused by a fall landing on hard ground?
Yes, like I said, it's a classic blunt trauma laceration.
Do you have an opinion to a reasonable degree of medical certainty whether this injury, the laceration and the basal fracture, was caused by Mr. O'Keefe falling backwards on the ground?
My opinion is that that's what caused his whole injury.
The pattern of the laceration, do you have an opinion whether that is consistent with hitting the cold, hard ground?
Objection, Your Honor. Can we have sidebar on that, please?
So I'm sustaining the objection, so no sidebar.
Your Honor.
Do you have an opinion, doctor, about whether that laceration on the back of his head was caused by a particular movement?
Well, the only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain and to his base of his skull.
Would that type of laceration require Mr. O'Keefe to have hit a line type or ridge type object?
A ridge type of object?
Yes.
No, like I said, the tearing of the skin in that fashion, you could look it up, would be just a classic blunt trauma injury.
Is there anything about that injury that would suggest to you it had to have been something sharp or ridge-like to cause?
Objection, Your Honor. Begin request kindly a sidebar on this.
All right, we'll come to
Thank you.
So this sounds like this is like pre-rebuttal of the defense position. Defense is arguing that remember from I think the opening that some type of raised object had to cause this injury. My suspicion is that Hank is focusing in on the laceration as somehow indicating that it was a raised object, and that's not what the expert has based their opinion on. It's not whether the laceration shows that there had to be a raised object, but whether the skull fracture pattern showed that there had to be a raised object. So that's my guess as to the nature of this objection and why he's getting at it. It's rebutting a non-herring. It's not relevant. It's misleading. It's relying on a theory of the defense case that is not what the defense is going to be presenting. So therefore, there's no good faith basis to be asking the question. You guys get all those details? God, I'm writing as frantically as I possibly can, and I have the subarachnoid space where there's a thin membrane and a traumatic event or an aneurysm. The space that it bleeds to is a subarachnoid, but then the subdural is another space, and that's because the dura is another membrane. I'm not sure exactly. I can't visualize what the difference is between these from this description, but the dura is another membrane, and it's got a lot of veins underneath it. And so if there's a venous tear, that can turn into a subdural hemorrhage, or you can have a slight tearing of the brain tissue that would cause an arterial bleed that would create a faster subdural hematoma. And all I caught with respect to John is that he had both subdural and subarachnoid bleeding, but it was not serious. Is that what he said? Did I catch that right? Like, this wouldn't have required intervention. These are like minor subdural bleeds. As well as bruising, and then the original point of impact. That's what I caught. That's what I caught. So I was really lost with his explanation of, you know, why you have a laceration to the back of the head and then, you know, bruising to the front and side. I understand the mechanisms of it, but I don't understand why he's saying that only happens from a fall backward. It happens in car accidents all the time. It just has to do with the acceleration.
So as we were discussing, Dr. Wolf, you
deceleration.
said this is a classic fall backwards. Is there anything about the pattern of that laceration that would suggest that there was a ridge or a line type edge that caused that wound?
Not necessarily.
And have you seen, in your experience, similar types of lacerations and breaks caused by falling on hard ground?
Yes, you can see that both in the occipital region. You can see it if patients fall on the forehead. The skin tears, they're still bridging, and then they get bruises.
Some of your work was in Minnesota.
Correct.
Was it a colder part of Minnesota?
Very cold part of Minnesota. It's Minneapolis.
I'm sorry. Did you often see these type of injuries there?
That's why Minneapolis
Yes,
matters.
we took care of a trauma center, Hennepin County. Very frequently, patients that are drunk fall down on ice sidewalks and could develop, lacerations in their head, epidurals, which are blood clots above the dura because they fracture a bone in the temporal area, and they can get a bleed from a fractured artery. And it happens when people are shoveling snow and have a heart attack and fall backwards. So there are various ways that people fall, resulting in head injuries and lacerations to their forehead or to different areas of their head.
Can somebody suffer this type of injury simply by falling backwards?
Absolutely.
You had taken us through the process of falling backwards and then talked about what happens to the brain. Can I ask you a couple detailed questions about that?
Sure.
When you explained that the brain upon impact then shifts forward and hits the front of the skull, is there a medical term for that process?
Well, the medical term is a coup-contrecoup injury. So the coup is when you first hit. In this case, it was the back of the head, as summarized by the laceration in the back of the head, and the contusions that the pathologist and the ME found in the back of the brain. And then the brain shifts forward, And as it's traveling at a certain velocity, because it's thrust forward on the floor of the base of the skull, it's getting bumped. And it's getting, again, you can think of it as a hammer hitting a thumb. It's getting black and blue in the areas that are sharpest.
Are there symptoms that result of the process coup-contrecoup?
It's, you know, this is clinically, it varies. I mean, you can go from anywhere from a simple concussion where you sort of are unaware of what happened, but you're still awake, you're confused, all the way to, you know, ultimately being in a coma.
Can this type of injury, the coup-contrecoup, and what you see in the review of your files, could this type of injury happen from an attack by a weapon, like a bat or a hammer?
Well, he did not have a depressed skull fracture. So any focal hit like that would more likely than not have caused a depressed skull fracture. Blunt trauma, the way he had, the assumption, would cause the coup-contrecoup without a depressed skull fracture.
When the coup-contrecoup process happens with the skull fracture, does anything happen to the front of the skull?
Well, you're asking me, does the rest, I mean, the forces, depending on how hard they are, can generate fracture lines all the way to the anterior fossa.
I can't wait for this.
You can have fractures along the lateral temporal area. You can have fractures along the orbital roof. The orbital roof is very thin. And so those forces can go all the way to that area.
Did you see any sign of orbital fractures in Mr. O'Keefe?
Yes, he had both the ME and the pictures taken, and the neuropathologist mentioned fractures of the orbital roof.
Do you have an opinion to a reasonable degree of medical certainty how those fractures occurred?
From the trauma.
Could you just explain a little bit how that would happen?
Well, as he fell backwards and he struck his head, it was clearly at a very high speed generated by the gravity. The bone, depending on the quality of his bone, the density, then generated forces. There's a certain amount of lateral give, and then you get a linear force going forward. It drives all the way up the clivus and forward into the anterior fossa where his orbital roofs lay.
This guy's not a good communicator.
This is why people like this get what they call raccoon's eyes.
Do you have an opinion whether the brain itself could have caused the orbital fractures?
No. The brain is a soft substance. You could literally put your finger through the brain. We often operate on people fully awake. The brain couldn't possibly cause a fracture.
Does this guy give you the idea he might have stuck his finger through someone's brain?
That clivus, that middle bone in the middle of his base of the skull.
Do you have an opinion to a reasonable degree of medical certainty whether or not the brain in any way could have caused these orbital fractures?
The answer is absolutely not.
In your study of the records and photographs and in your experience treating these types of injuries, do you have an opinion to a reasonable degree of medical certainty whether or not a person would remain conscious or would be immediately unconscious after the impact of the ground?
Well, it's impossible to know whether he became immediately unconscious, but his injuries were very substantial. And it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
What does functional activities mean?
The ability to, get himself up and about would be one of the functional activities. The ability to call for help would be a very significant cortical function. And that's why I was talking about, that there's a variation on the theme from a simple concussion to a severe concussion like this.
If a person does not have functional abilities because they are rendered unconscious, does their body, could it still move?
Yes, this is the interesting thing about our brain. So the cortex, which is the top portion of your brain, can get separated from your brainstem functionally. And what happens then is that your body is not acting autonomically, meaning vegetative. So why does that happen? We think it's because as we were a caveman, and if a caveman became unconscious, as an animal came up to eat it, the animal would touch it. Well, you have these automatic movements. One of them is called decorticating, which is where you draw your arms like this and you throw your feet out. And then a worse neurological situation is when you decerebrate. Now you push your arms out along with your legs. And that would scare off an animal. So we think that over time, genetically, this is what happened to our brains in order to create these. But those kind of movements are not thought processes. In other words, your brain is not telling you, oh, you have pain.
The fencer stance
Go
is
ahead
not
and
something
decorticate or
you choose to do.
decerebrate.
The fencer's
It's
pose.
an automatic movement in response to pain.
I want you to take us back now to after the fall. Would Mr. O'Keefe, in your study and opinion, have died immediately?
No.
Can you share? I'm sorry.
Yes, I'll tell it. There is very few things that you head injury where you would die, quote, immediately. So if I took a knife and stabbed you in the back of your neck right below your skull and I drove it through your brainstem, you would probably die immediately. If I shot you below your ear and went through and through below your ear and shot through your brainstem, you would die immediately. But traumatic head injuries, you would not die immediately. It's
There
a
goes
process.
everyone's monetization for
And it's
today.
a process of a combination of things. Brain swelling, which takes a while to develop. Decreased blood flow to your brain because you're getting swelling. And ultimately, death of the brainstem that controls your heart and your breathing. And so this is why there's a whole big issue about brain death. When is someone brain dead? Because it's not instant and it can take a long time to be conceived. In these injuries that are very severe that we took care of, there was a high mortality rate. In the linear skull fractures, it was about 67%. But it took time for them to die. It could take days to weeks to months. And also,
Was you left out in the cold?
these people got to shock trauma. So it was a while, whether it was hours, before they were even starting to be taken care of. And yet they weren't dead yet. That's why I don't think it was immediate.
Was there any other observations you made about Mr. O'Keefe or his body that support your opinion that he didn't die immediately?
Well, the medical examiner took pictures of his periorbital area and diagnosed raccoon's eyes. So raccoon's eyes occur because there's leakage through the orbital fractures into the periorbital space. Normally, it takes about 24 to 48 hours to develop. It has been noted as early as 1 to 3 hours, which would make it not immediate.
Could we please have Exhibit 14? Dr. Wolf, could you share with us what you see here in this picture?
So right here, you can see the black and blue that sort of configures if he had his eyes open, like what we describe as raccoon's eyes, right? And that's not caused by direct trauma to his eyelids. It's caused by what I described as the basilar skull fracture, which went to the anterior fossa, which is right over the orbit here, inside, with leakage of blood products into that periorbital area.
You mentioned that starts or takes at least 1 to 3 hours to begin.
Minimally, yes.
You take that down, please.
You said it's been observed as early as, but normally 24 to 48
If Mr.
hours.
O'Keefe had been brought to a trauma center or emergency room, what would the process be in your experience?
Well, he would have been intubated if he wasn't intubated in the field. One of the first things you need to do in a head injury is control the airway. Why? 2 reasons. One, you want to have enough oxygen going to the brain to feed it. And 2, you want to keep your carbon dioxide down because that causes increased intracranial pressure if it elevates. So you want to constrict the blood vessels a little bit. Then he would have had a CT scan immediately in order to assess whether he has a surgical head injury, meaning he needs to go to the operating room to evacuate something or not. During that process, he's obviously going to be getting medication to decrease the brain swelling. And from there, you make decisions based on his neurological function and what you're, capable of doing to, spare the brain from the rest of the injuries that will result. One of the things that occurs with contusions is a great medical term is they can blossom, which means they can get bigger.
Great medical
And
term.
if they get bigger,
Beautiful flower.
they might require surgical intervention to decrease the pressure as well as the volume of the blood that's destroying brain. And so you do serial CT scans in these patients over time, anywhere from every 6 to 12 hours to on a daily basis, depending on what the case by case, production of blossoming is occurring.
You mentioned that about 2/3 of your patients who suffer this injury pass.
Correct. What we saw is that in the patients that suffered linear clavicle fractures, 2/3 of them ultimately went on to die, and 1/3 lived.
Is there commonality on how they pass?
One of the common reasons they passed is if they trapped a major vessel in one of the fractures, they would get a significant brainstem infarct, meaning a stroke, meaning lack of blood flow to a very significant portion of their brainstem. And so that was one of the causes of death that ultimately we understood. And then the others died from the increased intracranial pressure that drove the brainstem down through the foramen magnum.
Did you review any materials that talked about or identified Mr. O'Keefe's body temperature when he was treated?
As I recall, his core temperature was 80 when he was found.
Is that significant in the process and development of his injury from the moment he fell and hit his head until his ultimate passing?
Well, hypothermia, if you define hypothermia, it starts at 95 degrees. Your core temperature is usually about 98, 98.6. 95 is very mild hypothermia. When you get to 82 degrees, you're in severe hypothermia. What happens when you're hypothermic, and I'm a neurosurgeon, but I can tell you that you get into multiple organ failure. Your heart starts to have problems. It can have arrhythmias. You're not breathing. And ultimately, at hypothermia, you also become unconscious and go into a coma-like state. Below 80 degrees, you're probably going to die. So all I can tell you, it wasn't helpful that he had a significant head injury and that he was then found hypothermic.
Is it uncommon in your experience for people that suffer this injury to pass within 5 hours?
Well, none of the patients we treated died within 5 hours, but it also didn't mean that we didn't realize that they were going to be in a potentially vegetative state. When someone's hypothermic, you have to warm them up in order to establish a clinical status, meaning you can't declare someone dead with a temperature of 80. You have to warm them up slowly, appropriately, and then reevaluate where they are clinically.
I've asked you questions about whether you had an opinion about Mr. O'Keefe and when he died. I want to ask it in the form of a formal opinion. Do you have an opinion to a reasonable degree of medical certainty whether Mr. O'Keefe died immediately or within 15 minutes?
No, I don't think he died immediately. Neither the hypothermia nor this kind of head injury would kill you immediately in any clinical experience I have.
Dr. Wolf, thank you.
All right.
Let me have a moment, Your Honor.
Sure.
Thank you.
Mr. Alessi, of course it is. Witnesses like this can be so much fun because they don't like to not know things. And so you can sometimes play on that. That's why I pulled up that question that somebody had mentioned in the chat earlier. Doctor, have you heard of grass? He's going to want to know know everything about grass and ground freezing and stuff like that. It's a possibility that can be a little bit of a risk with some expert witnesses. A little high on their own supply when it comes to their knowledge, and they can exceed the scope of what they really know and create some embarrassing moments sometimes. I really don't understand this. If someone's hypothermic, you have to warm them up to evaluate their status. Don't you find dead people who have cooled all the time? You're telling me you warm all those people up to make sure they're dead? No, I don't think you do.
Morning, doctor. I don't think we've had the pleasure of meeting. Welcome.
Thank you.
Sir, can you just describe, you started to do it a little bit on direct, a typical day for you?
I wake up at 4:15 in the morning. I go to my center. I set up patients with frames for their either radiosurgical procedures or stereotactic craniotomies. I go home. I make a cappuccino for my wife at 6 o'clock in the morning. And then I get back to work at 6:30 and move on. I have patients that I'm operating on, and I have patients that I'm seeing through the day.
And what type of patients and what type of work, just in a typical day? What are you doing? What type of patients and what do you do?
It varies. I mean, I see patients with brain tumors. I see patients with hydrocephalus, which is water in their brain. I see pediatric brain tumors. I see subacute and chronic subdural hematomas, post-traumatic. I see patients with strokes that are being misdiagnosed. I see patients with cancer, metastatic disease. I used to see patients with cervical problems. I stopped doing that 2 years ago. I don't know what else you want me to tell you.
No, that's great. And is that typical day, typical of the type of days you've had for the past month, past few years? Is it generally, without specifics, is it generally?
Correct.
So none of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist in.
I am, if you could have asked that question, very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Right. And you don't perform autopsies, correct, sir? You're a brain surgeon.
Correct. In other words, I see more brains than the forensic pathologist.
Right.
Oh, he's more
is it
of a
correct to
brain
say
expert
that
than the forensic
the brains that you
pathologist.
see are of living people?
Correct.
Okay. So what I'd like to do is to go to a different part of the head
Challenge
than
accepted.
was discussed, but sticking with the decedent.
Excuse me, I didn't hear the last
I'm
word.
sorry, with the topic is going to be Mr. O'Keefe, the decedent in this matter, sir. You testified about raccoon eyes. The medical term for that, sir, is ecchymosis, right?
Correct.
And ecchymosis, raccoon eyes, does not cause a laceration to form on an eyelid, does it?
No.
Are you aware that Mr. O'Keefe had a laceration to the outside area of his right upper eyelid?
I am aware that the ME described that. Yes, sir.
Now, could, Your Honor, I'm going to, with Your Honor's permission, ask to publish what is already in evidence in a moment.
Okay.
Mr. Wolf,
What exhibit number, Mr. Alessi?
we're going to, 165, Your Honor?
Okay, go right ahead.
Thank you. Dr. Wolf, have you seen this photo depiction before today?
I believe I have.
Is it correct that that injury on the upper right eyelid is caused by the application of force directly to that area of the front of the head, again, namely the upper eyelid?
That's possible, yes.
Is it more than possible? Is it probable that that injury was caused by the application of force directly to that area of the front of his head?
Well, an easy answer to that would be is that that's not part of the periorbital ecchymosis.
Thank you, sir. That was exactly going to be my next question. This injury is unrelated to any of what you've been describing, the fall backwards, the force transfer inside the skull, the, as you described it, the dura, the cerebral spinal fluid, all of that dynamic that you so ably described on your direct examination. This injury has nothing to do with that, correct?
Correct.
Good concession there.
I have one more moment, Your Honor. Thank you.
Thank you for answering my questions, Dr. Wolf. A pleasure again. No more questions at this time, Your Honor.
Okay, any brief follow-up on that?
No, thank you.
All right, Dr. Wolf, you're all set.
You are all set.
Thank you very much.
That's enough. Cut to the eyelid has nothing to do with what he's been describing.
Brennan?
Why? Because a
May
punch
we
to
have a
the
moment
eye.
to inquire of our next witness?
Sure. And why don't
Punch to the eye
counselors,
can make you
others,
fall
feel free to
backwards.
stand up and stretch.
I just went ahead and Googled real quick. Falling during a fight and dying. Man who died, this is from 2016 in Newberry, South Carolina. A man died after he was hit in the face and fell, hitting his head on a concrete pad. He died from a skull fracture and bleeding into the brain 2 days after the fight. Yeah, you hit somebody. This is what I'm talking about with this, you know, you see the stupid street fight videos, people out fighting on like a concrete driveway or, you know, basketball court or something like that. It's so stupid without your headgear or whatever. You fall back, you crack your skull on that. Yeah. Yeah, you might die from exactly the type of injury mechanism that this guy just described. You might die. And what caused it? Getting punched in the face is what made you fall back. Looks like
We'll take a 15 or 20 minute.
All rise for the court, please. Jurors, close your
15 or 20 minute break. So we're ahead of schedule because of that very disciplined, tight cross-examination. Just establishing he is not a forensic pathologist, and none of the processes he described tell us anything about why John has a cut to his eyelid. It's good, man. Keep it simple. Keep it simple, and that's what's going to stand out if you don't get into the weeds and get into a wrestling match over stuff that doesn't really matter. First off, we're counting on the jury having followed all that and made sense out of it. This guy is clearly not an expert witness by profession because he's not a particularly good communicator. And I would tend to think that surgeons in general probably don't need to be that good of communicators, because all you need to know is like what you need other people to do to assist you in your surgery. But he taught, and that would seem to help, but he's teaching other doctors. So this is not like you're teaching lay people about brain injuries and finding ways to explain them. You're talking to people who have advanced knowledge in anatomy and processes and stuff like that. So you've never had to explain this in a way that, you know, doesn't involve using this highly technical language and stuff like that to be able to make your point. So did the jury catch any of this and understand what he was getting at? I mean, maybe the important parts, you know, bottom line, fell backward, classic, very vanilla. That was helpful, I thought. It's very vanilla, classic blunt force trauma. It happens from falling backwards. Wouldn't necessarily die instantaneously. Is this helpful one way or the other in terms of, does this establish a vehicle accident? Not really. I mean, it tells us a little bit more about the process of death and what that may have looked like and what it may have resulted from. But it doesn't explain all of the injuries that John has, right? And, you know, none of this has anything to do with how he fell back, why he fell back. The Commonwealth is going to still have to come up with an explanation for how the car caused him to fall back, and moreover, how it caused him to fall back. I mean, and then what? Walk around? Are we gonna go back to John maybe walked around for a little bit after this accident? The calling for help was a good issue for this guy to raise, because yeah, wouldn't you do that? Wouldn't that be wouldn't that be a pretty initial, if you still have the ability to exercise conscious functional tasks, you still have some executive function. Calling for help, you know, making noise, that seems like a top one. But so he's talking about you can still have movement even if you have these severe brain injuries and separation. Guy, he's talking about like, this is something that you know, I've looked into to a very small extent, because it's you can learn a lot about if a person has a brain injury, what kind of brain injury it is based on what kind of posture they assume there's like these series of involuntary postures that people will often go into when they have, a severe neurological type of incident, and it, of course, comes up in combat sports. If you have a really bad knockout, sometimes you might see it. I'm seeing it on the football field and stuff like that as well. So that's what he's talking about when he's talking about, there can still be movement after these severe types of brain injuries, but it's not conscious movement. He's talking about these involuntary postures, and they can tell you a little bit of a different thing about the nature of the injury. Is this going to be how the Commonwealth is going to try to explain the steps? Why John is still taking steps after the end of their backup maneuver? Are they going to try to claim going into the fencing pose is going to register on the iPhone as movement? That seems pretty unlikely to me. But it's the only reason I could think of for why the Commonwealth is going into this area at all. Some very colorful descriptions here and some ways of talking about things that suggest to me this guy is not used to talking about lay people about these subjects. Don't talk about putting your finger through people's brains, dude. It's just not good. It's not what people outside of the brain lab probably want to be thinking about. Find a different way to describe the softness of the brain, not putting, because everybody literally just pictured you sticking your fingers through people's brains, and it's not a good image. It doesn't perhaps convey the type of aura that you might want it to. The caveman explanation and that this is fascinating to me. That's great. This is some good, interesting evolutionary type of theory. Like, why do you have these weird postures in the first place? I don't know. Maybe it's so that the animals don't come and eat you when you are helpless and incapacitated. Maybe, but just a very kind of strange thing to come up in the course of this trial, where suddenly we're talking about cavemen. So, not sure how much of this the jury followed and picked up on, and how much of this is whiplash between, injuries and cavemen and technical language. Wait, the foramen magnum. I didn't even say that right. The 67% high mortality rate when you treat it. It wasn't clear where that was from. Is he saying back in Minneapolis in the hospital? I loved that little hook that Hank is trying to put in. Oh, it's very cold. Yeah, it's very cold in Minneapolis. I buy that. Minnesota is kind of notorious for the winters. That whole part of the country, they get the cold air that comes down from the Arctic, and it can just make things extremely cold. Like Montana gets the same type of effect. Extremely cold temperatures. So yeah, I buy Minnesota's really cold. So you've seen cold frozen ground. Yeah, but when we're describing people having these injuries, where are they falling back and hitting their head? On the sidewalk. Yes, on the freaking concrete. On the concrete. On something hard, not on grass. If you don't know the answer, you can't ask the guy, how many injuries have you seen like this from somebody falling backward onto a frozen lawn? You can't ask it if you don't know the answer, and you're not going to know the answer in Massachusetts when you don't have pretrial depositions. So you don't already know the answer to that question. You can't ask it, but don't we all wonder, doctor? Yeah, everybody knows. You go home drunk, you slip, you fall, you crack your skull. You're shoveling the driveway, you collapse, you crack your skull. What about getting punched in the face, falling back and cracking your skull? Does that happen? Does that happen? Yeah, it does. Definitely does. But that was just a fun little fun little way to try to kind of cross qualify him as a frozen ground expert, because he did all this in Minneapolis. And yet when it comes up as the time to present an example. What's your example? Falling backward on the sidewalk. Yeah. There's no sidewalk here, is there? So if we're going to go around this area and start looking for concrete, where are we looking? We're looking in the areas closer to the house. We're looking closer to the house. So that was kind of fun. That was kind of fun. Surgeons are a whole vibe, man, aren't they? Aren't surgeons a whole vibe? Wow. Well, hey, we got a bit of a break still. I'm going to take the fan off for you, and we'll just keep going through some of what you guys have been thinking this morning. Owlophobia. Would taint one, taint all work for taillight? Seems easier to doubt February pieces than cert, but can't trust Feb pieces equals can't trust cert pieces. Maybe. I think part of the big problem with the cert pieces is the fact that they weren't properly kept separate and stored and identified. They just went into what appears to be a sort of lump of material that was gathered over several days and was all sealed and booked into evidence by David DeCicco, all on February the 4th. And so the January 29th, February 3rd, and February 4th pieces, we don't have a particularly good chain of custody on that. And so what folks who have been like sleuthing the taillight have done is they've gone back through all of those photos of what was photographed at the scene by CERT. The few times we have seen photographs are CERT. And then there's the partial photography of the February the 3rd search, the one that Buchanan and Proctor and DeCicco and all those guys, Tully, went back to do. They claim they found like 12 items, but there's only photographs of 5. But anyway, there's limited photograph evidence from the scene. And so the sleuthers have gone through, like, here's what's at the scene. Here's what it looks like it is from this bag. Here's where it looks like this piece from the bag ended up on the taillight. We're doing our best to reconstruct it with very limited information that we have. It would be so easy if like the A, B, C, D labels, if like the labels of what piece of plastic was what, were just all on the outside so that we could see them in the photograph. That would be really helpful, but that's just not how it was done. So there's a lot of guesswork in that and putting pieces together. Could the jury do that themselves? Possibly. They could be sitting back there with the photos of the cert search, with the photos of the bags, photos of the reconstructed taillight. They could be doing all that themselves and then matching up. Okay, well, this looks like the piece they found from the cert team based on this photo. It looks like that's in this bag. Is that going to help them potentially solve issues with the chain of custody? It could. I think that's really the question. You know, if the Commonwealth would do more of that work for them and present it to them, then there's a much better chance that they'll be thinking along those lines. But if they just kind of leave it out there and don't address it because the problems with the chain of custody are a bad fact for you, and so your strategy is just ignore it and pretend it doesn't exist, well, then that's handing the defense the opportunity to hammer on the fact that you have a chain of custody problem. They haven't sorted it out for you, and you should hold that against them. This is a possible way to look at the evidence, certainly, but it's not the only one, and it's not a necessary one. So the virtual juror reports sue Ted on X, court cleared of all electronic devices taken with them. Also told to leave second floor where court is located. Explain this. They want the questioning process to be, extremely confidential. No information about it. Not going to be enough to just have it at the sidebar in front of the audience with the white noise machine on. They want to make sure that, there's no lip reading, like no nothing. That's my best guess for why. Not totally unheard of for this type of thing to happen. Often they'll do questioning like this back in chambers. So it is out of the public eye. Don't want to see the facial reactions of the jurors, stuff like that. Coriana Alexandra, 24-mile-per-hour wheel spin in snow, maybe not actual movement. Yeah, that's long been kind of a theory of why it would show this type of activity, acceleration, but no corresponding like brake safety system not alerting, impact warning system not alerting, not alerting, all of those types of things. Yeah, it's anybody who's driven in snow, man, you've spun your wheels. You know what that's like. We have an issue at my house because our road sits a little bit below the like main road that we connect to get out. So in the winter, it can be hard to get out. It can be hard to get out because you're up there and there's snow before they plow. There's snow on the ground. And so you're up there like on a hill trying to get your, I got rear wheel drive and you're trying to get your little back wheels to get enough grip to get you up over this hill and onto the main road. Very familiar with spinning your wheels in snow. Probably looks like I'm going a gazillion miles an hour if you pull my data out. Skippy one, nobody has seen this data on the backup and the braking. These guys have. So we have to take it kind of from and through them. They're not going to put the raw data into evidence. So it's not going to be accessible that way for people who might also have expertise to be able to look at it and evaluate it. We're taking it secondhand. And so everything we know about it is based on, what somebody says it means and what the response to that is. So with, for example, the timestamps, I'm kind of taking it on faith that this time we have the timestamps and those timestamps are legit because the counter argument from the defense doesn't seem to have been, oh, these timestamps are trash because XYZ. It's just the timestamps have to be reconciled with the other available clocks. And that if you do that, you end up with problems with the rest of the data, particularly the health data. So yeah, we do kind of have to take it on faith through the significance that the experts who looked at it have chosen to give it. Stormy, I live in Utah and have a 2024 Telluride. I can tell you that when it's slippery and snowy, my car triggers with any kind of slide. Makes sense. Makes sense. My car doesn't have, my car is not made for winter driving. It doesn't have particularly robust systems. I mean, I'm sure it's got it's a Subaru, it's got airbags and, stuff like that. It's probably good from that standpoint. Crash, rollover protection, all that stuff. But I don't have a camera. There's no cameras in it. It's a little bit bare bones from that standpoint. But it's not a luxury car. It's a little sports car, so they keep that kind of thing minimal. In a larger vehicle, especially one Telluride, Tahoe, the names give it away, guy Denali. The names give away the conditions that we are expecting this vehicle to be operated in. And so, yeah, a lot of these, nice SUVs, 4-wheel drive, all-wheel drive, whatever, they're going to be built with operating in these kinds of extreme weather conditions in mind. That's part of the whole point. So yeah, I would expect that they are going to have finely tuned alert systems in those kinds of vehicles. Erica, Dr. Welcher has 30 plus years. He co-founded Biomechanical Research and Testing, LLC, BRT, in 1994. And in 2021, BRT partnered with Aperture. Welcher is very aware of how our degrees and certs must be verified. Now, here's some fascinating biological information. Hadn't seen this biographical information. I hadn't seen this. So he was the founder of a company that merged with Aperture just a few years ago. Yeah, you would think he's going to know the ins and outs of the business. It definitely makes sense. Very interesting, Erica. You keep adding to my anticipation of this cross-examination of Dr. Welcher, because why do I suspect it's gonna not be brought out on direct? Hank didn't bring out the degree issue on direct with Burgess even. He didn't try to take the sting out with Burgess. I don't know why you wouldn't do that. Yeah, he's gonna know. Remember, Bev makes him turn over his reciprocal discovery what their impeachment evidence is going to be. So he already knew this, but he chose not to address it. That's just bizarre to me. I don't understand that from a strategy standpoint. But if it's, ignore it and hope it doesn't come up, hope it doesn't land, whatever, then, might be the same strategy that he takes with Welcher. Don't address it, and we'll hear all about what the expected credentials are and so forth. Only once we get to cross. Lucy Fair, Commonwealth case where time is not time, steps are not steps, and Google searches are not Google searches. I'd be sick of it if I was a juror. All the laws that don't apply in Canton. The drinking driving laws certainly don't apply, but even the laws of physics, guys, even the laws of physics may not apply. We certainly know the laws of economics don't apply. That's why there's nobody rushing in to fill this enormous vacuum for which I hear from certain critics that there is a massive demand for commentary that presumes or looks at this through the lens of Karen Reed is guilty. Weird, like all these grifting law tubers see things the same way and they make money by adopting a certain viewpoint that sells. This is a theory, guys. The laws of economics don't apply in this theory, because if there is demand for that counter viewpoint, oh, you better believe somebody is going to find a way to supply it. And then that somebody is going to grow, right? So a little bit of a problem with the underlying premises here. Maybe it's just that everybody on LawTube who's watched this trial thinks she didn't kill John, because that's what the evidence tends to show if you actually pay attention to it. Could be that. Just putting it out there. Montana Alexander, these triggers and infotainment module are likely just parking maneuvers, i.e. 3-point turn, to display front rear cameras on screen, nothing more. This actually makes a lot of sense. I hadn't thought about that, but that makes a lot of sense, because I don't have cameras on my car. I don't have those types of screens. But obviously I'm aware that they're out there. I've had rental cars with them and stuff like that. And yeah, you're absolutely right. You flip it in reverse, and then suddenly that camera comes up on the rear. That's going to require some type of computer reaction in, the camera or the display of the camera. This makes a lot of sense to me. Great information there. Very good point. Wonder if we'll hear more about that. Ovechkin YT, wasn't Trooper Paul's KC 1164 making KC 1162 impossible to Karen's? I can't remember now. I should have gone and looked. Hang on. Which key cycle was it? Let's go back in the notes from last trial. Let me hunt down Trooper Paul. He was on day 25. He was on day 25. That's why I was still screaming on day 24 that we haven't yet heard a theory of how John O'Keefe was hit by a car. That was the delayed disclosure, I guess, from last time. So, Joseph Paul. What did he say? A lot of crime scene stuff, gross vehicle weight, NHTSA, acceleration testing. No data recovered from the ACM. Huh. How intriguing. got into the specific Lexus safety system a little bit. Text stream. 22 separate triggers, the key cycle. I have in my notes 1162 key cycle. That's what I have in my notes, 1162. See if it came up again at any point. My notes are certainly not the Bible, but I do, try to be as accurate as possible. Might have come up, kind of vaguely remember. It would have come up again on Cross because that's when they did the count through the different key cycles. No, now I have on Cross. Triggering events were 1162, but 1164 is his. There were 2 key cycles before that. And 1164 was his, meaning that was the one that he did. He identified as his. Okay, I see what you're saying. 1164 was the key cycle that Trooper Paul identified as his test. That was the one that he identified as his test. And so if you counted back from that, you would only have 1 key cycle in between his test and the 34 Fairview. What he's saying is the triggering event from 34 Fairview, which is this key cycle 1162. The problem with that is that there's more than two key cycles between 34 Fairview and Trooper Paul's testing. You have the picking up the car at Meadows, taking it to Dighton. You have the loading it and the unloading it from the SUV. You have the leaving in the morning. You got like at least 4 in between. So I see what you're saying. If these are timestamped and the timestamps aren't being disputed, then what's the easiest explanation here? And is it conceivable that Trooper Paul got it wrong? Which one was his key cycle? Gotta tell you, I don't know that I can rule that one out. I don't know how to reconcile this information from both of these trials at this point. Maybe the defense will clarify some of that. But yes, if Trooper Paul did his testing at key cycle 1164, then they either have key cycles that are not registering for some reason that would need to be explained, or you've got a bad count. The incredible shrunken bee guy. I still do not understand how 2 iPhones sitting side by side in one car have different times. Side by side, they should be synced to one tower. Yeah, I mean, it sounds like he's saying a 1 to 2 second discrepancy is normal, and that's what you would expect from 2 Apple phones. Yeah, I would expect simultaneous. I mean, I guess appreciate that there's always going to be some difference just because of the signal going to and from, the time. It's not instantaneous. It does take time for the signal to travel, even if it's so fast that, I guess satellites will take longer, but, cell towers pretty fast speed. We're talking speed of light, so doesn't take that long to cover that scale of distance. But things like interference and stuff like that could potentially interfere with it. Hard for me to see, if it's on a cell tower, how that would aggregate to like a full second or even 2 seconds. I don't know. Tamara, did neither of the 2 cell phone ones have crash or fall detection on? I don't know. Does iPhone have fall detection? It's a good idea if it does. I don't know. I've never had an iPhone. Yeah, makes sense. Get grandma an iPhone and then, grandma falls. Grandma's home alone. We already get some kind of alert. It's the whole life alert kind of system. I could see something like that being in an iPhone. You iPhone people will know better than me if they have those types of services. And if so, are they automatically on? Do you have to go in and turn them on? I don't know. It's a good idea. Very good idea. If you can turn it off, maybe they would. I don't know. Alessi's fantabulous lexicon. The Glarer posted a photo of he and Alessi flexing. It has now been proven Alessi is in fact Superman. I rest my case. I now need his workout plan. Law and fitness with Alessi, anyone? I'm there. You want to show up for the smoker, the Karen Reed smoker that we should all have after this? I've seen, like, through the grapevine, there's more than one person that's seen some time in the ring. That would be fun, guys. It'd be fun. Just check out each other's moves and stuff. Be a blast. Yeah, Alessi's in great shape. Takes very good care of himself. So, man of many talents, many disciplines. Katia Kane, I don't even believe any of experts anymore. I think it's all going to come down to common sense, actually. Did he get hit? Nope. Okay, done. Shake my head. They just want her. This is not an uncommon attitude for jurors to take in trials. It's not uncommon for jurors to just assume, look, the experts are hired guns. We know that they're just saying what the party who hired them wanted them to say. So we don't have to pay much attention to it. We can just throw all that out and, assume that they're neutralizing each other, and then just go with what the rest of the testimony and evidence seems to show us. It's not that uncommon. Just have that expectation that it's not particularly good information. And so, yeah, if they focus on all this stuff about timelines and vehicle activity and stuff like that does not matter if there was no collision and John was not hit by a car, because he doesn't have those kinds of injuries on his body. Carrie Collins, does anyone monitor judges' actions when obvious bias is taking place in televised trials? I'll come back to
All right,
this.
may we have Ms. Hanley, please?
Oh, we're coming back to Hanley now. You did mishear that. I said moves. I did not say nudes.
Then all we might be still in the road.
I said moves. Your moves.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. And ma'am, if you could just please introduce yourself to the jury again.
You got to go over the preliminaries again.
Sure. I'm Christina Hanley. Hanley is spelled Hanley.
And Ms. Hanley, given the break, if I could just ask you a few questions, just to reorient as far as the items that we were speaking about yesterday in your testimony. First, starting with the items of glass that you analyzed in this case. The first of those items was an item 3-2. Is that correct?
That's correct.
And if you could, please describe for the jury, or please provide
Gotta be
the jury with the
Lally-fied.
description for that item that you received.
Sure. So item
Tumbler.
3-2 was a clear glass cup with broken irregular edges. And there was some dirt debris material that was noted on the exterior and interior surfaces.
Your Honor, may I approach?
Yes. Did you show counsel? All right, thank you.
I gave Mr. Jackson my copy. Yes, thank you. Showing you a photograph, Ms. Hanley, do you recognize that?
Yes, I do.
And what do you recognize that?
So this is a photograph that I took It's item 3-2, but it's also, I would have to double check on my notes, but I believe it has item 7-12, one of the pieces that I'm holding that's showing a physical match between those two items.
Your Honor, Commonwealth will seek to introduce in the minutes of the next exhibit.
No objection.
Okay.
This was a Yuri Buchanan bag, guys. 712. A Yuri Buchanan bag.
And Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 9490. Ms. Hanley, what's up on the screen? Is that the photograph that I just presented to you?
Yes, it is.
And if you could, please describe for the jury what we're looking at here.
So that is a photograph that I took upon examination. It is the clear glass cup item 3-2. And I'm holding another piece, which again, I believe it's one of the pieces from item 7-12. I would need to confirm in my file, but I'm showing that one of the pieces physically fits with item 3-2.
Thank you, ma'am. Ms. Gilman, you can take that down. May I approach again, Your Honor?
Yes.
Gotta reorient
Showing you two
so we
other
can
photographs.
bury the damning evidence about the bumper sprinkles.
Did you recognize those?
Yes, I do.
And what do you recognize those as?
So these are photographs that I took of item 7-12.
Your Honor, Commonwealth will seek to introduce in the minutes the next exhibit A and B.
Is there any objection?
No objection.
Thank you.
Now remember 7-12 was found on
96A,
February the
196B.
And Ms.
So
Hanley,
there
if you could,
be
just
debris
remind the
noted
jury as
all
far
over
as the
that.
physical description that you received in regard to
think
item
there was.
7-12.
Sure. So item 7-12 consisted of some clear plastic pieces as well as 9 pieces of glass with broken irregular edges.
And may I publish, Your Honor?
Yes.
And Ms. Gilman, if I could have first photograph 9476. And if you can enlarge that just a bit, Ms. Gilman. And Ms. Hanley, what are we looking at in this photograph?
So this is the photo that I took of item 7-12 as I received it. So there's the several pieces of clear glass with broken irregular edges.
And Ms. Gilman, if I could have 9477. And if you can enlarge that just a bit. And again, Ms. Hanley, what are we looking at in this photograph?
Those are the same pieces of glass as in the previous photo, just a little bit more up close of the clear glass that was recovered and is item 7-12.
Thank you.
Yes, it
Ms.
doesn't
Gilman, you
have a
can take
lot
that
of
down.
debris and dirt and stuff on it, does it? As you sure would think it would after being outside in that
Ms. Hanley,
lawn,
as
snow
far
melting
as a
for 2 weeks.
comparative analysis between items in 3-2, the glass cup, and 7-12 regarding the glass pieces, what, if any, conclusions did you make in reference to your comparison between those two items?
Sure. So upon comparing those items, I did note that 6 of the 9 pieces of clear apparent glass had a physical match to item 3-2, the clear glass cup.
And if you could just remind the jury as far as a physical match, what does that mean?
And I know you got a photo of
So
that.
a physical match
Oh, thanks for that.
is
Reminder on the banner.
basically if an item breaks and those items have broken irregular edges, if those pieces come back together like a jigsaw fit, then it's a physical match, and they were at one time together as one larger unit.
Now, as far as each of those items within 7-12 had a letter associated with them, correct?
Yes.
And do you recall which of the 6 were a physical match for item 3-2, the glass?
I would just need to refer to my notes for the
Does
exact
it matter?
letters.
Because
Sure,
the
you can
jury's not
take your
going to know.
The 6 pieces of glass from item 712 that physically fit to item 3-2 were A, B, C, D, F, and K.
May I approach, Your Honor?
Yes.
Well, let me ask you this first, I'm sorry. So Ms. Hanley, during the course of this physical match analysis that you're conducting, are you memorializing that process with photographs as well?
Yes, I am.
May I approach, Your Honor?
Yes.
I'm presenting you with 4 photographs, if you could review those and look up when you finish. And do you recognize those, ma'am?
Yes, I do.
And what do you recognize those?
Those are photographs that I took upon my examination of items 712 and item 3-2.
Your Honor, combo is introduced and admitted as the next exhibits, A through D.
No objection.
Thank you.
Sounds like Alan Jackson.
Exhibits 197A through D.
So guys, these ones are the match, but these are not the bumper sprinkles. These are the ones that Yuri found
May I
out
double
on the
check?
lawn
Yes.
on February
Ms. Gilman,
the
if I
10th.
could have 9502, please.
He says, do they look like they were found on the lawn?
And Ms. Hanley, what's up on the screen? Can you please describe for the jury what we're looking at in this photograph?
So this is one of the photos that I took of one of the breaks that physically fit together between item 3-2 and item 7-12.
And Ms. Gilman, if I could have 9514. And again, Ms. Hanley, can you please describe for the jury what we're looking at in this photograph?
Sure. So this is a photo that I took when I was doing my comparison of item 3-2 and several pieces from item 7-12.
Now, as far as the individual pieces had sort of little white stickers or labels affixed to them, is that correct?
Yes.
Is that something that you did, or is that something that when the items were provided to you was already done?
So item 7-12, I received those pieces with the labels already on them.
And again, those items, especially 7-12, had been with mixed veneer in your unit prior to coming to your table or your station, correct?
Yes.
Ms. Gilman, if I could have 9518. Again, Ms. Hanley, what are we looking at here?
So this is another photograph that I took of the physical match. It's just another view of the items together of item 3-2 and several pieces from item 7-12.
And lastly, for this batch, Ms. Gilman, if I could have 9520. And again, Ms. Hanley, what are we looking at here?
So this is another picture that I took of the items just slightly rotated of item 3-2 with a physical fit to several items or several pieces from item 7-12.
You can see the top of the glass on
Ms.
this
Hanley,
one.
is there a laser
Little
pointer
rim
on
at
the
the
desk
top.
in front of you?
Yes.
If you could, preferably using this screen just so it's visible for the jury, could you delineate where you see in this photograph item 3-2 and where you see the items associated with item 7-12.
So this right here is item 3-2. And these pieces up here are several pieces from 7-12.
Thank you. Ms. Gilman, you can take that down. Now, the other two items that you analyzed or examined in this part of your physical match analysis were items 3-3 and 7-14, correct?
That's correct.
And turning your attention specifically to item 3-3, if you could just remind the jury as far as the physical description of that item that was provided to you.
Sure. So item 3-3 was 5 pieces of clear glass with broken irregular edges that were recovered from the bumper of the vehicle.
May I approach again, Your Honor?
Yes.
Single photograph, do you recognize that?
Yes, I do.
And what do you recognize that?
That is a photo that I took of item 3-3.
Your Honor, Commonwealth seek to introduce in the minutes of next exhibit.
No objection, Mr. Jackson?
No objection, Your Honor.
Exhibit 198.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9446, please. And Ms. Hanley, in addition to the 5 pieces of glass associated with item 3-3, what else is depicted in this photograph?
This is a photo of the 5 total pieces that are from item 3-3.
And in addition to that, is there a ruler depicted in this photograph as well?
Yes, there is.
And what is the purpose of that ruler in the photograph?
It's there just as a scale.
Thank you, Ms. Gilman. You can take that one down. And Ms. Hanley, the last of those items, 7-14, if you could just remind the jury as far as what was the physical description that was provided to you in reference to item 7-14.
Sure. So item 7-14 was a clear piece of glass with broken irregular edges that was recovered from the road.
May I approach again, Your Honor?
Yes.
Again, Ms. Hanley, just showing you a single photograph. Do you recognize that?
Yes, I do.
And what do you recognize as?
This is a photo that I took of item 7-14.
Your Honor, Commonwealth seeking to introduce in the minutes of next exhibit.
No objection.
All right.
7-14 found by Proctor.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9471, please. And again,
The two screens don't match.
no.
Screens don't match. Not good.
Thank you.
Thank you, Your Honor. Ms. Hanley, again, if you could just describe for the jury what is depicted in the photograph up on the screen.
This is the photo that I took of item 7-14.
Thank you. Ms. Gilman, you can take that down. So, Ms. Hanley, in addition to the physical match analysis that you did between item 3-2, the cup, and 6 of the pieces that you found to be a physical match from item 7-12, did you also compare pieces from item 3-2, 7-12, and 7-14?
Yes, I did.
And what did you conclude in your physical match analysis of those items together?
So upon examining and comparing item 3-2, 7-12, and 7-14, I had concluded that six of the 9 pieces of glass from 712 physically fit with item 3-2. And the remaining 3 of the 9 from 7-12 did not have a physical fit to item 3-2. I also compared item 3-2 and 712 to 714, but there was no physical match to item 7-14.
Now, in addition to that, did you also do a physical match analysis between item 3-2, the drinking glass, 7-12, pieces found from the roadway, and certain pieces from 3-3 from the bumper of the vehicle?
Yes, I did.
And what did you conclude based on that physical match analysis between those items?
So upon examining and comparing those items, so there were 5 total pieces of glass from item 3-3. I used 2 of those pieces for physical match comparison to the items recovered from the road. Upon my examination, I did not, there was no physical match between those 2 pieces from item 3-3 to any of the pieces recovered from the road. So that included items 3-2, 7-12, and 7-14.
Now, as far as the 2 pieces that you had selected from item 3-3, do you recall which of those 2 lettered pieces you chose for your comparative analysis?
Yes.
And which were they?
They were pieces A and B.
And if I could ask why pieces A and B versus other pieces?
So A and B were used for physical match. The remaining 3 of the 5 were not used for physical match comparison due to their size and condition.
Now, those same 2 pieces from item 3-3, pieces A and B, did you then do a physical match analysis between that and 7-14?
I did.
And what did you conclude from that analysis?
I concluded that there was no physical match between the 2 pieces from item 3-3 to item 7-14.
Now, did you also do a physical match analysis between piece E from item 3-3 from the bumper?
I did not. No, not a physical match examination.
Did you do any comparative analysis between a piece of glass E from 3-3 from the bumper and item 7-14?
Yes, I did.
And what did you conclude from that analysis?
So I selected piece E for further examination. I did microscopic examination as well as instrumental analysis, and I did the same microscopic and instrumental analysis to 7-14, and I compared the data, and I came to the conclusion that the piece that I sampled from item 3-3, piece E, was found to be consistent in physical and instrumental properties to the sample that I took from item 7-14.
If you could, Ms. Hanley, could you please explain to the jury when you say instrumental analysis, what is that? What does that consist of?
So the instrumental analysis that I conducted was on the GRIM instrument, which measures the refractive index of the samples. So after I had ran my samples for both item 3-3 and 7-14, I compared the data to determine whether they were consistent or not consistent.
And so when you say that something is consistent in instrumental properties, what does that mean?
So in this instance, they had consistent refractive indices.
Now, in addition to that comparative analysis for the glass items, what other additional examinations did you perform in this case?
Let's talk about the
Sorry,
bumper
could you say that
sprinkles to
again?
the tumbler.
In addition to items 3-2, 3-3, 7-12, and 7-14, what other items did you look at in this case?
So I also examined item 3-1 and item 7-18.18.
And what was the description provided to you in reference to item 3-1?
3-1 was a tail light, and there were also some other plastic pieces as well.
And taillight from the same vehicle as the glass from the bumper, correct?
Yes.
May I approach, Your Honor?
Yes.
You have another single photograph. Do you recognize that?
Yes, I do.
And what do you recognize that?
This is the photo that I took of item 3-1.
Your Honor, the Commonwealth will seek to introduce in the minutes.
No objection.
Thank you.
200.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 9394. And Ms. Hanley, do you recognize what's up on the screen as Exhibit 200?
Yes, I do.
And what do you recognize it to be?
This is the photo that I took of item 3-1.
And what's contained in here, is that a fair and accurate portrayal of what the item 3-1, the taillight housing, looked like when you received it?
Yes.
Now, as far as, and we'll get to this more a bit in a moment, but as far as any sort of comparative analysis that you did with any other item, what part of this taillight housing were you comparing to that other item?
So there were clear and red plastic portions of the taillight that appeared to be broken. So I sampled portions of the clear plastic as well as the red plastic on the taillight.
And just for clarity purposes, if you could with the pointer,
Sampled them,
as
what
far
does
as
that
which
mean?
of these pieces up on the screen were you sampling the clear and or the red plastic from?
So the red plastic that I sampled was from this area.
You're saying
It's a little hard
sampled,
to
you
tell
mean
from
you
here. I think I'd have to
broke
refer to
off
my
another
photo
piece?
in my notes, but I think there were a couple of different areas that had clear broken plastic. I think this might have been one of the areas that was broken that I sampled.
And just for my purposes, really what I'm asking, Ms. Hanley, is the clear plastic that you used from item 3-1 was from the housing unit itself, the large piece, correct?
Yes.
Ms. Gilman, you can take that down.
You broke off more pieces is
Now,
kind of what I
the
understand
other-
that to mean.
Item that you were comparing this to was item 7-18.18, is that correct?
Yes, that's correct.
And what was provided to you as the description of that item, 7-18.18?
So 7-18.18 was debris that was collected from two pieces of clothing from the victim.
And specifically, that would be 7-17, an orange T-shirt, is that correct?
I believe that is correct, yeah.
Okay, as well as 7-18, a gray long sleeve shirt, is that correct?
Yes.
And when you say that item 7-18.18 contained debris, what did that debris consist of?
So the debris consisted of one clear piece of plastic, as well as several pieces of red plastic, among some other trace material.
Now, were there measurements taken of those items within the debris, specifically the clear plastic and the red plastic?
Yes.
And what were those measured to be?
I would just need to refer to my report for that.
Okay, go ahead.
Thank you.
Yeah, go refer to your report because we heard it yesterday, but we obviously need to hear it again.
Okay, so the clear piece of plastic in 7-18.18, it measured approximately 1/8 of an inch by 1/16 of an inch. And then I measured the largest and the smallest of the red plastic pieces. And the largest piece of red plastic measured approximately 1/16 of an inch by less than 1/16 of an inch. And the smallest piece among those measured approximately less than 1/16 of an inch by less than 1/16 of an inch.
And so those particular pieces that you measured, about how small are we talking about?
So the largest for the red plastic, the largest piece measured, just for visual purposes, it's roughly like the size of a grain of rice. The rest of the pieces were smaller than that.
And who within the lab provided that debris in that taillight housing to your unit, to the trace unit?
So the debris from the clothing was transferred to my unit by Maureen Hartnett, and the taillight was submitted to the lab by Trooper Christopher Moore.
May I approach, Your Honor?
Yes.
Showing you a series of 5 photographs. You could review those and look up when you're finished.
Denise coming in here with the important questions. There's a pretty big difference.
Generally speaking, Ms. Hanley, do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those?
Those are the photographs that I took of 7-18.18.
The Commonwealth will seek to introduce and admit as the next exhibit, A through E.
No objection.
Thank you. It's 201 A through B.
Your Honor, may I publish?
Yes.
Now, Ms. Gilman, if I could have photograph 9352. And Ms. Hanley, what is depicted in this photograph on the screen?
So this is one of the photos that I took of 7-18.18. This is how I received the clear piece of plastic.
And is that a tin that it's encased in at the time that you receive it?
Yes.
Ms. Gilman, if I could have 9355. And what is this, Ms. Hanley?
So this is a photo of the clear piece of plastic that was within that tin.
And Ms. Gilman, if I could have 9364. And Ms. Gilman, if you could enlarge this just a bit. Maybe just a little more, please. Thank you. And Ms. Hanley, what are we looking at in this photograph?
This is the photo that I took of the debris that was collected from the clothing items.
Ms. Gilman, if I could have 9366. And again, Ms. Hanley, what are we looking at here?
This is a photo that I took under a microscope of the red plastic pieces that I noted within the debris.
And lastly, Ms. Gilman, if we could have photograph 9369. And Ms. Hanley, what are we looking at here?
This is a picture that I took of the red plastic pieces that I removed from the debris.
Thank you. Ms. Gilman, you can take that down. Now, Ms. Hanley, in reference to your comparative analysis from item 3-1, the taillight housing plastic, to the clear and red plastic pieces of debris from debris from item 7-18.18, the clothing of Mr. O'Keefe. What types of instruments did you utilize in this comparative analysis?
Sure. So after completing my examination, I utilized a comparison microscope as well as a polarized microscope, a FTIR, which is Fourier transform infrared spectrometer. And I also used a microspectrophotometer, also known as a microspec.
And what is a microspec?
So a microspec is an analytical tool that we can use to examine samples that have color. So it provides information on the sample's dyes and pigments.
And how is that utilized in your comparative analysis?
So I ran samples from both items that I was comparing, and I compared the data from those two items as a part of my comparative analysis.
We know you compared.
When you run that sort of data, can you describe for the jury sort of what that data looks like? Like what are you physically seeing when you're examining the data from a microspec?
So what we refer to it as a spectrum or just a graph, and when we do the comparison, we can overlay those spectra or graph to determine if they are consistent or not consistent.
And I know you spoke a little bit about it in your testimony yesterday, but if you could remind the jury as far as an FTIR, what is that and how is that used in your analysis?
So an FTIR is another analytical tool that we can use. A sample is exposed to infrared light and it reacts in a certain way with that light. And what's produced is a spectrum of peaks and valleys that are representative and unique to your sample. And so that instrument was used to run samples from both items, and then the data was compared from both items.
Now, from your comparison of starting with the clear plastic from the debris from Mr. O'Keefe's clothing, from your comparative analysis of that clear plastic to the clear plastic from item 3-1, the taillight, what did you conclude?
So the clear plastic from the debris was found to be consistent in color and instrumental properties to the clear plastic from the taillight. So accordingly, the clear plastic from the debris could have originated from the clear plastic from the taillight or from another source with the same characteristics.
And with reference to the red plastic from item 7-18.18 from Mr. O'Keefe's clothing, in your comparison of that red plastic with the red plastic from the passenger side taillight of the defendant's vehicle, item 3-1, what did you conclude from that analysis?
So the red plastic that I sampled from item from the debris from the clothing from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight. So accordingly, the red plastic from item 7-18.18 could have originated from the red plastic that I sampled from the taillight or from another source with the same characteristics.
I'm sorry, Your Honor, if I could just hold on 1 minute while the sirens pass. May I approach again, Your Honor?
Yes. Actually, is this a good time to take a break, Mr. Lally? Mention break?
Entirely up to the court. I probably have another 3-4 minutes left.
I'm going to see counsel for 2 minutes, folks.
Why are we skipping over the bumper sprinkles to the tumbler, Lally? How come we're skipping over the comparison of the bumper sprinkles to the tumbler? That's what you were getting into right when you were getting into the close of the day yesterday, huh? Those bumper sprinkles from 3.2. You started looking at its microscopic qualities.
We'll take a luncheon break and we'll take an hour. So I know we'll take an hour.
Taking a whole hour.
So we'll just go and follow.
All rise to the court, please. Your closing notebook, follow me.
A whole hour. Give it a second to see if they're going to do anything after the juror leaves. But I saw a couple of notes are coming through about I'm seeing reports that there's 17 jurors back in the courtroom instead of 18. Not entirely sure who is the source of that. But did see that come through. Let me see if I can trace it real quickly. I think it might be from Sue. I think that might be from Sue O'Connell over there at NBC. Nope, no, she says all the jurors are here. So I think that was maybe an initial count. She says, I deleted the post with the wrong juror count. All jurors are here. Seating has been changed. 2 of the jurors have swapped seats. So I believe those initial reports are not correct. And we still have all 18 jurors. So sounds like nobody has been removed. Just wanted to follow up on that. Hello, guys. Good morning. I guess maybe Dr. Wolf is the super busy one that has to be accommodated. So it sounds like it's on the schedule. Goes all the way home after going to work to make his wife a cappuccino. Guys, at that point, I don't care who he is, how arrogant he is. This guy's awesome. Okay, I don't care about it. I don't care how many people's brains he's with. Going home before work to make a cappuccino for his wife. How do you not love that, guys? I went ahead and got the stream muted. Sorry about that. Still getting the little shenanigans with kind of comparing the different sound feeds. So anyway, hopefully that's all sorted. while we were listening to that testimony, I just, I'm interested in stuff. I always like going and looking for studies and information and stuff. I found that article about the incident from 2016. The guy fall backwards from a fight, bashes his head on a piece of concrete and dies 2 days later from subdural bleeding. And look at this. Here's also an article. Let's see, where was this published? Math. Good Lord. What is this journal? I don't always know the shorthands. Mathematical and Computational Applications is the journal. This is an article from 2020. Mechanism of coup and contre-coup injuries induced by a knockout punch. So they have a fight where somebody died as a result of a knockout punch in a boxing match. And they evaluated it. And look, lo and behold, it's a contre-coup injury. Yeah, because that's what happens. You get hit, you get knocked out. When you get knocked out, you can't, you're not necessarily going to like react in a way that's protective. Your head slams into the ground and you have those exact same forces he's been talking about, the contre-coup injury. So yeah, I like how Alessi did that, man. Just keep it tight. Remind us, here's the injury that isn't explained by the car accident. It's not explained by the fall backwards. What does explain it? We've heard a punch so far. Medical examiner told us that was from blunt force trauma. This doctor agreed with that. At least it's possible that it was caused by blunt force trauma. But if nothing else, we can certainly agree has nothing to do with the ecchymosis, nothing to do with the brain injury that he was there looking at. It's completely separate. Yep, adds up. Definitely adds up to me. So go ahead and make sure everybody knows we're on our lunch break. Hey, taking a little bit longer of a lunch break today. So I guess we'll be back about 11 a.m. my time. What a treat. I'm going to go ahead and go through some of your comments and questions before we step aside, check the trees and all that. What have you guys been thinking? Carrie Collins. Oh, here's where we left off. Does anyone monitor judges' actions when obvious bias is taking place in televised trials? Are there any remedies that can take place to dethrone the queen? No, nobody's monitoring. Nobody's monitoring and watching. There are typically judicial ethics oversight bodies. Who does in Massachusetts? Let's see who handles discipline. Judicial discipline. They have a Massachusetts Commission on Judicial Conduct, CJC. It's the state agency responsible for investigating complaints alleging that a state court judge has engaged in judicial misconduct or has a disability preventing him or her from properly performing judicial duties. CJC is also responsible for pursuing, when it is appropriate, remedial action or discipline against state court judges. So usually what happens is there's a complaint. Somebody makes a complaint, and then based on that, the judges will review it. It is not completely unheard of for something to come to their attention, a problem to come to their attention because of a news item or story or something like that. Sometimes it'll happen. For example, a judge might get arrested for a DUI or something, and there's a news story. The Judicial Commission finds out about it. It's just, one of those things that rapidly becomes known. So you don't necessarily need a formal complaint to initiate an investigation of something like that, but something that like facially kind of raises questions about, is there going to need to be judicial discipline here? But in a situation that's not, quite that, highly doubt anybody from the CJC is sitting here watching this trial, looking to see if there's any issues, any problems, any remedial things that need to be taken for Bev's behavior or anything like that. Anything would likely result from some type of complaint. So those are the remedies, guys. It's up to them. I'm not sure in Massachusetts if there's any kind of like impeachment process for judges. I know that they're appointed by the governor. Beyond that, removal, I don't know. I don't know what if any mechanism there is. So apart from that, you're typically looking at the disciplinary proceedings, and no, they're not watching the trial to see how she's doing. They're just waiting to see if anybody makes a complaint that warrants an investigation. The Traveler, tomorrow is the buffer zone hearing. Will Canoni appear? What are the next steps for that? Good question. I did see that some of, let me see if I can find it. Some of the folks who, here it is. In fact, I can just share it because, of course, Dee Dee, as always, has the documents. She's got the goods. So 3 individuals that have filed requests for review per the supplemental order. The supplemental order just said a judge, a superior court judge will review it, not necessarily which judge. So we don't know if this is going to go in front of Judge Canoni or not. She might be on her way to the Cape. We have no idea what her plans are for tomorrow. But set for hearing is more information than I had about it at this point. So Erica Walsh, she's the one who's been wearing this Criminals Control Norfolk County sweatshirt. She has apparently worn that into the buffer zone, but doesn't interfere with the administrative justice. It's not while jurors are coming and going. She had no intent to do that. She's just been wearing this t-shirt as a demonstration, a political speech. And so this is real squarely within that modification that the First Circuit was requiring that Judge Canoni make to the order. Because for this, outside of the courtroom, off of the courthouse premises, to be able to regulate conduct outside of that area, they were relying on the Cox decision that had a mental state requirement. There has to be an intent to interfere with the administration of justice. So this seems to fall pretty squarely within that, arguing that just wearing this t-shirt alone, jurors are not coming and going. This is an overbroad application that infringes the First Amendment rights. Then there is Jason Grant. Mr. Grant had a sign that cited 2 Corinthians 3:17, which he spells out for us. Now the Lord is the Spirit, and where the Spirit of the Lord is, there is freedom. What a great one. That's a great verse. The Massachusetts State Police denied him access, into the buffer zone, basically. He wants to be across the street from the courthouse holding this sign. Is that going to interfere with the administration of justice? A Bible verse? Pretty squarely First Amendment activity. And then, sorry, Dee Dee. Oops. Gotta find back to where we were. Then the last couple, Thomas DeRosier was filming the exterior of the Norfolk Superior Courthouse from across the street. He was initially told he's fine, but then somebody else came over and grabbed him, injured him, dragged him across High Street. He required medical attention. There was no criminal violation here, is essentially the argument. So they've basically established these 3 different kinds of protected speech. Wearing the T-shirt with the Criminals Control Norfolk County. Political speech about the government, the Bible verse, religious speech, and then the act of photography, taking photographs. This is First Amendment protected activity as well. So that's what's up for a Superior Court judge to review under the amended gag order, amended buffer zone order. So who is that going to be? I don't know. I don't know if that'll be Judge Canoni or if it will be some other judge. If it's been set for hearing, then the next thing that will happen is just for the parties to show up and make their arguments. This comports with the First Circuit's ruling, or it does not. So that's what I would anticipate coming out of that. Mr. Pastulio, can they possibly do a third trial if it's a mistrial? Do you think they would do it? I feel like there should be a limit. I definitely feel like there should be a limit. But in terms of the constitutional limitations from the double jeopardy clause, there's no limit as long as there is a manifest necessity. If the jurors can't reach a verdict over and over and over and over and over again, then they can continue to retry, or they can continue to keep trying. You would think at some point there would be a practical limit, if nothing else. Surely you would suffer some political blowback by prosecuting this case for the third, fourth, fifth time after you've been unable to win it before. But that's not legal. That's not legal. That's just a matter of judgment of the person who has the power to make decisions about what gets prosecuted. And so the only limit on that is the ability of the voters to influence that person's exercise of their judgment. Do you think they would do it? I don't know about a third time. On the one hand, there's so much sunk cost here. They've invested in it. They've really doubled down. Now they went out and bought a whole new Lexus and got these new experts and all this stuff. Like, they've really doubled down on this prosecution after the first mistrial. So if there's a sunk cost factor in all of that, then it just means they'll double down even more and they'll throw even more at it. But I have seen the little hints here that just suggest to me it's possible this is kind of being set up to be the last shot and then done. The way that Jen McCabe has kind of been anointed the representative of everybody who is inside 34 Fairview. She's the only one that was called by the Commonwealth to come and testify about the events of the night. So that way, if the jury doesn't buy it, we can point the finger squarely at Jen McCabe. Say, look, the problem is you. They didn't believe you. If they had believed your testimony, they would have convicted and we would be done. So the fact that they didn't means we can point the finger at you. Same thing with Michael Proctor, really marginalizing him, trying to distance him, keep his fingers out of it. And that way, if it comes back and they can't convict her, it's possibly it's that taint from Michael Proctor. So those things can't necessarily be overcome. If the jury thinks Jen is a bad witness because she lied to the FBI, you really can't overcome that. If the jury thinks that the evidence is bad, we don't believe Jen because look at what they're saying, all these people inside the house to each other in their group chats when they think nobody's looking. That's a problem you can't overcome. So, I mean, there's little hints that maybe they wouldn't, maybe this would be the last shot, but I don't know, guys, with everything they've thrown at this, it's a lot to walk away from. Heavy pull of that sunk cost fallacy at this point. Poll 10, it amazes me how the victim's family can apparently support the prosecution and law enforcement in the Delphi and Karen Reed case. Thanks for the great commentary, Andrea. People want to believe the police. They want to believe the police are on your side. They want to believe the police are doing the best to provide answers, to provide resolution, to find the right people, et cetera, et cetera. Your incentive is aligned with believing in the police if you're somebody that has been victimized by a crime. You want to believe in them. So it's not really very surprising to me. I think in this particular case, that is maybe strengthened a little bit too by the fact that it seems pretty clear Peggy didn't think much of Karen. They already didn't like her. Already looked down on her, already, condemned her various ways for various reasons. I mean, who knows? I don't even, we don't know the whole story here, but we know when Peg and Jen run into each other, or Peg and Karen run into each other in the hospital, Peg's reaction, what's she doing here? And the whole, so you just left him there, dropped him off at the house. You just left him there. There was never gonna be a way for Karen to be on the right side of this situation in Peg's eyes is kind of how I see it. So you have those two converging things. You have Peg is already ready to believe that it's Karen. It's perfectly consistent with her pre-existing viewpoint that Karen sucks. And then that's combined with you want to have faith in the police to give you the right answers. Yeah, man, the mind is an amazing thing. The things that it can rationalize and reconcile and explain away, it is truly remarkable. Josh Fiore, do you think Welcher is still next witness? Appreciate you for sharing your knowledge and to help us understand this crazy case. I was predicting that, but I am wrong. It's Christina Hanley coming back. So I don't know what the plan is for Welcher. I don't know. We've still got a full day. I don't know if there's going to be other witnesses that they call besides Welcher at this point. I don't know who it would be. I don't think they have any other tech people to bring in. Don't think they're calling Trooper Paul. Trooper Paul got shit canned for these Aperture people. It wouldn't really make sense to call like Good or Seraph or any of the other first responders, any of the other precipient people. Like we've moved kind of past that part of the case presentation. Not that you can't do it. It's just it doesn't fit the logic of the presentation. So I still think he's got to be soon, but I don't know. I was wrong about it being him today. So maybe he'll be this afternoon. Maybe he'll come for the half day tomorrow. Really not sure. Josh H. Turtle Boy looked up the Matt McCabe Aperture connection the other night on his show. It's not the same Matt McCabe. Yeah, this is kind of always the issue of trying to do biographical research with the internet is on it, even with like sometimes kind of rare names, unusual names. They're not unique. They might seem like it, but they just aren't always. And so hard to verify who you're talking about when you just have names and stuff like that and in news items and websites and so forth. A cool breeze. Where is the strike point that indicates how the blinker shattered? I await these types of explanations with great anticipation. Yes, where is the impact point of the taillight that had such significant force that it caused the taillight to shatter, but not enough force to leave a bruise? I definitely await that explanation. Think that's going to be a pretty tough hill to climb, in my view, but we'll see. Rotorman Dan, Bev gave several tells with her eyes and body language when she ended the session yesterday. Yeah, a little bit more of the same stuff yesterday with just the smiles and the kind of laughing and giggling a little bit. They do. There seems to be some type of body language level communication that's happening between the case participants. And like I said, in and of itself, that doesn't particularly alarm me. Like the people who are running the trial, they know more about the process of the trial than the observers, the jury, and so forth. They know what's been discussed at Sidebar and what kinds of issues they've been dealing with. So they have their own inside knowledge that the rest of us don't share. And it's not really that alarming to me that they, will recognize that mutually among each other. But what does bother me is a perception of like you got little inside jokes or little funnies or things like that, particularly with this person. That's what I don't like. Roy Handy, LX570 does not have auto braking when in reverse. One of the safety features apparently does not have. I don't know. I've never had a Lexus LX570. I know some people are like super car people. They know every model. They know every feature of every car. It's like the same kind of brain as the sports trivia people. Some people, my brother was like this. When he was a kid, he would just have this, you could spit out who is where and where they started, what their rookie year was, what their batting average was for the last 3 years. Like all those stats just has them, like that. I don't really have that kind of brain, for that granular. level of data stuff, but I know plenty of people do, and cars are commonplace to have that granular level of data. People know everything. People wait for the car shows. Every year they do the car shows with the new models and the new features and the concept cars and things like that. And there's people that watch and learn and retain every single little bit of that information. That is not me. I have no idea what the safety features are in any model year of any Lexus, let alone, the specific one that Karen has. But I do expect to hear from it. That seems like the kind of thing I should hear from a defense expert, because I would want to know one of the ways to put this information in context, this information that we got from Shannon Burgess about the data, is to understand how does it fit within the universe of data that is or should be available, and what would be expected in this universe of data from the type of incident that the Commonwealth is alleging happened. I don't expect the Commonwealth to give me that, because unless it helps them, the fact that there's nothing on the black box, any of the black box devices, these other sensors and things like that measure things like rapid braking and rapid acceleration and sudden turns and all of those types of movements. If it helped the Commonwealth, they would have told us all about that stuff. So I'm kind of depending on the defense to help us understand the significance. As far as the Commonwealth is concerned, this all just exists in a vacuum. But I think that would be potentially very helpful to understand what else is there. Tell us about this car. Tell us about the safety features, the monitors, and so forth. Jesus Freak. Has tow driver been interviewed? He would walk around before hooking up, and after loading, securing. If he saw damage, he would photo document for CYA. He's on the defense's witness list. The tow driver is on the defense's witness list. I know he did at least one public interview where he indicated that he did not see the damage to the taillight. And yes, everybody, this has been a common, even all the way back to the first trial. If there was damage, surely the tow driver would have documented it, because you don't want to be on the hook for it for liability purposes. You are a bailee of the item is the legal term. You are entrusted with it. You are temporarily responsible for it while it's in your possession. So you are responsible for returning it to the owner in the condition in which you found it. Bailee can be like a valet for your car, sometimes a parking garage, but not always. Just a lot of factors can come into whether there is a bailment that's created by temporary changes in possession. But tow truck driver is a bailee. I don't think there's really any question about that. If he goes and he hooks up his tow hook to your spring instead of to the tow hook or frame of your car or something like that, and he pulls the spring off of your car trying to load it onto his tow, he's going to be responsible for that. So while he's got the car in his possession, if he doesn't secure the car all the way to the tow, and you're driving down the freeway, and you take a hard turn, and the car goes tumbling off of the back of the tow truck, he's going to be responsible for that. So yeah, they're going to document the condition of the car, because you don't want to show up with a damaged car and be blamed for it. And if you haven't documented that the car was not damaged when it came into your possession, then you might be getting blamed for it. You might be getting hauled into court and all that. So this has long been on the radar that surely the tow truck driver would have documented it. Not clear to me from that interview the tow driver gave whether he did in fact photograph it, or whether his view was that there was no damage, so nothing to document. But he's on the defense witness list, so I anticipate we'll hear from him. Jason McClellan, is there a risk of this trial becoming too technical for the jury? Yeah, and I think that risk is escalated when you have the types of witnesses who just can't, they're not able to put it in lay terms, in everyday communication that people can understand. If you're just up there like Jessica Hyde throwing out the SQLite database this and the that, and it's just this soup of technical terms, or even this neuroscientist, this neurosurgeon that we had today, you know, the foreman, whatever, and you know, the subdural versus subarachnoid, and all of those types of terms, you really increase that risk, because it just sounds like a blizzard of incomprehensible stuff to people who aren't familiar with this. So a brain surgeon that's used to using a lot of anatomical language while he's teaching other doctors isn't necessarily going to have the skill set to be able to explain to a jury, this is what this brain injury means, and this is how I know. Yeah, I think you run the risk. You run the risk of it being too technical. It should be common sense. It should be fairly easy. Most car collisions are, hey, this person looks like they were in an accident. The vehicle looks like there was an accident. There's markings on the road that indicate an accident took place. There are witnesses who saw it, heard it, captured on video, whatever. It's in the black box of the car, you know? This is definitely not that. It's definitely not that. So they're having to rely heavily on this technical stuff to try to make the case that there was an accident, because they can't make the case from John's body. But at the same time, they don't seem to have, at least so far, been able to tie this together in a way that is simple and easy to understand for lay people, that is not overly technical. So yeah, I think that's a real potential risk here. Guys, it's been about half of the lunch break so far, so I am going to go ahead and pause at this point. I'm going to step aside, do my little check everything out routine, get a few steps in. I haven't been so good about doing the get up and move around. A lot of sitting so far. So get a few steps in, I think will help a lot for the afternoon session. But thank you very much for hanging tight. I will be back very shortly. We're back, guys. Thank you for accommodating me. Gosh, this long lunch is so luxurious. I'm almost half tempted to put my feet up, take a little nap, a little power nap. I've never been good at that, though, is the problem. I'm one of those people, I lay down for a nap and I'll see you in, 3 hours. I'm not good at the fall right asleep and wake up 20 minutes later completely refreshed. I don't understand this skill. If anybody has this skill and can share with me how to cultivate it, I would love it. But never been my talent. Let's see what else we've got. K, a pending degree usually means you've completed the coursework and applied for graduation and await the diploma. SB was misleading. Yeah, I don't know if this is a term of art or anything like that. Pending, yeah, does make it seem like there's just a formality that's waiting to be completed. Maybe you need to sign a paper. Maybe you need to, show up and walk on a stage, be handed a diploma. I don't know, but pending does sound like just a little thing that needs to be wrapped up. Currently pursuing, that could mean anything, right? That could mean anything at all. Seems like the main takeaway is just it means you don't have it. So I don't know what it's doing on your resume if you don't have it. I'm not in the habit. Are you guys in the habit putting stuff on your resume that you don't have? But it seems like it would be a good idea someday. So you look some stuff up on the internet about it, and that's your pursuit. You're currently pursuing it because hey, I looked into a program online. Yeah. Grifting gamer, I'm pursuing being a lawyer for 20 years, but I truly did become a cop. This case was wrapped up a little too nicely. It's obvious evidence was planted. Well, it's, I find it fascinating that you think that. It seems like the biggest problem I have with the evidence and how all these pieces tie together is the absence of anything that morning. When there was hardly any snow, when you have the snowblower out there, you take it down to bare ground and there's nothing. And then all of a sudden, after all this time, there's all this other material that's found. It's really hard for me to get past that. The issues with the chain of custody. I don't know why you wouldn't. If this is such good evidence, and it is, it's great evidence. I don't understand this at all. It's great evidence. If you've got Karen Reed's taillight that you are collecting from the scene later that day, she hasn't been back to the scene. So there's really only one time, last time her car was there. It's like really the only time when it could have caused that taillight to be there. You recover that the same day. That's good evidence. And you don't go to the trouble to lock that up tight. Take it away from the defense. Why would you not book that immediately into evidence? I just don't understand it. And it seems like maybe it's just cockiness. They really did think, oh, she's going to plead out. None of this stuff really matters. It's just a formality. I think, one of the sort of unforeseen conclusions that one might draw from watching this trial is, if you're going to pin it on the girl, if you're going to do the frame job, you better commit to it all the way, because boy, you leave these loose ends, get a little too chatty in your group chats. It's what makes the whole thing fall apart. So yeah. And just like this guy has seen more brains, he's seen more brains than the forensic pathologists. You've seen a lot more criminals than the defense lawyers. Mandy 727. If injuries were from a dog, there should be heavier skin cells inside hoodie sleeve. If not, indicates hoodie was off, equals he did go inside the house. Interesting theory. I don't know about this. I don't know how this works. Not quite sure how that pattern would work. If the pattern is supposed to be the dog's teeth went through the hoodie and then his arm, scratched his arm, well, then it seems to me like there should be blood from his arm on the inside of the sleeve near where those holes are. Shouldn't there? I mean, at a bare minimum, I'm not sure I, know enough to know like what the skin cell deposition or anything like that, the cell pattern would be. That's well beyond my limited frame of reference. But at the very least, I'd expect the blood, or just whatever. Sometimes you get that like lymph seepage, that clear seepage from a wound. You get a scrape, doesn't bleed, but it seeps. Something like that. You'd expect something like that on the inside of the hoodie, around at near the edges of where these holes were. Doesn't sound like we can't have any of that either. So I don't know what to make of this. Now, I know there has been in the past a theory of laundering or something like that. Theory of laundering of the clothes. I don't, this has been a theory outside of court. Of course, it hasn't been presented in court. No idea if there's a way to evaluate that or validate that or rule it out or anything. I don't know. Maybe how would laundering fit into things? You can only get so much blood out in the laundry. I think many of us can speak to that. But if it's fresh and if it's new, I don't know. I don't know what to make of all this. Jason McClellan, is blood spatter like ballistics junk science? I mean, it can be. I don't know that it's necessarily junk science in the same way that ballistics, the bad ballistic stuff is, just because it is at least derived from, fairly consistent physical principles. Like we know how fluid works. We know, biomechanical stuff. We know how, actions produce reactions, and forces acting on items produce certain, other reactions and stuff. So it at least is, grounded in that kind of hard science, and just interpreting how do those principles apply to produce the pattern that you see. But some of it I think can be junk science. It just depends, I think, on how far you take it and how much of an inference you're trying to draw from a particular appearance of a blood stain, blood spatter, blood pattern, something like that. If you're going to try to tell me something like, this smeared pattern of from blood came from a finger, like it better have a fingerprint in it, or I'm going to have a hard time, buying that there's any reason to think this smear was caused by a finger compared to, some other part of a body or some other object entirely. So just things like that. It depends on how far you take it. The problem with the ballistics, it's got grounding in good scientific principles, materials, and how they interact and so forth. The problem is that there is no validation to establishing what a match is. It's sufficient agreement is the standard. I look at this, it appears similar, therefore it's a match. I mean, that's kind of what the standard is. So a little bit different in that sense, as far as what makes it junk science and why. So I think in some respects, blood spatter is a little bit more valid than that. But it's like anything, you can always take it too far. It just depends on what the evaluation is. But I mean, there's really no question that given what we know about fluid dynamics and stuff like that, if you have blood in a particular pattern, blood spattered in a particular pattern, yes, at least in theory, you should be able to work out the physics that led it to that configuration. And from that, that can help you potentially sort out a mechanism for what caused the blood to spatter in that pattern. So I'm not going to throw it all out, but it just always depends on the details. Jason McClellan, if second mistrial, would the Commonwealth go for a third trial? Depends on their sunk cost. Talked about that right before lunch. There's a lot of sunk cost here. They've really doubled down in the second trial, hiring all these new experts, buying the XUV. I mean, they've really doubled down. And so I don't know if that means that we're going all in on this trial. And if we don't win it here, we're done. Or if it means we lose this one, we have sunk so much into it at this point. You know, I can not lose, but, you know, get another hung jury, for example. We've sunk so much into it at this point. Do we really just walk? I don't know, guys. That's going to be hard to get past. Somebody is going to be really committed to moving forward just because they've already put so much into it. And it would seem like a waste not to. And if you decide not to, is that somewhat of an implicit admission that maybe you shouldn't have gone so far down this road in the first place? That maybe the decision to throw all these costs at it was a mistake? Nobody likes accountability for that kind of decision. So these sorts of human factors seem to me to tip in favor of, yeah, they'd probably try her again. D. London 1144. The dash cam footage of the welfare check shows the tail light largely intact. Where did all the plastic in evidence come from? The dash cam video, I mean, or the dash cam, the still, it's in many ways, you know, once again, just a little bit of an ink blot. It's a little bit of an ink blot. I want to see if I can find that particular photograph. I just don't remember. I don't remember where it was introduced in evidence in the first trial. Yeah, I just don't have it readily available. I was going to pull it up so that we could all look at it. I think the issue with it again is just it's not that clear what you're seeing. It's covered with snow. It's not high definition, super detailed. It's a screenshot from a video. And so to some extent, I think you can kind of see on it what you want to see. It's not even clear to me that there's any defect on it at all. How much of what appears to be a defect is a product of the fact that the snow is not falling uniformly, accumulating on all parts of the tail light at the same rate. You got wind that's factored in. You've got just, the vertical angle, like all these different types of things. So I see that it looks different from the other tail light, but is that because the tail light itself is different or because the conditions at that corner are different than the conditions at the other corner? I don't know. So, I mean, the jury, yeah, they're going to be looking at that photo. What are they going to make of it? It's kind of an ink blot. If they want to convict her, I think they'll look at that tail light and be like, look, it was cracked at 8:30. You can see in the picture, just like you can see the white light in all of the surveillance videos. If you think she's innocent, you're like, this photo shows nothing. It shows nothing. It shows at best some kind of crack that is consistent with what Karen described. And frankly, even how Jen described it initially, it was cracked. But that is kind of a hard thing to predict. Amelia Walsh, Paul snowplowed One Meadows after they came home. I remember that. Lally showed us that during the first trial. We sat there and watched for like half an hour, at least, maybe. Maybe my memory has distorted that. It seemed like forever. We just sat there and watched video of that driveway at One Meadows Ave. And somebody goes out with one of those, snow blower machines that, chews up the snow and shoots it out the side. And you watch them do that for a while. Feel like it was at least half an hour that we watched that. So, that would tend to undercut if Karen had dropped pieces of taillight into the driveway. Number one, it explains potentially why nobody ever found them, because you chewed it up and you blew the snow wherever and the snow got plowed away, and kind of what you would expect in that sort of situation. But also, that's why if there's some theory of Jen McCabe or somebody else even went over to One Meadows while Karen was in the hospital before she came back to get her car. They would have had that window in the morning. It would have had to have been like before the O'Keefes came over. So it would have had to have been a pretty quick decision. Decide we're going to pin it on the girl. Get right over there and get it before people start showing up at John's house. And I mean, frankly, even then, isn't that pretty risky? I don't know. But yes, I remember that Ring video loud and clear. It was excruciating having to watch all that in the first trial. Odin's Martyr. If only they had Higgins' phone to prove he didn't go to John O'Keefe's early in the morning to get tail light pieces. It would rule out, wouldn't it? It would rule out. Did they get his CDRs? Did they get his call detail records? Plug those into Trax or Cellhawk or something like that, like they seem to have done with Jen McCabe's call detail records? You can get some of that from the backside, from the tower side. Possibly could have done that. Suspect if they had, we'd have known about it already. Eric Wolfrick. Do we think the defense brings in the Dighton officer from the tow who said the tail light was cracked but not completely broken? He is on the witness list as well, Officer Nicholas Barros. I think there's a decent chance that they will. I've always, ever since last year, I've been kind of marginal on the significance of his testimony. He didn't say, nobody asked him, here's the photo of the taillight in the Canton Sallyport Police Department. Is this what the taillight looked like when you saw it? That would be real definitive, I think, about did something happen after the taillight came into possession of the investigators of Proctor and the folks at the Canton Police Department that changed its condition from when it was in Karen's possession. That would be real definitive if he looked at that taillight photo and was like, yeah, no, it didn't look like that. But nobody asked him that. And I think that's in part because the answer that he gave, it was one that both parties can use. Cracked works for the defense, but it also works for the Commonwealth. Because everybody can say it's. But you don't ask the final question because it's too damaging. And so somebody is losing the case depending on the answer.
Now, Ms. Hanley, when we left off, you were discussing the comparative analysis you did between item 7-18.18, Mr. O'Keefe's clothing, and item 3-1, the taillight housing or the plastic within the taillight housing of the defendant's car, correct?
Correct.
And there were a number of different instruments that you used.
Let's reorient again. Let's go through the instruments again.
Correct?
That's correct.
And what were those instruments that you used again in that portion of the analysis?
I can't believe he's actually doing it.
I used a polarized
Tell us again what those are.
A comparison microscope, an FTIR, and a microspec.
And Your Honor, may I approach?
Yes.
I can't believe he did. I really was
Three
joking.
documents, if you could review those with Dr. Finch, please. And do you recognize those?
Yes, I do.
And starting with the first page of that 3 pages, what do you recognize that?
It is the FTIR comparison data for the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And if I could direct your attention to the second page within that, what do you recognize that?
So this is also FTIR comparison data from for the red plastic from item 3-1 and item 7-18.18.
And lastly, the third page within that set, what do you recognize that?
So this is the comparison data from the microspec from the red plastic from the item 3-1 and the red plastic from 7-18.18.
Your Honor, the Commonwealth will seek to introduce and admit as the next 3 exhibits individually.
No objection, Your Honor.
All right, thank you.
You want them marked individually or you going to set?
Individually, please. Thank you.
Lolly's really go in on that, matching the debris.
Exhibits 202, 203, and 204.
Thank you.
As if somebody couldn't have busted
And
the
again,
tail
Ms.
light
Hanley,
out
when
in
it
the
came
Sally
to
port.
your analysis of the clear plastic
Use the
material
little
from
rag,
the debris from
put it up
John O'Keefe's clothing and the
shirt, the
clear
little
plastic
rag.
material from the defendant's taillight, what were your conclusions from that analysis?
Sure. Upon
Say
comparison,
them again.
the clear plastic from item 7-18.18 was found to be consistent in color and instrumental properties with the clear plastic from item 3-1. Accordingly, the clear plastic from 7-18.18 could have originated from the clear plastic from item 3-1 or from another source with the same characteristics.
Thank you. Your Honor, may I publish, and I'm sorry, I forgot already the
Yes.
exhibit numbers, but
Yes.
Ms. Gilman, if I could have the clear plastic. And Ms. Hanley, can you describe for the jury what we're looking at in this, what's up on the screen right now?
Sure. So this is the FTIR comparison data of the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And Ms. Hanley, if you could, using the laser pointer before you, if you could direct the jury's attention to which is which as far as the top and bottom.
Sorry.
Good to know about the Apple Watch.
So the top,
Sorry, I apologize, Your Honor.
That's okay.
Something humorous is happening.
the top spectrum is item 3-1 and the bottom spectrum is item 7-18.18.
And Ms. Hanley, when you're comparing these two as far as the data that you receive, what is it specifically that you're looking at in your comparison as far as the data is concerned?
So when I'm comparing the spectra, I'm looking at the peaks in each sample to determine if they are consistent or not consistent.
Please tell me it was whoop whoop.
And if I could turn
Under
your
the
attention to
police.
the red plastic material from the debris from Mr. O'Keefe's clothing and the
Great
red
ringtone.
plastic from the passenger side taillight of the defendant's vehicle, what did you conclude in your analysis there?
So upon comparison, the red plastic from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the red plastic from item 3-1. So accordingly, the red plastic from 7-18.18 could have originated from the red plastic from item 3-1 or from another source with the same characteristics.
Thank you. And Ms. Gilman, if I could have the red plastic data. And Ms. Hanley, directing your attention to the screen again with the laser pointer, if you could delineate for the jury as far as which set of data is associated with which item.
So the top spectrum is item 3-1 and the bottom spectrum is item 7-18.18.
And again, if you could just direct the jury's attention with that laser pointed to the areas as far as the data peaks and valleys that you're looking at in comparison of this.
Those
data.
don't look like a match, do they?
So
if you look at
when
the
I'm comparing them, I'm
60 to
comparing
80
the peaks
or 80 to 90
to each
area
other in each of the spectra.
On the bottom
to determine
one versus
if they
the 90
are
to 100
consistent
area
or
on
not
the other one,
consistent.
there's like a shift.
And in this case, you found them to be consistent. Is that correct?
That's correct.
And Ms. Gilman, lastly, if I could have
They're not identical.
microspec data. And Ms. Hanley, if you could describe for the jury, please, what are we looking at in this particular data set?
So this is the comparison data from the microspec of the red plastic from item 3-1 and the red plastic from 7-18.18.
And as far as the data in any microspec, but particularly this one up on the screen, using that laser pointer, could you illustrate to the jury sort of what these individual lines or what this data means?
So these are the samples that I ran, and they samples that I ran from item 3-1 and 7-18.18, and the spectra are overlaid in order to determine, to look at it and to determine whether they have a consistent or not consistent pattern.
And from overlaying the data from the pieces of plastic from Mr. O'Keefe's clothing and the pieces of plastic from the defendant's tail light, what do you observe as far as from overlaying those two sort of data points?
So I determined that they had consistent microspec data.
Again, if you could just remind the jury as far as the microspec data, what type of data is that?
So the microspec, it analyzes samples that have color. So it provides information of a sample's dyes or pigments.
Thank you very much. Ms. Gilman, you can take that down.
Well past that
Thank you, Ms.
4
Hanley. I have no
minutes
further
Lally
questions,
estimated, huh? Oh, how come you skipped over the bumper sprinkles, Mr. Lally? How come you skipped over the rest of the bumper sprinkles?
Good afternoon, Ms. Hanley.
Good afternoon.
Nice to see you again. We met about a year ago.
Remember me?
First things first, you were just talking about some plastic pieces in 7-18.8, correct?
It was 7-18.18.
0.18, I left the one out. 7-18.18. We're dealing with a lot of numbers. I'm going to see if we can cut through that here in a second. Sure. First of all, you indicated that you were doing a comparative analysis in different, sort of different categorical ways, using microscopy, using the microspec, using the FTIR. I think you also use the FTIR in that as well?
Yes.
And you indicated that your analysis concluded with those pieces could have come from the same source, from the source that in 3-1, the taillight. But you're not conclusively saying they did, correct?
It could have come from, they could have a common origin, or it could have come from another source with the same characteristics.
Right. So in other words, another way to say that, Ms. Hanley, is it may have come from the taillight, may not have.
It's a possibility.
Okay. I also want to ask you real quick about the taillight manufacturer. You were shown an exhibit, I think it's exhibit 200, and I think we have that available. With the court's permission, we don't have to cut the lights. I think the lighting is just fine. This is exhibit or a photograph of exhibit 200 that you saw just a second ago. Quick question about that. In your inspection of that taillight, it's true, is it not, that that is manufactured entirely of plastic or plasticine pieces? There is no glass in that taillight, correct?
I have to check my notes. I don't think I noted any glass.
Okay. So in other words, you didn't note any glass inherent in the manufacture of that taillight. It's basically plastic.
Check your notes. Refresher. Let her take her time.
Yeah, I think most of the parts were plastic. I'm not 100% sure if the entire thing was plastic. There may have been other material, but portions were plastic.
But you certainly didn't see any glass inherent in the manufacture process.
I'd have to double check my notes, but I don't think I did.
Okay.
Do you want her to check her notes?
Why don't you?
Yes,
Are your
why
notes
don't
in front of
you?
you?
Yes.
With the court's permission.
Yes, sure.
Good idea. Go ahead and check your notes. Because we know there's some metal in the taillight. We know that there's screws. We know that there's some metal parts of the housing. There might be like rubber gaskets and stuff like that. But any glass?
Okay, so I did not make any notation that I noted portions that were glass.
Great. Final point before we get into the actual analysis. On any of the glass, I want to shift gears to just the glass material that you analyzed and that you looked at and you inspected. You saw no blood, no skin, no biological material, no tissue, human tissue or otherwise, on any of those pieces that you inspected, did you?
Upon examination of those items, making observations of those types of material, that's not my area of expertise. I don't think I noted anything that was maybe consistent with that.
So in other words, even though you're not in the bio material expert section of the lab, you certainly would have noted if there was skin or biological material or obvious blood on glass pieces. You were looking at them in many cases through a stereo microscope, correct?
Yes, I would have made note of observations of anything that I would have noted on the surface.
Great, and you did not, because you didn't see anything that was suggestive of that, correct?
I think I just made note, I have to check each item, but I think I did note that there was some dirt debris on some of the items.
But not biological material.
I did not note anything that would be maybe consistent with that.
Great, thank you. I want to talk about the comparisons that you did. And you'll forgive me, I'm a visual learner. So I'd like to talk about it in 4 categories.
Okay.
Linear categories. Category 1, item 3-2. Category 2, item 3-3. Category 3, item 7-12. Category 4, item 7-14. 3-2, 3-3, 7-12, 7-14. Can we talk about it in those particulars?
Sure.
Okay. 3-2 was the cup, correct?
That's correct.
Okay. And I'm going to use the word cup rather than glass for obvious reasons. You can get confused by that. So when I say the cup, Do you know what I'm talking about?
Item 3-2.
Great. 3-3 are the 5 items that were found on the bumper, claimed to have been found on the bumper by MSP or crime. Okay?
Yes.
5 items, A, B, C, D, and E, correct?
Correct.
Item 7-12 are 9 items, glass items, that were recovered at 34 Fairview by Trooper Buchanan in an evidence envelope, correct?
So sustained as to who they were recovered from.
Sure. Did you receive the items along with an evidence envelope?
It was on the evidence envelope.
Need to double check if it was an envelope, but I received it packaged.
Okay. And the packaging normally, under normal circumstances, the packaging comes with labels. It gives you reference about where things came from. For instance, when Mr. Lally asked you, were you aware? Or did
Definitely
you
find the
aware
exhibit
that
with the
items
photograph,
had been found on
if not the
bumper?
bag itself.
You didn't actually find those items, but that's what that was the description you were getting, correct?
That was the description of the item in our limb system.
Okay. And going back to 7-12, that's our third category. Was that described as 9 pieces of glass that were found at 34 Fairview by a sergeant by the name of Buchanan? Or do you recall that?
I am not sure who recovered them.
Well, what it said on the evidence envelope, that's what I'm asking.
I would have to check my photos to see if it says that.
We'll get to that in just a second, but fair enough. 7-12, 9 items, A, B, C, D, E. And if my memory serves, I, K, and L.
I'd have to refer to my notes to.
Can you please?
Yes.
Is anybody believing that a forensic scientist
So the 9 pieces of glass from
Wouldn't notice
7-12 were
blood?
labeled A, B, C, D, E, F, I, K, and L.
Great. And then finally, what was in 7-14, that's an easy one, 1 piece of glass.
That's correct.
Okay. Your Honor, may I approach?
Yes.
If I could, Ms. Hanley, I'm going to hand you photographs. That should be 2 photographs of the exact same thing. Do you recognize what's depicted in that photograph?
I've never seen. I did not take this photo.
Understood.
So I'm not. I haven't seen them, so I don't know.
So I'm asking you to look. I know you haven't seen that photo. Does it look like the cup?
It looks consistent with the cup.
Okay. Just gonna set this aside for a second.
She went to the Buchanan School of not authenticating the other party's exhibits.
Take a look at
Don't
the second
know.
photo. Do you recognize what's depicted in that photo?
Could be the cup, looks consistent with the cup. Can't say it's the cup.
So I did not take this photo. It appears to be a photo of a container that another analyst took a photo of item 7-12.
And item 7-12, once again, included plastic pieces and 9 glass pieces, correct?
Correct.
Do you see the evidence label on the very top of that evidence envelope?
I'm not sure which label you're talking about.
One under the red tape.
Yes.
Does that appear to be a label marker that's done to maintain chain of custody?
So I think that label. Sorry.
Sure, can we bring these over to side? Sure.
Now Hank wants to see him. We're going to sidebar because she has so much difficulty recognizing the bags that she examined if they're in a photograph that's taken by somebody else. How do you even recognize your kids in their school photos? You weren't there. You didn't take it. Oh, look, I understand that not everybody who goes into a certain field necessarily has all of the skills and attributes that you may need in that field. Comes up all the time with things like, oh, folks in construction, you're really, really good at building stuff. You're good at solving problems. You're good at putting pieces together. You're good at cutting at the right length, etc. Doesn't necessarily mean that you are good at running a construction business, handling the calls, filing the taxes, preparing the bids, etc., etc. I can see how people who really like lab work could end up in a job like this, and that having that skill in working in a lab does not necessarily translate to having communication skills. But I swear, I don't know how you end up as an expert witness. Why didn't you go into research or something like that if you don't want to be a good communicator? Go into a research lab. There's lots of labs out there you can work in. You don't have to work in the forensic lab because you really need communication skills in the forensic lab. I don't have anything personal against Ms. Hanley or any beef with her. By and large, again, I think much of her data is helpful to the defense. But it's really like pulling teeth, isn't it? It's just painful to watch. I don't know why it would be so hard to recognize an evidence bag that you looked at and you yourself took photos of and you also wrote about in your notes, just because somebody else at the lab is who took the picture of that bag. Just so very careful and slow with everything. I appreciate care with stating conclusions and methods and things like that. Precision is very important. And it's very possible for this type of work, the conclusions drawn, to be overstated. I appreciate things like she's very careful to say it's consistent with that item, meaning it could have originated from that item or from another item with the same characteristics. Because plenty of people would come in and say that's a match, like they did in Delphi. Come in and say that's a match. The science consensus at this point, you cannot say it's a match. You cannot exclude the entire universe of firearms, by looking at comparing marks on this bullet from marks on that one. You cannot definitively exclude the whole universe of firearms. But lots of people will go into court and say, yeah, that matched. So I appreciate being very, very careful with the language and what it actually substantiates. But this might be a little excessive. You're maybe being a little bit careful about a photograph of an evidence bag from your own lab. I don't know why, Jackson, just use the ones that are already in evidence. They're already in evidence. Lally put them all in. Just go get them. Use those. Show her those. There's a bag. There's a photo of the bag of 7-12. Lally got it in. Show her that. It will be much easier than trying to drag her into acknowledging that it is the same bag. It's just a bridge too far for a witness.
Jurors, sometimes we're at sidebar in an effort to try and speed things up. So even though we take your time that way, this should make things move a little easier. So you can cut that from back.
Thank you. Ms. Hanley, I was asking you previously, we already looked at what's been marked for identification as triple G. I was asking you about what has now been marked as triple H.
CG, she's been doing this almost 20 years. She's a 40-year-old woman.
A trooper's name in the middle of that evidence bag.
She's been doing this almost 20 years. Yeah, she is a professional witness.
Yes, I do.
Is that Buchanan?
That is part of the job of being a crime lab
like
analyst.
it says that, yeah.
Okay, and just so we're clear, that bag is associated with 7-12 of your analysis. The item 7-12, correct?
He went and got the exhibit.
Yes, again, I didn't take this photo, but I have,
I
yeah.
realize that. It says 7-12
Yeah.
right on the photo. doesn't it?
Yes, yeah.
Okay, that's all I need. Taking a look at what's been marked as triple I for identification. Do you see a name associated with that evidence bag?
Yes.
What name is
She's
that?
in the ballpark of 40. I did the math. She started working at the lab in 2007, if that was after college
It's actually
graduation.
a little hard to read.
Doing it for 18 years.
It looks like it says, it could say Trooper Proctor.
Okay,
Graduate
and that is
21,
associated with
22.
7-14.
You're like 39 or 40.
Fourth category, correct?
This, it is labeled as, excuse me, 7-14.
Thank you. And finally, does that, which has been marked as, for identification at least, as triple J, does that appear to be the contents of that bag, which is a single PC class in 7-14?
This appears to be the photo that the analyst prior to me took of item 7-14.
And that would be analyst Valier.
Correct.
You see her initials there.
Yes.
Okay, thank you. So the four categories, just so we're clear and we can stop using so many numbers because they can get confusing. 3-2 is the cup, right?
Yes,
3-3 is the bumper glass, correct?
that is correct.
7-12 is the Buchanan glass, correct? You just looked at it.
Yes,
Okay. 7-14 is the Proctor glass, the single piece, correct?
correct.
So when I make reference to those items by those names, you'll know what I'm talking about.
Yeah.
Just
yes.
accept the naming
No,
convention.
I just, I'm just used to referring to them to the item numbers, but I will try to stay with you.
My brain will melt if we continue that way.
Can she do it both, Mr. Jackson?
Sure. Any way that you wish. I have another document that I would like to approach with, if I could, with court permission.
Okay.
Thank you. I'd like you to take a look at that. You got a copy of this? Have you ever seen that before, or a variation of it?
Yes.
Okay, saw it last year, correct, or something close to it last year?
Yeah, it looks consistent.
Okay,
I'm sorry, may we approach on that?
Okay. If there are
Another
any others,
sidebar.
Mr. Jackson, why don't we bring all the,
this is it.
Yeah, guys, I mean, about 40 years old. What'd she say yesterday? I'll find that. Pretty sure she said 2007, and that was after she got her bachelor's in some like chemistry, something like that. In 2008, she started at the crime lab. Sorry about that. My bad. So she's been there for 17 years. 17 years at the crime lab as she's been doing this. I didn't write down all of her education, but I want to say it was some kind of chemistry field. Yeah, guys, she looks great. She looks great for 40. Didn't write it down last year either. So I was going back through last year's testimony just because I was trying to kind of reconcile it. You know, it's the same thing kind of we saw with HeartNet. You can have the same data, and just depending on how it's presented, it gets very confusing. So what I'm looking for here is that we know that she put the bumper glass, or the one piece of bumper glass, under the grim. And so that's the refraction index measurement. You wouldn't do that in a vacuum, though. Like, in and of itself, that information doesn't tell you anything. You would do that to compare it with something else that you have grim data for. But she didn't testify here in this case about any molecular type of comparison. You know, any grim result, and how that compared from the bumper sprinkles to the other items. We have no physical match with the cup or with 714, but we did have, is that what she used the grim for? It was consistent with that piece of glass that Proctor found, but the piece of glass that Proctor found, 7-14, it didn't physically match the cup. Was it compared to the cup under the grim? I don't know. I don't know if it was. And like, it shouldn't be that hard to find, right? If you want me to understand what, based on what testing, we should know that, shouldn't we?
So I think I gave somebody the copy that I was using. I need a copy.
If I may approach?
Yes. Thank you. All right, so let's mark this first for identification.
Happy to.
So we have, 3.3, the cup is consistent with, no. 3.3 is the taillight sprinkles, the bumper sprinkles. 3.3 is the bumper sprinkles, consistent in the grim properties. 14, the glass that Proctor found. But then what? Like, that's...
Ms. Hanley, if I could ask you very briefly, I want to go through this.
Clear it up, Alan.
With you for a moment.
Clear it up for us.
Do you recognize something on the left, looking at the first category? Do you see 3-2?
Yes.
How is that described?
It's described as a cup.
Okay, and you see that there's a photographic representation of the cup just above it, correct?
It looks consistent with...
Okay. Moving to the second category. What category is that?
It's item 3-3.
And 3-3, first of all, there's a photograph above it. Do you see that?
Yes.
It appears to be of a bumper, correct?
Yes.
You didn't take that picture.
I did not.
Okay, let's look down beneath it. You indicated that there were 5 items in 3-3, A, B, C, D, and E, correct?
Correct.
Do you see A, B, C, D, and E represented in that category on this chart?
I do see A, B, C, D, E categorized, yes.
Great. Under A, you previously testified that the bumper glass sub A in 3-3 did not match the cup, correct?
That's correct.
Did not match anything in 7-12?
Sorry, just give me one moment. That's correct.
And did not match anything in 7-14?
That's correct.
And you see those represented by sort of the international symbol for negative, correct? A circle with a line through it. Correct?
Yes.
Okay. Under subcategory B, glass B, or item 3-3B, did not match the cup, did not match 7-12, did not match 7-14.
That's correct.
Is that accurately represented on the chart?
Yes.
Finally, with regard to E as an echo in that same item, 3-3, you see that there is a green indication that glass recovered by Proctor does match or did match in your analysis, or was consistent with the item in 7-14, correct?
It was consistent microscopically and instrumentally.
Does that accurately reflect that finding on this chalk?
Maybe not if you said match.
Yes.
Okay, now turning to category 3. There were 9 pieces of glass that you looked at, correct?
Correct.
A through F, I, K, and L. Is that right?
If I could just reference my report to make sure.
Of course.
Yes, those are the correct letters.
And A, B, C, D, F, and K all matched the cup, correct?
Again, I would just need to confirm with my report.
Take your time.
Yes, so A, B, C, D, F, and K
All matched the cup.
had a physical match to 3-2, the cup.
Is that accurately represented on this chart? With green.
Yes.
And E is an echo, I is in India, and I think that's L is in Lima, did not match the cup, correct?
That's correct.
Okay, is that accurately represented on this chart?
Yes.
And finally, the last category, 7-14, that is the single piece of glass that was recovered by Trooper Proctor. That did not match the cup, and it did not match anything in 7-12, correct? And if you need to check your notes, feel free.
Yes, that's correct.
Is that accurately represented on the chart?
Yes.
Your Honor, I would move for the admission with the amendment that the court indicated at sidebar of triple K.
Okay, I'm going to allow it in.
205.
205?
Oh, it's in as a regular exhibit and not as a demonstrative?
Yeah.
Okay, great.
Your Honor, the court indicated that it would like to see us before anything's published to the jurors.
Hey, come on over for a second. Actually, have those have those been done?
It has been done, and
Okay.
I was going to explain at sidebar.
All right, then come on over.
So she required some type of redaction to the chalk. Remember they brought this up pre-trial, like this, this has been out there. They've known since pre-trial they wanted to use it. But here we are having sidebars talk about, needing to redact and so forth. Really kind of makes you wonder sometimes what the purpose is of raising things pre-trial in this courtroom at all, because you don't get any answers in a timely fashion. It's interesting to me. It's got an exhibit number 205. The way they've been handling demonstratives so far is they get marked for identification, and they can be published to the jury and shown during the witness's testimony, because that's what a demonstrative is for. It's there to help the witness who is testifying explain, clarify, illustrate their testimony for the jury to make it easier to understand, but it is not in and of itself evidence, so it doesn't go back into the jury room. They've marked this one as an exhibit, and that suggests to me they are not treating it as a demonstrative. It is same evidence as all the other evidence. It will go back to the jury room. Odd and unusual and different, but I don't know. Her Eminence is allowing it.
205.
Thank you. Request permission to publish.
Yes.
Ms. Hanley, you see the chalk that's been, or actually what's been marked as Exhibit 205 in evidence on the screen?
Yes.
Is that consistent with what you and I were just talking about at the witness stand?
Yes.
If you'll direct your attention to the screen on the right, just because it's a little easier and I think the laser pointer shows up a little better. You see the 4 categories represented in these
turn the captions off.
Exhibit?
Yes.
Okay, so 3-2, I'm going to go over it very quickly one more time, just visually. 3-2 on the left is the cup, correct?
Yes.
3-3 represents the 5 pieces of glass of what we call the bumper glass, A, B, C, D, and E, correct?
Yes.
7-12 is the 9 pieces of glass recovered by Trooper Buchanan at 34 Fairview, correct?
Yes.
And finally, 7-14 is the glass, single piece of glass recovered by Trooper Proctor, correct?
Yes.
Taking these one by one, just so everybody see. Taking these one by one, looking at starting with the bumper glass, category 2. Piece A did not match the cup, anything in 7-12 or anything in 7-14, correct?
That's correct.
Piece B did not match the cup, did not match anything in 7-12, did not match anything in 7-14, correct?
That's correct.
And moving over to category 3, there were some matches in these 9 items, 6 of them, A, B, C, D, F, and K, correct?
Yes.
But what those matched, Ms. Hanley, with a cup, nothing on the bumper, correct?
Correct.
And what didn't match the cup were E, I, and L. I, and L. Is that right?
That's correct.
Moving back to category 2, however, there was one thing, item E, that did match something in this series of categories. Isn't that right?
Not a physical match, but instrumentally there was consistency.
All right. And this is an item, the only piece of bumper glass, the only piece of bumper glass to match anything else in your analysis. Matched what? Or was consistent with what?
Item 3-3, piece E was consistent in physical and instrumental properties with the sample that I took from item 7-14.
Which is the single piece of glass recovered by Michael Proctor, correct?
Yes.
But not a single piece of glass, nothing that you analyzed coming from that bumper matched the cup. Did it? Nothing.
Physical match comparison, there was no physical match comparison to the cup.
She deliberately, perhaps, did not do
done
the
with this, Mr.
instrumental
Jackson?
comparison.
We can take this down, Your Honor.
Why'd you not do the instrumental comparison? We're not going to ask because we don't know the answer. But why didn't you do an instrumental comparison with the cup?
Your Honor, that's all I have. Thank you.
Mr. Lally?
The question itself goes to Bowden, doesn't it? Why didn't you just check and see if this matched the cup?
Now, Ms. Hanley, as far as you were asked some questions on cross-examination about biological pieces or tissue or things being on the glass, and you referenced that that was done in another unit, correct?
Yes, if that type of examination was needed, that would be done in a different unit.
Objection, Your Honor.
I'm going to allow that, but next question.
Which unit would that be conducted in?
Objection.
So the objection sustained. You need more, Mr. Lally, before you move on.
Now, as far as the chalk that you were just presented, as far as the 4 photographs that were depicted in there, have you ever seen any of those 4 photographs before?
No.
Do you know specifically who or where any of the items 3-2, 3-3, 7-12, or 7-4 were physically recovered from?
I just have the description that's put in the LIMS system when it's submitted to the lab.
And do you know that 3-2, the drinking glass, was recovered by the Canton Police Department on January 29th, 2022?
Objection.
Sustained.
Do you know that item 3-3, the bumper glass, was recovered by Ms. Maureen Hartnett from your lab on February 1st, 2022?
Sustained.
Do you know that each of the 4 items were recovered by different people on different dates at different locations?
No reproach.
Yes.
Now he's just being improper. He already knows. You already know. The problem is she's already answered your question. She says she doesn't have personal knowledge. She just have what's in the notes. So you don't get to use her as an opportunity to try to riff on stuff she doesn't know. That's what your closing argument is for. Nice to see Judge Bev applying the same rule to Mr. Lally that she would apply to Mr. Jackson if the shoe were on the other foot. I don't know that her not having seen the photos on the chalk before really does anything to undermine the chalk at all. Who cares what the photos were? The photos don't matter. The photos are just here to clarify and help us keep track of what we're talking about. But the point of it was that analysis, wasn't it? It was that final conclusion that we stated explicitly: nothing from the bumper matches the cup. That was the point of the chalk. Photo doesn't matter.
Ms. Hanley, from your conclusions that you testified about before, you found that the item 3-2, the drinking glass, was consistent with 6 different pieces from item 7-12 that were found in the roadway outside of 34 Fairview Road, correct?
That's correct.
And you also found that piece E from item 3-3, the bumper glass, was consistent with the single piece from item 7-14 that was found in the roadway outside of 34 Fairview Road. Is that correct?
Yes, that's correct.
And you also found that items from 7-18.18, the debris from Mr. O'Keefe's clothing, were consistent with the item 3-1, the taillight housing, correct?
Yes, Your Honor.
You on the scope.
Now, as far as the chalk that you were presented with on cross-examination, was there anything in there about item 7-18.18 or item 3-1, either the taillight housing or the debris from Mr. O'Keefe's clothing?
No, there was not.
Nothing further.
Anything?
Very briefly. So in sum, not a single piece of glass on that bumper could be connected to that cup, correct?
There was no physical match to the pieces that I compared for physical match from the bumper. There was no physical match to the glass cup 3-2.
Thank you. So another way of saying that is not a single piece of glass that you analyzed on that bumper matched that cup, correct?
Sustained.
But the one piece of glass that did match something came from the same source, it was consistent with coming from the same source as the single piece of glass recovered on the possession of or bagged by Trooper Michael Proctor, correct?
It was consistent with item 7-14.
That's all.
All right, Ms. Hanley, you are all set. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch.
What? Because we got to have scheduling. Are we done for the day? We don't get to start with Dr. Welcher. We having a little break today? Is that a question that just screams, why didn't you test the bumper glass against the cup instrumentally? Did you not want the answer to the question? Guys, we've talked a fair amount. Get the mute. We've talked a fair amount about the questions that you just don't ask. They're too high risk. It came up in Delphi. We have all of these eyewitnesses on the trail the day the girls disappeared. They see somebody, they say it's Bridge Guy. They're describing Bridge Guy, describing their interactions with Bridge Guy. And not a single person in the course of this trial asks any one of these eyewitnesses, here's this gentleman sitting over here at the defense table named Richard Allen. Is he the man you saw? When like the key issue in the entire case is Richard Allen Bridge Guy? And nobody would ask the question. Why? Because you can't. It's a case destroyer, one way or the other. Somebody's case is getting demolished by the answer to that question. So it's too high risk for either side to ask in an adversarial system. Same reason why you don't ask Officer Barrows, Nicholas Barrows from the Dighton Police Department, here's the photograph of that taillight in the Canton Police Department sallyport. Is that consistent with what you saw when you responded to Karen's parents' house in Dighton? Nobody will ask that question, because if he says, yes, it's consistent, the defense has just blown the case and they've given up that advantage they had with his answer of it's cracked. You can use that to your advantage. It's cracked. He just said cracked. He didn't say broken and missing pieces. He just said cracked. But if he says, yes, that's what it looked like, that argument is blown out of the water. If he says, no, that's not what it looked like.
Right, so jurors, I know you don't like it when we're at sidebar. We don't like it when we're at sidebar, but I can tell you that after speaking to the lawyers now, we're ahead of schedule. And they've worked very hard to get us to this point where we're ahead of schedule so that tomorrow, instead of being a half a day, you have tomorrow off. So you have tomorrow and Friday, a good long weekend. It's very, very important. Do not discuss this case with anyone. Don't say a word about this case. Don't let anybody say anything to you about this case. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. I believe next week, except for Thursday, are full days every day. Watch your social media use this weekend as well. Have a great long weekend. We'll see you here Tuesday morning, ready to go.
Report, all right to the jury.
Next week, full days, except for Thursday are full days, but we got to assume no Monday either, right? Nobody's coming in for Memorial Day. Monday is Memorial Day, right? Sometimes I have to check my calendar to keep track of that kind of thing. I don't even have it on my calendar. But yeah, it is. It's the last Monday in May, the 26th. So it's Memorial Day. I'm assuming we're not coming back Monday either, but she didn't specifically spell that out. I will give it a minute to see if there's anything they're going to handle with the jury out of the courtroom. Really emphasizing that don't talk to anybody, don't say anything to anybody.
So no one needs to see me about anything? We get cleared up.
Put on the record that what's been marked for as actions that interviewed evidence 205. We're in the process of printing a new one. The one that actually went into evidence is not the one that we shared.
Okay.
Instructions. We'll get that printed and to you. I think before we leave. I think he's printing it now.
All right. I'd like it before we leave. So before you leave. So, all right. All right. Have a good weekend.
Thank you, board. All right.
It's not the one that should be in evidence, but it was shown to the jury. It was shown to the jury. How are we getting around that? I really hate this sloppy record keeping stuff. The appellate lawyer in me is absolutely cringing, because what I suspect they're going to do is they're going to go take that one that was published to the jury and the jury saw and it was marked as evidence, and they're going to just throw it away, and they're going to take this new one and they're going to put a tag on it and they're going to label it as 205. That's what I suspect they're going to do, and I hate that from the standpoint of the appellate attorney, because that's not what the jury saw. The jury saw the one that is in evidence. So I hope at a bare minimum there is some record of what was actually shown to the jury, that it's retained, labeled in some way, marked in some way, identified. I don't know if an appeal issue is going to turn on this. Seems unlikely, but you really just never know. You really don't. A lot of stuff like this comes up in courtrooms, just very, very sloppy with the identifications and the documentation. You see it a lot with digital evidence, because somebody will have like a thumb drive and it'll have a whole bunch of different items on it. You know, a bunch of, say it's got 5 videos, only 1 or 2 of them gets admitted into evidence, but the thumb drive itself is in evidence. And so then what happens with the rest of it? Somebody is getting into the thumb drive and deleting it. Sometimes it has to be redacted. It's in evidence, but you're going in the thumb drive and redacting it. You play only certain portions of it for the jury, but or only certain portions are admitted, but the entire video file is on the exhibit. Like, it gets extremely super messy, and I just hate that from a clarity standpoint. This is not how we make a record. I don't care for that. Well, we're ahead of time, aren't we? Ahead of schedule. We were so far ahead that you get to take tomorrow off too. Huh. Sounds like a great weekend at the Cape, doesn't it? Good weekend to be at the Cape. What's the weather going to be like? Oh, it's unfortunately not the best day. Rain on Thursday, rain on Friday, rain on Saturday, but then Sunday and Monday clearing and starting to get warm all the way up to a nice high of 64 degrees on Monday. Well, I guess you get what you get in the early season, but not really that bad. I was talking when they came back, you know, the questions that you don't ask. It's the same thing with Barrows. Somebody's case is getting destroyed if you ask that question. So nobody will ask the question. They don't have the incentive to ask it. If Barrows says, no, the taillight didn't look like that, the Commonwealth, you're done. That means it changed condition when it was in the possession of the police, of the investigators, and that means they framed Karen Reed. He says, yes, that's what it looked like. You're going to have a lot harder time selling this Karen Reed was framed theory to the jury defense. So nobody will ask the question. I don't know why did you not instrumentally test the bumper sprinkles and compare them to the cup, when the only clear and obvious inference from the glass pieces being present there at all under the Commonwealth's theory of the case is that they came from the cup? I don't know if that question is quite on that level, but it's a similar kind of idea, isn't it? If you don't want an answer, maybe you already suspect you know the answer, then maybe you just don't ask. This is the kind of area too I would love to know. Are there communications back and forth between the lab and the investigators? That is not uncommon, that they'll do some preliminary testing. They'll make preliminary findings. They'll contact the investigators. They'll discuss it, and they'll find out, what do you want me to do with it now? I would love to know if there was any kind of conversation with the prosecutors or with the investigators Okay, preliminarily, I've done this physical match comparison, and I don't match those bumper glass pieces to the cup. Do you want me to go ahead and proceed with a microscopic or instrumental examination? Sure would love to know the answer, because why wouldn't you? Why wouldn't you do that? Wouldn't that be an obvious thing if we're trying to attribute all these different pieces of glass to the source, and the only obvious source of any of it is that cup? Wouldn't we be trying to do that? Only things that got instrumentally compared to each other. The bumper glass with the Proctor glass. And then the taillight pieces. The taillight debris. Those are the only instrumental comparisons that I see that she did. Interesting selection. Very interesting selection. What do you guys think? How did that sit? Did that land with the jury at all? I really like how Mr. Jackson did what you need to do for the jury, which is just simplify it, make it very easy to understand the point, and preferably make it 1 point, maybe 2, but not like 100 points. There's not 100 points that need to be made out of this evidence. Really, with most witnesses, there's rarely like 100 points that the witness needs to make. There's just 1 or 2. So get there and make it. And the bottom line, yeah, it doesn't match the cup. The bumper glass doesn't match the cup. Now she's qualifying. There was no physical match comparison. Does that just scream, I didn't do instrumental comparison? I didn't do microscopic comparison? It kind of seems like it does, because you've talked about those things and you're emphasizing, well, it's only this one, only this one analysis that I did. And it didn't pass that analysis. Why would you not go on and then look at it instrumentally? I would imagine it's pretty common if you're going out and collecting a whole bunch of tiny shards of busted glass, as one often gets with a broken cup or something like that. Oh man, anybody in where's my food and bev folks? Where's my waiters? Where's my bartenders? How many times have you dropped a glass, shatters? I would expect that probably it's pretty common to not be able to physically match up a lot of those shards, because that is a very intricate puzzle. And, did you get every single piece and so on and so forth? I would expect physical match would probably, not having a physical match would be pretty common. So wouldn't it make more sense to rely on the microscopic and the instrumental to identify if these are the same glass? Like, wouldn't it almost seems like that would be the go-to? Why wouldn't that be the default if we want to know if these came from the same source? I don't know. To me, that really screams. It tells me you didn't want an answer to that question. And if you didn't want an answer to that question, it's because you were afraid of the answer. And if you had confidence in the provenance of these materials, you wouldn't be afraid of that answer. You should not be afraid of the answer. Do the bumper sprinkles instrumentally and microscopically match the cup? Because the Commonwealth's going to be trying to tell us it came from the cup. Why didn't you corroborate that? Because you're afraid of the answer. Why would you be afraid of the answer? Because you already freaking know it didn't. You already know where the bumper sprinkles came from, and you know the bumper sprinkles didn't come from the cup. So you don't want that analysis. That's why they didn't ask. Oh, I would love to have any conversations between the lab and the witness. I would love to know if they had a little chit chat. Did the physical match? Couldn't find anything. What do you want me to do next? Oh, just compare these ones. That'll be good. Not uncommon at all to have that type of conversation. Well, this was not what I thought we were getting today. Andrea's prediction, big fail, fall on its face. I thought we were going to get Welcher. No Welcher. We got Wolf and we got the rest of Hanley. Wolf had, he was a character. Definitely a character. Just a pro tip for next time. Don't talk about putting your fingers through brains. Okay. It's just not, it just doesn't sit well with people who aren't in the habit of putting their fingers through brains. It's not maybe the best way to describe the softness of the brain. You could find another analogy. Give me an equivalent item. Is it harder than a molded Jell-O? Is it harder than a rubber gasket? I don't know. Just give me something, but not you could put your finger through it. Just not maybe go there. But I was highly entertained by the trip down memory road with the cavemen. I'm fascinated with evolutionary theories for why we are the way that we are and stuff like that. I enjoyed that thoroughly. Have no idea what it has to do with the case, but there's something new from this trial all the time. I was coming in with my low expectations, thinking this is just going to be a refined version of trial 1.0. And instead, no, I get gifts like cavemen started adapting the fencing pose, the fencing posture as a way to scare off animals from eating them. My life will never be the same now that I know that. I love new knowledge. It's such a wonderful thing. Is that legit, guys? Those of you in the chat who know about this type of thing, you got some evolutionary biologists in there, perhaps. Does that hold water? Is that legit? That's a crazy idea for me. But I mean, I guess from an evolutionary standpoint, it makes as much sense as anything else. I just always kind of assumed it was, I don't know, damage to, particular parts of the brain that, trigger like the whole neuromuscular connection. But I don't know. I don't know the mechanism of it. But fascinating thing to learn. Learned a little bit about cavemen today. The cont-coup injury, bottom line, cont-coup injury, fell back. The ecchymosis is from, in his view, the basal skull fracture. All of this is very vanilla. Nothing extraordinary here. It's a classic linear basal skull fracture, is how he described it. We got a lot of technical stuff about subarachnoid and subdural and bleeding, and not clear exactly how significant John's brain injuries were. Thought he said it was not the kind of thing that would require intervention. I just sort of assumed anything like that would require intervention, but maybe he just meant surgery. I could see where he wouldn't necessarily surgically intervene, but I don't know. Definitely not. I'm definitely not a brain surgeon. So yeah, it's from a fall backward, but then he went and gave us some scenarios about how those types of falls backward can occur. Oh, you're shoveling the snow and you get drunk and you slip on the icy sidewalk and you fall back and you crack your head. That happens in Minnesota a lot, apparently. Yeah, on a sidewalk. On concrete. Yeah, I bet that does happen a lot. Black ice. We got bad black ice around here. I've already told my story about Crystal Mountain. Lost my edge on my backside on the snowboard, and just you're down like an instant. Oh, back of my head slammed into the ground. Wear a helmet, guys. Wear a helmet. If you don't think the helmet looks cool when you ski or snowboard, I guarantee you it looks a hell of a lot cooler than your brains splattered at the base of a tree. That's not a good look. It's not cute. Nobody thinks that's cute. Wear the helmet. And then, people can shovel snow, have a heart attack, fall backwards. Okay, so falling backwards, we've established falling backwards could cause this type of injury. He thinks it's not from an item, from like a weapon or something like that, because it was not a depressed fracture. And he says that's what you would expect. You would have a depressed skull fracture, which he didn't explain what that word means, but I interpret it and understand it to mean that part of the skull then is going to be like pushed inside the interior of the skull. I got to get my banner off. He didn't spell that out specifically, but that's kind of how I would understand. So the brain swelling would not have caused the skull fractures. Impossible to know if he became immediately unconscious, but his injuries were severe, and it's probable that he quickly lost his ability to engage in functional activities, which he described as things like getting up or calling for help. So you would not be able to do that type of thing very quickly, but sometimes the body can still move. The cortex gets separated from the brainstem. That's when we talked about those the caveman stories and the autonomic movements that you can make, but those are not conscious. So in his opinion, John would not have died immediately. Very few head injuries cause immediate death. Now some more, thanks for getting us demonetized, everybody, Dr. Wolf, because we're talking about driving a knife through the brainstem or shooting through the brainstem. That would cause immediate death. The brainstem controls the internal life processes of the body. So yeah, the brainstem gets messed up. The body is not going to function. But the upper level stuff, if the brainstem remains intact, then yeah, possible you could stay alive potentially indefinitely. And that's how you end up with people in long-term vegetative states. And so usually what causes death is the swelling of the brain that decreases the blood flow into the brain. It can, cause pressure up against the skull, stuff like that. That results in death of parts of the brain. And that's how people die from a non-brainstem type of brain injury, but it takes time. It is not instantaneous. I don't know if there's any this is totally apropos of nothing, but he's talking about, he had mentioned like arterial bleeds in the brain. I don't know anything about I'm just thinking about like an aorta. Aorta is obviously a major blood vessel. You can bleed out very quickly, if your aorta is ruptured. Is there anything in the brain, any type of blood flow, like structure in the brain that could cause like a rapid internal bleed out in the brain? I don't know. Just something I wondered. So people do die a lot from a linear basal skull fracture. 67% of his patients, 2/3 of them, but it takes days or weeks. And then we got the raccoon eyes. It normally takes 24 to 48 hours to develop, but it has been noted in 1 to 3 hours. Here's something that might be worth tracking. If I'm the defense, a paralegal, one of the assistants, something like that, I'm on the defense team. One of the things I might be tracking are what are the kind of extraordinary circumstances that are present in this case. They're not ruled out. They're not impossible, but it's just, this would be a rare circumstance. Exactly how many of those are there to get to the Commonwealth's theory being the case? How many car accidents have an impact and result in death, but have no visible bruise on the body? How many of those are there? That's going to be extraordinary. Impossible. I don't know if we're going to say that, but it seems like that's going to be the vast, overwhelming minority. How many vehicle accidents don't show up in the black box? In some of the black box data, they don't show a hard acceleration, a sudden stop, a sudden turn, something like that that's going to be picked up in black box data. On a modern vehicle like this 2021 Lexus LX 570, I would think that's also going to be a minority. Not many, you know, I mean, it's not impossible. It could certainly happen, but you would think it wouldn't be many. Now we have the ecchymosis that's developed in less than the normal 24 to 48 hours. Okay, it can be this early, but that's going to be a rare circumstance. And yet, lo and behold, that rare circumstance seems to be present here. That might be an interesting way, an interesting lens to look at this case through, is how many extraordinary circumstances do you have to accept as having happened all in this case to believe the Commonwealth's theory? Kind of seems like a lot. Just might be a way to look at it. We talked about the contusions blossoming. I understand. It's normal medical term, but just maybe not the best one for court. And you got to use technical language sometimes, but is blossom a technical term, or is this a descriptive term that has been adopted in medicine to describe a process? Just say it can grow, it can get bigger, you know. And maybe that's just me, you know, maybe that's not something that's going to seem inapposite to other people. Talking about bruises on the brain, but then also blossoming flowers. A little bit of a black humor, black kind of comparison. But they can grow, bruises can grow. He talked about then the other main reason why you die from the brain injury besides the swelling is because if there's a major vessel that's affected, that can lead to an infarction, which is a stroke. So you can have a stroke as a result of that. Otherwise, it's the brain swelling. We have this complication of the hypothermia. So he describes that it starts at 95-degree core temperature, is very mild. I feel like it would take me no time at all to get to 95-degree core temperature because my resting temperature is low. If the 98.6 is the average, mine is like 96.8. So I feel like that would take me no time at all to get to that. I don't know. That's very mild, but then below 82 degrees, you have severe hypothermia, and then below 80 degrees, you will probably die. So if someone is hypothermic, you have to warm them up in order to evaluate their status. I'm just a little bit baffled how we distinguish between a person who is found with no signs of life and is 80 degrees. Is it just because of the environment, because they were outside, that we think maybe this person is alive but hypothermic versus this person is dead and their body has cooled? Is it because there would be corresponding rigor mortis by the time the body reaches 80 degrees, by the time it's cooled enough to reach that point? Is it going to be stiff? I don't know. Maybe that would make sense to me, but it's just something about this that's kind of stood out to me because we don't know how long John was dead. We don't even know if he was dead or just, in the early process of dying. We don't know when that process started. It's just, it's so complicated by the weather conditions and just not having anything that we could really hang our hats on, as far as I can tell. To say John was 80, how much of John being 80 degrees was because he had died and how much of it is because he had been outside in the cold? I don't know. Seems like it would be helpful to know. Mr. Alessi kept it very simple as well. He's not a forensic pathologist. He doesn't do that. He does see more brains than the forensic pathologists do, though. That's a guy who thinks highly of himself, doesn't he? He knows more about the brains than the forensic pathologist. Well, but maybe living brains. Maybe living brains. Maybe not so much dead brains. He did concede that. And then the ecchymosis, unrelated to the laceration on the eyelid, completely different injury mechanism, unrelated to anything he had been describing as far as the Coup-contrecoup injury. So nothing here is ruled out. John got punched in the face, fell on his back, smacked his head, as is not especially uncommon in a fight type of situation. And you would probably see, I mean, you see this injury, you see this kind of injury, hold up the medical study, even in a boxing ring where the floor is made, you know, to have a little bit of give. It can happen. At least the brain injury part, probably not the laceration and the fracture and so forth. But at least the brain injury, that same movement, yeah, it's pretty common. Pretty common if you fall back, hit your head. But nothing on it has ruled out the cause of falling back and hitting his head. He's shed no light on that. And so Alessi has pointed squarely at this laceration on the right upper eyelid. Maybe it's that. Maybe it's that, because I don't think that's probably a car accident injury either. Probably not. It would not be typical. I don't think many people are getting hit and projected on their eyelid by a motor vehicle. But we'll have to see what Dr. Welcher has to say. Then we got to Hanley, and we struggled. My God, it was quite painful. I understand. I understand people have different skills, but it is a little bit painful to get through. But the bottom line was summed up for us very nicely, I think, by Mr. Jackson. Let's just get it. Let's just get it all clarified. The bumper sprinkles match the piece of glass that Proctor found. Yuri's glass that he found matched the cup. But the bumper sprinkles did not match the cup. And so then the only instrumental analysis, microscopic and instrumental analysis that was done between the piece of the bumper glass and the Proctor glass. And then the plastic shards that were recovered from the clothing and the plastic taillight piece. All of this stuff is in Proctor's possession, guys. To me, it might even be funny, you know, if you're a cop and you're having fun planting some evidence, you broke off the piece of plastic, and I mean, it doesn't break clean, like it shatters, plastic shatters. So yeah, you might have some little pieces, go and wipe that up with his shirt. That'd be hilarious. Wouldn't that be funny? I could see something like that. All of this stuff in Proctor and Buchanan's possession, not secured the way that you would want it to be able to rule out being able to ask these types of questions about the state of the evidence anyway. And remember, guys, this is the care being exercised for the death investigation of a fellow law enforcement officer. This isn't just any random Joe Schmo that they didn't care about ruling out those types of inferences through proper evidence handling and documentation. This was a fellow officer to whom they gave this care. Really does seem to say a lot to me. So that's what we had today. Not too much of a recap, but that was really the bottom line. We are ahead of schedule, guys. We're assured by the lawyers we're ahead of schedule, so we're not coming back tomorrow. Originally it was going to be a half day, but now no court tomorrow. Next week, all full days except for Thursday. I see that she did tell the jury, see you on Tuesday. So Memorial Day has been acknowledged. Guys, we got a long weekend. My goodness, Thursday, Friday, Saturday, Sunday, Monday, 5 whole days off. I don't even know what I'm going to do with myself. What am I going to do with myself? How much baseball is there to watch over that weekend? How much baseball can I watch? Let's see. Thursday, Friday, Saturday, Sunday, no game on Monday. That's not too bad. That's not too bad. We got a Taiwan Walker start tonight against Colorado. God, Colorado. Good Lord. I didn't realize how bad it was. Jeff pointed it out to me. 8-40. Oh my God. I feel really bad for, if anybody in the chat is a Colorado Rockies fan, you have my deepest sympathies right now. On the other hand, you know, last year, for example, watching the Phillies, they had the best record in baseball for like a huge chunk of the season. And then you watch them kind of spiral down after the All-Star break. Sometimes it's a kindness to have your low expectations set really early on in the season. So you're not going to get disappointed if you don't end up in a pennant race. You've already managed your expectations. Some of us aren't so fortunate, guys. 5 whole days off. Hey, we'll be back. We'll be back on Tuesday. Absolutely. Tuesday, Wednesday, and then it sounds like a half day on Thursday again. And then Friday. Well, guys, let's see where we're at. We've got some new members now, but does your mom deny it? Is a YouTube member. Welcome to the channel. Shite Show Supervisor. Welcome to the channel to you as well. Gary Burnett. Andrea, I'm wondering with this morning, what are the chances the Commonwealth is trying to run out the clock to give Welcher more time given the court schedule? Long weekend. Hey, not a bad prediction, huh? Not a bad prediction. We bring on the slowest talking witness in the history of witnesses, and then we repeat everything. We make sure we identify the instruments for the 3rd time. Come back after taking the witness out of order. We got to revisit it. Break for lunch. Got to come back after lunch and revisit it too, because it was extremely critical for the 2 times they used it. Not the times they didn't. Don't think about those times they didn't use it or why that might be. Hey, I think this is not a bad theory at all. Not a bad theory at all. Buy some more time for this guy. He's kind of limited, at least certainly in his direct, with what he can change from what has already been disclosed from the defense. I mean, he really can't. He really can't. There's nothing that has been presented yet that he can rebut. But he's also received the defense materials, including that ARCA stuff that was just disclosed on May the 7th. So he's had 14 days as of today. 2 full weeks. We just bought him another 5. We bought him almost 33% again more time. A little over 33% more time. Not a bad theory, Gary. Not a bad theory at all. I like how you think. Prime Finder, would you anticipate the jurors' sidebar questions this morning will be part of the official record and part of the public record one day? Thanks. I would expect that. The juror's identity is not, but yes, this questioning at sidebar absolutely is part of the record. And it should be part of the public record. There's no reason why it wouldn't be. I routinely see this type of thing in appeals if there's an issue with the jury. Like I said, it happens far more often than you might like. It doesn't happen in every single case, but it doesn't surprise me if there's something that comes up that causes the jury to be questioned. It happens with that kind of frequency. And so, yes, it is always in the appeal record. It has to be in the appeal record because we got to be able to look at whether there's a serious problem with the jury here. Did the judge handle it correctly? That's a significant room for error, and it's one particularly, again, putting my appellate attorney hat on, I'm concerned about. I'm focused on it if I see something, because we have the potential for a double jeopardy issue. If the judge mishandled it in a way that led to like the jury being dismissed or something like that, we may have a double jeopardy issue. So very, very important for this stuff to be part of the record. No reason for it not to be part of the public record. It routinely is. Just the names, if they're using the names, shouldn't be, but that can be solved by redaction. So yes, to answer your question, I would expect we should be able to see that someday. The rural juror. Okay, crash daddies definitely get to talk about saving soldiers now if this guy gets to talk about how he just got out of brain surgery. I didn't mind his description of his day. I got to tell you, this is one of those philosophies that I don't always think it lands the same for everybody. Some people are going to listen to this doctor's testimony and they're going to think, what a guy, what a go-getter. He's got a work ethic. He's diligent. Look at how much he gets done. Some people might look at this doctor and think, you know, this is a lot and you're getting up really early and it just makes me maybe question whether you are putting the time and attention into each one of these very serious cases that's in front of you that they deserve. You might be trying to cram too much in. Sometimes overachieving can be a virtue, but sometimes it can be a vice. Sometimes it means you're taking on more than you can chew, and then you got to cut corners, etc. I don't know that, that's automatic idea anybody's going to jump to, but if you don't necessarily embrace the grind culture, this kind of attitude, got to be grinding all the time, always working, always productive, always doing something. No, we have to appreciate rest and recovery and, other aspects of life. Just part of what keep us sane and healthy and able to be our best when we're in there doing those important tasks. I do sometimes wonder about that, but yeah, I would think that the crash daddies should get the same amount of leeway to describe their average day, some of their experiences that have informed what they're going to tell the jury about, just like being in a trauma residency in Minnesota, in Minneapolis. Was it Minneapolis? I think it was Minneapolis. Has to do with your ability to evaluate the evidence in this case. They should have the same leeway. Liz, Heme Onk. Oh, this name, Heme Onk. Blood cancer? You do leukemia and stuff? I worked in the same hospital system as this man for many years. He's smart, but I'm sure people who worked with him have stories. I kind of assume that's the case for pretty much any surgeon. Brain surgeon, I would imagine, is kind of a very, very special breed. I hear stories about it's late in the day. Why can't I remember the word? The people that go and fix your joints and stuff like that. That surgeon, the guy that does your knee replacement and stuff like that. Somebody in chat, help me. What am I looking for? All I can think is osteopath. No, not the osteopath. The guy that is the guy that's doing your orthopedic. Thank you, chat. I love you, chat. You guys are the best. Thank you for that. I hear stories about orthopedic surgeons, relatively frequently, because I think probably there's a lot of them. A lot more probably demand for orthopedic surgery than there is for brain surgery. Seems like anymore, pretty much everybody's joints go bad at some point if you live long enough. But hopefully few of us will ever need a surgical brain intervention. So, I kind of always assume surgeons are a little bit of a special breed, but a brain surgeon, whole other animal entirely. I would be very intrigued to know kind of, I'm not asking for like the tea on this particular guy or anything like that, but just in general, like trends. Are there patterns? Are there like characteristics that you see in common with these different specialties? I would love like a personality test every medical specialty. Just see what you get. Like, it doesn't have to be like, I'm not talking about like MMPI or something like that. I just like the Big Five, for example, maybe would be interesting. Matthew D'Elia, Alessi's cross-examination of this guy is going to be better than Tyson Holyfield. Well, it was precise. It was not brutal. It was not, there were no fouls. No fouls. I have to imagine Alessi, the expert man. Okay. Alessi, who has worked with and cross-examined experts for one of the, largest and most preeminent law firms in the world. He has run into his fair share of arrogant experts, people that are inflated with their own self-importance. They think very highly of their own opinion. They don't necessarily limit that to their area of expertise, but sometimes just allow it to leak over into areas where perhaps they are not the experts they think they are. So I imagine Alessi would have a whole bag of tricks for dealing with experts like that. Ways of just, illustrating the foolishness, perhaps, of having that type of excessive self-regard. We should have humility as scientists, right? If we're engaging in a scientific process, which the jury trial ultimately, ideally should be, right? If it's a truth-finding function, what the jury should be doing is evaluating it in a scientific manner. Then you need to approach that with some humility about the limits of what you know, what you can know, what you think you know. But we did not get a Tyson Holyfield. We did not get a huge engagement here. Obviously very short. I'm going to give the win to Alessi because ultimately what this guy accomplished in his testimony isn't hurting the defense. John falling on his back and sustaining a brain injury and a laceration like you'd get if you slipped and fell on a sidewalk on the icy ground. I don't know that that's really hurting the defense's theory of the case here. Nobody has tied the pieces together with the frozen lawn. Nobody has tied that together. I think that Brennan is maybe just hoping to let that slip through. He's gonna equate what Dr. Wolf said about the sidewalk. You see this when somebody slips and falls on the sidewalk, or they're shoveling. What are they shoveling? Oh, yeah, that would be their driveway, or perhaps their sidewalk. Fall and crack your head. None of his descriptions have anything to do with falling on a lawn. So unless Welcher is going to go there, I think he might just be hoping to hang his hat on. Look, the meteorologist said the ground was frozen, and Dr. Wolf said you can fall backwards and crack your skull like this on frozen, on cold ground, cold, hard ground. But it's not really equivalent. So he didn't score a lot of points on the direct that I saw. And then Alessi had those key points that are pretty devastating. The main one, he's not a forensic pathologist, but yeah, he probably has seen more brains than forensic pathologists. I buy that. But you haven't explained the eyelid injury, and none of them have explained the eyelid injury. So if Jud Welcher doesn't explain the eyelid injury and how this was caused as part of the mechanism of this collision, then they don't have a complete explanation. And John's condition remains, as it kind of has always been, the key obstacle that the Commonwealth has to overcome if they want to convince anybody that Karen Reed hit him with a car. Cyarnus, jury questioned due to graphic images of skull. Possible, but that would be unusual. That would be unusual. And you could probably do that as a group. You would just, kick everybody out of the courtroom and be like, hey, jurors, we're going to look at the skull. Anybody have a problem with that? There's no real need that you would need to isolate the jurors from each other to talk to them about that. So possible, but I think it's unlikely because of that. Priya Rose, do you think Alessi has read all of the doctor's works? I bet he had. I bet he did. I bet he went through and read that guy's peer-reviewed articles as part of his prep. Nothing really in it to work with, but yes, I fully expect he did. And if there was something in there that was helpful, it would have come out. Sarita Banana, that gamma knife he speaks so proudly of using has been around since 1967. It's a commonly used tool. This guy glows neon with narcissism. Well, again, I don't hang out in hospitals and with a lot of medical professionals and stuff like that. But I certainly hear stories and things like that. And like I said, people definitely have their view of surgeons. There is a theory that the surgeons are higher in the so-called dark triad traits. Because you kind of have to have a very high self-regard to think, sure, I'll go ahead and cut into this person's skull and stick my finger in their brain and improve them because of that. You have to have a massive amount of confidence to even engage in this type of practice. But you also have to have a certain callousness, not being particularly sympathetic to, that's probably not the right word, but you can't be feeling for the patient. He's talking sort of gleefully about, yeah, we do brain surgery with the people awake a lot of the time. That's going to be really disturbing, I think, for most people that have a tendency to put yourself in the shoes of the other person when you know what's going on. And this person is like, hey, la la, and telling you a story. And meanwhile, you're sticking your finger through their brain. That's, I think, going to be disturbing for a lot of people. So you kind of necessarily need a little bit of low empathy and a little bit of high self-regard. So that's a theory. I've seen some sort of weak substantiation of that with, different studies and stuff, but nothing that's real hardcore. But it does make you wonder, doesn't it? Matthew Delia. Okay, so if the head injury is from hitting the ground, that leaves no other injury from a 6,000-pound SUV ramming into him. No, it doesn't. No, it doesn't. And this explanation that, well, it's a side swipe, this has never worked. If it's a side swipe, it still needs to hit the center of mass if it's going to move his body. Otherwise, it's just going to move whatever was hit in relation to the center of mass. So if it just hits his arm, what's that going to do? It's going to spin you, more than anything, might knock you over, but it's not going to project your whole center of mass across the lawn. So how did he end up there? They're going to have to explain that. Trooper Paul's pirouette and projection was the theory from the last trial. Is it going to be knocked him down and he walked over there and collapsed now? I don't know. Maybe it is. Maybe it is, but that's a problem with the mechanism here. And frankly, even the point of impact being the elbow, where's the bruise? At the very least, the bruise, if not the broken bones. It does leave a problem, doesn't it? If he didn't get hit in the skull, and that can be identified as the point of impact. The Marilyn Manson cases, Haas long to simplify testimony. Well, you might be waiting a long time with Dr. Wolf. A, how did Robert Alessi come to be involved in Karen Reed's defense? So I don't know any real specific information about who called who and when and stuff like that. But the general lore that I'm aware of, and chat can fill in the details if you guys are aware of any of these, But the general lore that I am aware of is that it was after the first trial. He was aware of the case and basically just volunteered to be involved, to help with it. And he's doing it pro bono. That's kind of the lore of the case. So saw the problems with it, and yeah, just stepped in. I don't know the mechanics of how that happened as far as who called who or whatever, but that's the general story that I have heard. Sarita Banana, folks haven't been getting injuries from sidewalks since Quaaludes were legal in the 60s or 70s, per what my mama told me. Yeah, Quaaludes. Quaaludes were like the big thing for a while. It was in the Cosby trial, and then suddenly it popped up in Johnny Depp. And we're like, wait, Quaaludes went out in the 80s, right? They stopped making the Quaaludes. Or correction. They did not stop making the Quaaludes, but I believe they stopped distributing them in the United States, leading to a black market for Quaaludes. Yeah. Lots of sidewalk injuries, guys. All kinds of ways to get injured on a sidewalk. Oh man, sidewalks can be lethal. You have the little, like the tree root that causes a little crack and a little uplift, and it doesn't even take very much before you're walking down the street like a normal person and you catch your toe on that little piece of sidewalk and down you go. And now your shoulder's broken. Now your skull is bashed into the ground. Yeah, sidewalks are pretty dangerous, guys. Kini Leva, did his CV have majored in general caveman studies? Where do you get that residency? Where do you do the residency in caveman twitching? Is there a lab somewhere where we get to sick a saber-toothed tiger on a unconscious caveman and see what happens? Sarita Banana, Charlie, my $200 a month chat GPT best friend has just finished up his deep research on this guy. I can confirm a second round of the Burgess show is to come. Interesting. Sounds like you've been out scraping some data from some sources. You have a theory about what's going to happen with Burgess. He's the one that they set up to come back for rebuttal. I don't know why you picked that guy, but they did. So, whatever ARCA did and whatever ARCA has to say about the problems with the Commonwealth's analysis seems like perhaps focuses in on the data that this guy was responsible for and his interpretation of it and the clock drift and all that stuff. So he's going to be the one that gets to come back and explain why it's all okay, do more testing, whatever. I don't know. Scott Keir. Hi, Andrea. 24-year medic here. Yes, the overwhelming majority of cardiac arrest hypothermia patients get warmed. You're not dead till you're warm and dead. So my question is, I guess, is the trigger for thinking this 80-degree person is hypothermic is just because of the fact that they were found outside in the cold? Because obviously, if you find somebody that's 80 degrees, but they're in a warm environment, we can assume they're cold because they're dead and they've been dead for long enough to reach 80 degrees. With the cold, how long could somebody potentially be outside in the cold, dead, before you'd realize this person is dead and there's no need to revive? Is there a point? Are you always going to revive the person that's found out in the cold with a low body temperature? Or would we look at, surely there's a point, right? There's decomp, probably no point in getting him warm. Okay. But is there some middle ground? I don't know. I'm just curious about that. Andrea McBurnett. True story. A family member got into a fight, striking the guy in front of a convenience store. He fell back, hitting his head on the concrete. Sadly, he passed away. My cousin was sentenced to 25 years to life. Sorry to hear that. This is sounds like it was probably a manslaughter. It would be hard to escalate that to a murder, but depends on the state, I guess, and the statute that you're going under. Yeah, this stuff happens. Stuff happens. You get the wrong shot, you fall back. The case that I read from North Carolina, just the first thing that pops up when you run a Google search. I don't even remember what I searched, but something like street fight, hit concrete, die. I don't know. Something like that. This is not particularly uncommon. So thanks for sharing that personal story with us. It is sad. But these things, they do happen. Mispronounced name. That's very clever. My MRI says I'm quadriplegic. My 15 minutes on the treadmill says neurologists can't predict clinical outcomes. That's an interesting point. Yeah, makes some sense. How often when you hear about things like severe, brain injuries, or like people going through circumstances that you would just expect that they wouldn't survive, or that they would be severely impaired as a result of them, or something like that, and they make sudden, miraculous, unexpected recoveries. I mean, it happens. Definitely happens. I don't know how often it is, but it's non-zero. So it makes sense to me that what you see and what the situation should be, according to your diet, your normal diagnostics and things like that, it may not play out in reality. And I think part of that is because the human is a very complex organism. It's a very complex system we have going on, this biological system, and all the different pieces and how they interact with each other. And there's protective responses, just all this stuff. Very complicated. To think that we understand all of it would be, I think, quite an overassumption. I think there's a lot that we don't know about the human body and human processes, and especially when it comes to things like synergistic effects and stuff like that. Makes sense to me. The clinical is not the same thing as the forensic. There's a reason why, for example, well, I guess that's a little bit different. I was going to say in psychology, the clinical folks generally cannot testify. You can't testify as like an expert in trial. You can testify as a lay person if you're subpoenaed and there's no privilege, or a privilege is waived or something like that. So, testify about what the person told you, but you can't go in and like offer your diagnosis of your own client. That's considered unethical. But I think part of that is because these are different. They're different tools and different approaches. You have a different objective. You're doing different things with the information that you're provided. So forensic pathology is a specialty for a reason. Hannah, what's your opinion on what happens next if Karen Reed acquitted? Do you think feds will reopen investigation, especially after new Higgins video, etc., or anything? Don't know. The whole federal investigation has always been such a big mystery. What are they looking at? Is it in fact, concluded? Is that legit information that was just passed to these two law enforcement folks and not to anybody else? It's not coming from the horse's mouth. It's the secondhand information. Does the investigation being concluded mean that the feds are done? Or are they just waiting to put together a grand jury? What is any of this stuff? What does it really mean? It's very hard to know because there's little to no transparency about the federal process. Don't know how much of this is political and priorities. There's a new administration now running the federal law enforcement system. They don't and are not required to have the same types of investigative or prosecution priorities as the previous administration. That could play a role. Don't know if it does, but it's possible. So just all these pieces that could come in. If it's a political decision that this is not a priority to pursue any further, then I don't know that this would change it. But if it was insufficient evidence for something specific, then maybe more evidence would change that. Maybe. I think the issue I've pointed out, I think a few times, is that when you're talking about prosecuting corruption, which is probably one of the better guesses about what a federal investigation here was all about, and it does explain why there seems to be some overlap between the feds investigating Sandra Birchmore and prosecuting Matthew Farwell, and then also getting interested in this investigation of Karen Reed that involves so many of the same personnel, the same Norfolk County District Attorney's Office, and so forth. Corruption seems like a logical thing to be investigating, but to prosecute corruption, you really need proof of the quid pro quo. You need proof of the benefit. And that's hard to do when your corruption is the old boy network, because nobody has to be told what to do. You don't have to be told what your role is. You don't have to be told, you got our back now, we'll have your back next time. It's understood. It's systemic. It's part of the problem. So they could have gotten tons of evidence about all kinds of shit these guys got up to. But if they can't tie it to benefits, it's not necessarily going to be something you can prosecute as corruption. So that's a possible limiting factor here as well. I don't know if Karen Reed is acquitted. The sad answer is that most of the time nothing happens. You go back and you try to rebuild your life because you can never get it back. You're never getting back the time. You're never getting back your reputation. You might make some more money back, but you're not getting back this money that you spent and this time that you could have had it invested in, getting returns and so forth. You're not getting any of that back. And just who you were before you were accused of something like this, you never get that back either. And so there's rarely any recourse for having been wrongfully prosecuted. Rarely. And you typically have to identify something real specific, some real specific wrongdoing, illegal activity, and so forth. They've got, inferences of some of that possibly here, but, solid evidence. No, there's, again, no smoking gun. There's no smoking gun, just little hints like bumper sprinkles that don't match. Things like that. Taillight video that's mysteriously disappeared and so forth. Not entirely sure what the statute of limitations is for a claim like that either. Statute of limitations for like a 1983 claim, a civil rights claim, it gets enormously complicated because it doesn't have its own statute of limitations. It derives the statute of limitations from whatever the equivalent state level tort statute of limitations is. So what is the tort that we're looking at here? It can get a little bit messy. So I don't know if that's even feasible still at this point. The reality is likely Karen goes back and tries to rebuild her life as best as she can. Gingy Probs. I believe Karen Reed is not guilty and possibly innocent, and general consensus seems to agree. But I want other point of views. Canton Confidential yesterday was so pro-Commonwealth, it made me wonder if I'm just in an echo chamber. Thoughts? I do think there's always a risk of being in a bubble and being in an echo chamber. We try to, not make our chat that. It's not the goal to be cultivating an echo chamber here. We like different opinions and different perspectives on things, and we like debate. I think that's how you get closer to determining what the truth is. But it's got to be done respectfully. Everybody's got to be able to respect everybody else's right to have a different viewpoint. And so, that's where things tend to devolve is things get nasty, things get, people start losing the debate. And so they get mad and start throwing personal attacks and stuff like that. It's hard to have a good debate on a particular issue. So I mean, I do. I think it's helpful to expose yourself to viewpoints that aren't necessarily the ones that you agree with, and then you can evaluate. Is that something I should give credit to or not? I see a lot of viewpoints that are in favor of the Commonwealth or pro Commonwealth, anti Karen Reid, as I think they sometimes get shorthanded. I rarely find points that I agree with in terms of what is the significance of evidence and what does it mean. Where I do sometimes, not that infrequently, agree with the anti-Karen Reid perspectives is how is it going to affect the jury? Because you can't know that. None of us can know that. And so if there's multiple ways for a thing to hit, multiple interpretations of it, one of which is consistent with guilt and one of which is consistent with innocence, we don't know how the jury is going to take that. So, as a predictive exercise, it's especially important, I think, to be getting outside of your own bubble and your own perspective and try to see things the way that the other side could see them. So I try to point that out in my analysis too. Like I've said many times, I think the strongest pieces of evidence against Karen Reid, the taillight, the CERT taillight, them having found it on January 29th, that's big. You've got to be able to undermine that, or a jury could very easily decide, look, all this other stuff is really messy. I can't make sense of it, but there's no other explanation for her taillight being there, but that she hit John. It's possible a jury could reach that conclusion. That to me is really probably the strongest evidence that they have. Is it enough for me? Absolutely not. Of course not. I mean, for me, the bottom line is look at John. Look at John. He was not hit by a car. Sorry. The guy's face is cut up. His nose is all red. He's got the little gash on the inside of his lip. I don't think we heard that in this trial. We heard that in the first trial. Maybe we'll hear it from the defense's forensic pathologist, but these are all things that look like fight injuries, the blood pattern on his clothing. This looks like a person that's been in a fight. Eye test alone is this guy was in a fight. This guy was not hit by a car. But that's just me. That's what seems significant to me, and I'm not the jury, So it's helpful to entertain a perspective where maybe that doesn't matter. Maybe we are willing to give the benefit of the doubt to a theory of how a car accident could result in no bruising or broken bones. If there's enough else there. So very insightful comment and question there. Appreciate you bringing that up. Chubbs W. Timestamps are from infotainment. Key cycles are from TextStream. SB said he didn't look at TextStream. Variance was calculated assuming Welcher association. Okay, that's interesting. I did kind of wonder how these pieces fit together because that's kind of what I recalled was that the TextStream data didn't have any timestamp associated with it. And I was having a hard time seeing how was user data going to suddenly provide a timestamp for this other data that we already had. It didn't make a lot of sense. So it sounds like you're saying these are two separate event recording types of systems, and we're simply trying to correlate them. So if the infotainment timestamp showing a 3-point turn, I guess I'm interested in what is that? What is that timestamp? I'd love to see the data. How do they know this is a 3-point turn? The car said it was a 3-point turn. Is it reported that way? Does it just report a certain movement? I don't know. So then they've tried to do the same thing as they had to do with the clocks, right? We find the same point and then we, they're off. So we match them together at the same time. So if we have the 3-point turn on the TextStream data and a 3-point turn on the infotainment, then we can correlate those things, I guess. Or is it just that we're deriving everything from the presumption that this all starts with key cycle 1162? And then from that, we have the time that the engine was powered on. We have the time of the event. And so we know so much time elapsed before there was a 3-point turn, and then so much more time elapsed before there was a backing maneuver. And those pieces came from the text stream. But I guess the clock, I don't know. I think this is a good and important point. But it's hard for me to picture it because I don't know exactly what these systems are doing, independently. So what does the one contribute to the other, and how are they matched up? That wasn't really made super clear to me. So good observation here, and it makes sense. But I think I'm going to need to learn more from the folks who examine these systems. Romy, why isn't it permitted for witnesses in this trial to testify via Zoom? It would have saved Dr. Wolf a lot of time and effort. Dr. Elizabeth La Posada testified via Zoom in the Turk trial in the same courthouse. Is that up to the judge's discretion? Yeah, it's typically up to the judge's discretion. There can be some argument that effective cross-examination presumes that the person needs to be there in the courtroom, that you have the right to confront them, personally, not just over a video feed. When courts have looked at that, which they did at length through the, COVID era, because Zoom court became the norm, started doing lots of trials and stuff by Zoom. And they had to consider the constitutional implications of that. I am not aware of a single court that said you have a constitutional right to have the person present in court. But nevertheless, some judges are still going to be cautious if there is a defense objection on those types of grounds. No, he needs to be here in person. I want the jury to see him react. Karen has the right to look at him in the eyes and for him to look at her, while all this is happening. That interaction is part of the structure of the trial that lends to the truth finding process. Some judges will be conservative about that and just err on the side of, yeah, she's got a confrontation right, so we'll make the person appear personally. So it could be there's a defense objection, or it could be just nobody asked. I mean, you can ask. Zoom court is really not particularly unusual in this day and age. Yeah, really ever since COVID. Pretty much every court is equipped for it. And that's why more and more I see very little reason not to fire these inept camera people that come in from network TV or wherever and don't show us what we need to see, when the court system would do that. The court system will have a camera that shows you the exhibits. It will have a camera that shows you the witnesses, etc. So, J-Man, John O'Keefe clothes look like rinsed out blood stains, like they put him fully dressed in a shower or used a hose for hours, could also bring down temp. Yeah, we mentioned this earlier. There have been some theories about laundering or something like that. So I kind of see what you're seeing, and it's that it looks like there is some kind of so, capillary action is one of the properties of fluid, right? And so, and then also the surface tension. So the fluids tend to attract. So if you have, a droplet of something come into contact with a droplet of something, they're going to be attracted, and there's going to be a mix, and it's going to look like, more of a diluted kind of substance, as opposed to like a fine droplet or a smear or something like that. And so I understand what you're talking about. When you look at the shirt, it does look like maybe it's gotten wet. And so the blood, the kind of pattern and color of the blood is maybe not what you'd expect if it was just, straight blood flowing down onto the shirt. I think that the problem is it's just hard to identify the source of that. The guy was lying in the snow, for who knows how long, wearing the sweatshirt. The snow is going to be a source of it getting wet. So it could just be as simple as that. He's in the snow. His body heat melts some of the snow on the back, on the front. That melts. That then interacts with the blood that's on his shirt, and it looks the way it did. Another explanation, one that again is just something I have a little bit of personal experience with. When you get in a fight, you sweat a lot real fast. Does not take a long time to sweat through your shirt in a good solid 3-minute round in a boxing ring. Happens real fast, and you get the same kind of effect. I'll get a bloody nose on my shirt, I'll sweat all over my shirt, and it blooms, if you will, while we're talking about blossoms and bruises and things like that. So it could be that too. There's a fight. You have to account for the fact that you're going to sweat into your clothes more than likely. So, possible different explanations. I would think if there is a, laundering type of theory, there would be some way to, I don't know, probably not. I mean, I guess probably not. I was going to say some way to are there laundry, soap residues or something? But if there are, you'd expect that anyway, because everybody washes their clothes. I don't know if there's any way you'd be able to tell. Maybe there's a blood stain analysis way to evaluate that. But I don't know. Rhonda, Iowa girl, that's not a tall vodka and tonic glass like Karen put the shot in. That's a whiskey glass. It is a different glass than the one we saw in Karen's hand, but it also came from a different bar. The ones we saw in her hand were the drinks she was having at CF McCarthy's. I think the argument is that, and it just kind of part of how it came out from the clip, one of the clips that was played, was that John had bought her another drink over there at the waterfall, and she didn't drink it at all. And John, didn't want it to go undrunk. So he took her drink and left. So that's where I think that cup comes from. It comes from the waterfall. So I don't know, bartenders in the chat, is there a normal way you're supposed to mix a vodka and soda, particular glass you're supposed to use? I know sometimes these things get real specific, which glass you're supposed to use for a Manhattan, which glass you're supposed to use for a Cosmopolitan, stuff like that. And if you're real into those fine details, that kind of thing could matter. But I'm not sure there's a standard like that for a vodka soda. I think you could put that in any number of different types of glasses. Just so that's a possible explanation. I think is just that it's a different bar. It's a different it's a different place. So they may very well use different glassware. Particularly, one place might be also very particular about, let's make sure we use the right glass for the old fashioned and the right glass for the Manhattan, and the next bar next door may not care at all. They'll just use whatever's at hand. So I think some of those are possible. I really hope or wish the light would be plugged in to demonstrate the LEDs and how it doesn't match the video of Karen Reed leaving at 5 a.m. There are more missing. Loved that demonstration by Be in Trouble 31. That video he made, extremely compelling, I thought. Extremely compelling, and such an easy thing to do. Just take the tail light and plug it into an electrical source. So simple. Make it light up. I would love to see a demonstration like that. I would love to see ARCA doing something like this. It seems like a great kind of thing that ARCA could do. I really hope we get to see that, because it was very powerful having that visual and seeing here's the actual effect on the light from having all these pieces gone. And then you can see for yourself, is that what it looks like in the tail light? Because it sure didn't look like it to me. Denise H. What numerical alpha combo makes this testimony stop? Congratulations on 100,000, Melanie. Did Melanie Little get her 100,000 subscribers? I got to go check. Let me see her. 100,000 subscribers. She did indeed. Congratulations to Melanie. Good for her. Very well earned, very well deserved. She is, one of the absolute OGs on this case. I was watching Melanie on this case long before, I had anything of my own to say about it. So thanks for bringing that up. We like to be able to celebrate the successes of our fellow law tubers. Lindsay, have you seen a Nike dumbbell, the swoosh like a J? I haven't seen a Nike dumbbell, but there is, swoosh is, yes, a little bit like a J. I wonder, that J pattern was called out, wasn't it? On the cross-examination of Dr. Scorty Bello, that there's a J pattern kind of in the abrasion. That seems like a hint that's being dropped. A little seed that's being planted. Perhaps that will come up in future testimony. We'll have to see. The defense has a theory about how and why this wound appears the way it does. Kristen from Manhattan, have you seen Sergio Denaro Truth Revealed, former CIA? He analyzed McCabe Albert Higgins' testimony in Trial 1 and now Trial 2, called out the garage and other critical factors early. Recommend you take a look. I don't think I have seen that one. So let me make a note. I've got kind of accumulating a long list of things to look into as soon as I get free time, which hasn't happened a whole lot, but hey, we got 5 whole days off now. Truth Revealed. So I might get a chance to go take a look at that. Thank you for the recommendation. Aunt Nancy, Andrea, I'm so curious about your break photo. Don't look at me, I'm hideous. What's the backstory? So the backstory is I needed an avatar one time when it was when I was in Delphi, and I went on like kind of randomly out of the blue with Ian and Rob. I forget whose channel it was on, but it was one of Ian and Rob's joint streams. And this was at night. This was after we'd had a full trial day. I'm already in bed. Like, I'm not going on camera at this point. And so I just picked that one from the birdcage, Nathan Lane's from the very beginning of the birdcage. Nathan Lane is, don't look at me, I'm hideous. And he needs the Pirin tablets to feel better. It's one of my favorite movies, The Birdcage. It's a wonderful movie. I really enjoy it. So anyway, that's the story behind that. And I've just never gotten around to changing it to something else. So don't look at me, I'm hideous. Everage, dear Andrea, have you ever seen a case where there were so many wolves involved to prove a person was or was not attacked by a dog or hit by a car? A lot of wolves in this one. Normally, unless you have a family, very common, if you had a wolf family, that you would expect a lot of wolves, but all these unrelated wolves that are coalescing around a dog. Curious indeed. No, I've never seen anything like it. Kelly, objection beyond the scope of all reality. Unless they matched glass to the waterfall or ruled out 34 Fairview glasses, surely this is another nothing burger. Can defense show all unmatched glass plastic? They could. They have, or they should have, all of the information that they need to be able to bring that out. Now, I don't think they have done that, because most of that information, you're going to have to glean it from the expert reports. I don't know if there is enough here with what's been admitted into evidence to do the kind of reconstruction that folks like Brandi Churchwell did, and so other folks have done as well, where you're matching this reconstructed taillight that was shown, this photograph that was taken, and the pieces that you can see on that to the pieces from each individual bag as it was photographed in the lab. Because otherwise, all you know, you have the information that I have when I went through and I did my little spreadsheet. Bag that was 7-5, that was from the search. It contained 3 pieces of plastic. 2 of them matched the taillight. 1 of them did not. 7-6. 2 total pieces in the bag. None of them matched to the taillight. When you have, for example, item 7-8 was 12 pieces in total. 4 of them matched the taillight. 8 of them did not. We don't necessarily know which piece is which. And so if I just look at the photograph of item 7-8, I know that 4 of them match, but I don't know which 4. So that would prevent me from being able to show the jury, here's the pieces that didn't fit. So I don't know that groundwork has been laid by the defense to be able to make that clear. I think that would have had to have come out in the cross-examination of Maureen Hartnett. Possibly it could come in from another expert who relied on Maureen Hartnett's work and analysis, reviewed the report, analyzed it, drew their own conclusions from it. But I kind of doubt that that's coming. So in theory, yes, you absolutely could. But in practice, in this case, I don't think they have the pieces that they would need to be able to make that demonstration to the jury. But this argument that they never bothered to try to compare it to the glassware at the waterfall or have somebody at the waterfall even look at it and say, we had a witness from the waterfall right here in court. We didn't even show her the glass, the base of the glass, and be like, hey, does this look like your glassware? Is this one of the things you use? I think that's legit to point out. You're making a lot of assumptions about bumper glass matching to cocktail glass having a specific origin at the waterfall, but you're never testing those assumptions. That's what makes those conclusions unscientific. You haven't done anything to try to validate that or to try to corroborate that. So I think that's a perfectly legitimate point for the defense to raise. Add it to the list of Bowden issues, right? All the things you didn't do, all the things you did wrong, that's all Bowden stuff. So it should all be on the table. Nikki, the judge was seen talking to Karen Reed during the sidebar about the jury. Do you think that could have been some kind of waiver? I don't know. I really don't know. I would hesitate to guess. I would hesitate to guess. Just without knowing more about what was the issue being presented in all of those issues, and all that questioning and so forth. It's just too hard, I think, to guess. There's too many possibilities. Waiver is certainly possible. We're advising her of something and asking, do you want to go ahead and continue anyway? It's very possible. If there was a question about maybe a juror spoke to somebody, and that's why Bev is being all emphatic, don't talk to anybody about the case, or maybe an allegation that somebody talked to a juror, and maybe the evidence is ambiguous, again, being very hypothetical here. No indication that any of this is the case, but just for purposes of a hypothetical, would you maybe ask Karen, are you satisfied? Do you want me to do anything with the jury? Possible. Yeah, possible. But it could be other stuff. We really don't know. Time out. I can trust Lally to take an expert and make it the most unbearably boring listening experience. I feel bad for the jury. Lally really can make anything boring, can't he? He could make us nap through a Kiss concert. It would be soporific, that experience. And he wasn't helped with this particular expert already. Again, I'm not trying to give her a hard time, but it's a little painful when you're that slow and that careful and that cautious. Some of these answers seems like they should come a little bit more quickly, but I don't want to judge her and all that. But I can't deny the effect of it. It's a little excruciating. Austin Pro Courier and Apostille. Thanks for your excellent coverage. As the son of a murder victim, if our police handled my dad's case this way, I'd be pissed. Very sorry about that experience. And thank you for sharing this perspective, because I do think this comes back to why there is the outrage about the case, and why, I understand why folks have a really hard time with the family and how the family seems to be like not troubled by any of this. Because I think most of us would be pretty troubled by it. You might catch somebody, but if you've been this sloppy with your investigation and your documentation and stuff like that, it's not hard to lose a case you should have won, because of little oversights. That's why it's so critical to do things by the book. The book exists for a reason. They didn't just make up the book for shits and giggles, guys. It's there so you don't hand arguments to the defense to be able to point out, hey, we have no idea who handled this plastic, what they might have done with it, just for example. And so I think this goes back and speaks to why this case has generated a lot of the reaction that it has, why people are pissed. Because, okay, John O'Keefe wasn't my son, he wasn't my brother, he wasn't my husband. But if this happened to one of those people, and this is the investigation that I can expect out of it, I'm not satisfied, and that needs to change. And somebody needs to fix it. They need to get their house in order. So I can understand that very, very well. Thanks for sharing that. Kitten Fire Department. Seems like 5 days off for jurors works against the defense. Theories dissipate and everything seems like it appears on the surface. From a kind of substantive standpoint, in a normal universe, if you break for a long period of time in the middle of the prosecution case, you would expect that to be really bad for the defense, because that's all that's on their mind during the 5 days. They have that extra time for it to just kind of sit and simmer, and whatever impression they left with, there's nothing going on in the interim to kind of dispel that. So then remember the memory process. It's rewriting, it's strengthening kind of where you're already at. You go over the trial and where you're at in your mind, and what you're going to be doing is just re-emphasizing what's already landed with you, the impressions that you've already gotten. And so, you might be just entrenching your viewpoints more and more and more during that time off. In a normal case, that could be really, really devastating for the defense. I think the question here is, are the jurors walking away today for 5 days with an impression of the strength of the prosecution's case, and the impact that it's had on their ideas about what happened? I'm not sure that they have. Certainly not where they should be. In a normal, good prosecution, you should be way ahead by this point. The prosecution, it really shouldn't be in question. Like, this is the high point for the prosecution. You've put on almost your entire evidence, and the defense has put on nothing at all. So you should be at almost the high point, because you've gotten all your stuff out, just about, and the defense hasn't been able to answer any of it. All they've been able to do is pick at it through cross-examination. They should be so far ahead at this point. But I don't think that's the case, because there's very little that they've been able to bring out that hasn't been able to be neutralized or mitigated or something like that in some way by the defense, just through cross-exam. So I tend to agree with you that just in the average case I'm used to seeing, yeah, this would be devastating. Like you might as well just call the trial over at this point. By the time we come back after 5 days off, we're walking back in and we're reminding ourselves, oh yeah, I remember when I left on Friday, she killed him because of this, X, Y, and Z. And that's where you're at, In this case, I'm just not sure. I'm not sure that the prosecution has made that much leeway for it to be that beneficial. But I don't know if we'll ever know. I mean, I think it's helpful in this case too that because the defense theory now seems to be focused far more on the Bowden, on the failure to investigate, the lack of curiosity, not asking questions that you don't want the answers to, and so forth. That does kind of help them to the extent that's already been presented. And some of that the jury's already had a chance to think about while they're thinking about the prosecution's case. It helps that impression be less strong, The impression, the case against Karen is really bad, but we may also have a strong impression that the case against Karen Reed is really wrong. There's a lot of problems with it. So if they're walking away with there's a lot of problems with this case against Karen Reed, that's not a bad place for them to be sitting for 5 days on the beach drinking Mai Tais and whatever. Mike from Providence, I swear in 3 weeks we better not hear Bev complain to the defense about how long the trial is taking. Lay the marker down right now. Absolutely. We better not hear a peep. We better not hear a peep. Nothing. And if the trial starts going long, I'm going to maybe have some issue with these comments to the jury about how everything is ahead of schedule and it's great while the prosecution is running things. And we're getting unexpected half days and witnesses not being called in and so forth. If things start to go long while we're in the defense case, I might start to have a problem with some of these comments that have been made because it implies everything was fine. We were even ahead of schedule while the Commonwealth was running things. It's the defense that's making this take forever. It's not an appropriate message to be sending to the jury, even if it's just implicit. Yeah, good marker, good call. Lay it down. We better not hear it. Sean and Michelle, hypothermia slows metabolic processes almost to a halt. Warming up the body kickstarts those processes to begin recovery. If you're dead, the kickstart doesn't work. That also makes sense to me. Yeah, I mean, cold is gonna slow everything down. Severe cold is gonna slow everything down. If you're not actually dead yet, add heat, turn it back up. Makes sense. Blood starts circulating faster. Heart starts beating better. Breath starts becoming deeper, more rapid, stuff like that. It makes sense to me. Definitely, if you're dead, it won't work. I get that. I guess I'm just wondering if there's a circumstance where you find a cold person outside in the cold, not breathing, no heartbeat. Do you ever just assume this person is dead? Is there a point somewhere between the person is decomposed and the person, is fresh? Where you'd be like, no point in trying reviving here. The person is dead. I don't know. This is just kind of casual interest to me, I guess. But it's just because we have this particular issue in the case where, I mean, am I wrong on that? Am I off on that? Like, he's 80 degrees. How much of him being 80 degrees is because he was dead versus how much is he was 80 degrees because he was in the cold? Am I wrong to be thinking that there's some kind of issue, some kind of like problem there with being able to sort that out? Because if he wasn't breathing, if he didn't have a heartbeat and stuff at the time when they found him, that could have been the case for a while, right? Until the other death processes start. Nobody said anything about rigor mortis or anything like that. So I don't know. Just trying to find a way, if there is one, to try to untangle that particular little complication, but I'm just not sure there is a way to untangle it. I guess I have to assume that the experts would have done that if that's possible. Nora, I believe John O'Keefe could have been saved. This thought haunted me since the first trial. I hope that the hospital staff that worked on him will be investigated one day. Well, I don't know that he could have or not. My understanding is that by the time you have to do CPR, it almost never works. CPR almost never works. You rarely succeed at reviving somebody who's already stopped. So I don't think that's their fault. I wouldn't want to hold it against them. So, but you are absolutely entitled to your opinion. It's just not one that I tend to share. CC Agility, how are they explaining the orbital fractures? Well, he didn't explain them, did he? He didn't explain the orbital fractures. Don't know. Don't know. Would you get orbital fractures from the force, the counter coup, kind of force? No, the brain bouncing wouldn't cause them. Is there some way just the impact, the original impact, travel through the skull, affect the orbits? I don't know. I need an expert to tell me. Mark, I don't know about you, but I think I'd be upset to learn that I was brain surgery number 4 for the day, to be honest. Thanks for your excellent coverage. You've hit on, yes, thank you for putting this in a way that I was not able to distill it this cleanly. Talking about the grind culture and the work ethic, and I'm so busy and I do things all the time and I'm so productive and stuff like that. And the downside to that is, yeah, somebody is the 4th brain surgery of the day. And is that really where you want to be? Is that really where you want to be? You want to be the last guy after the fatigue is already set in. What if you're the situation where something goes bad? Are we really at our A game, able to deal with that if we're the 4th person in line for the day? Yes. Thank you for personalizing that and making that point a little bit clearer for me. I agree. I'm not sure I would like to be surgery number 4. KIU, aka Kirstine, with a super chat. Thank you so much for that. Kirstine. Kathleen R. I bet Alessi's truncated cross of the doctor threw Brennan off. I wonder if Brennan planned to get a lot more in through redirect. That would be bad strategy if you did. It's the whole you can't pull your punches. If you get the opportunity, you really need to take them. You really need to take the opportunity because you don't know if you're going to get it again. And sometimes things happen and you just forget, and then you get a gift in cross and it enables you to go in and cover the point that you should have covered when you had the chance to do it. It would be very bad strategy to gamble on anything happening in cross to open it up for redirect, because you just don't know. You can get pantsed in trial like that, making assumptions about what the other party is going to do. But it was a short cross, wasn't it? Very short. And at least from a timing standpoint, yeah, he might have expected that Dr. Wolf was going to take like all day. And then Christina Hanley would still be finishing up tomorrow. Maybe that was the whole plan for the rest of today and the half day tomorrow. Turns out we don't need the half day tomorrow because, hey, we were able to get through all of it today. So very possible that the truncated cross took him by surprise. But if he was planning on putting new stuff in through redirect, that would be a very poor strategy. Nora, we watched 2 first responders lie on the stand. We know they're lying. That's why I don't even trust the hospital staff who worked on John O'Keefe, just to clarify. I understand this perspective too. Yeah, they claim things happen that we can see on the video did not happen. It's not how it happened. And your own independent stories don't add up with each other. I get it. Nuttall, I've said from the beginning, I tend to give Nuttall a pass on lying. I think what he's doing is confabulating. That's why he was called as a witness, because he so sincerely believes in this false memory that he has, that he comes across as very sincere and very earnest. He doesn't come across like a liar. He really does believe it. He's insistent about it. He doesn't have any lack of confidence in it. He has all the hallmarks of somebody with a false memory that they believe in 100 bazillion %. And he believes in it so strongly that every time he tells a story, he adds new details that reaffirm it. To me, Timothy Nuttall is a classic confabulator. But I could be wrong. That's just my impression. If he's confabulating, he's not doing it on purpose. And honestly, I tend to, in this type of setting, I will give people frequently a lot of benefit of the doubt. If you get something wrong, there's a lot of reasons why we get things wrong. And very rarely is it I'm deliberately getting it wrong because I'm trying to lie. But it certainly does happen. I do look a little more side-eye at Katie McLaughlin and her story, in part because it is so detailed, very detailed, and once again, doesn't align with anybody else's memory of how this happened. But then we also have that relationship factor. You know, she has that link to the Albert family that could give her more of an incentive to just make sure she's part of the team, part of team. I hit him. But I can't prove she lied. You know, I'm just I think it's more of an open question with her than for me personally with Nuttall. I think Nuttall's just a confabulator, and that does happen a lot. People get their memories tainted. And we tend to have very little humility about our memories. You know, I think the more you understand the process, the more you're likely to discredit it. Be like, wow, this memory I have is probably completely fake. Guys, I have a memory from when I was barely 2 years old when Mount St. Helens erupted. I have a memory of being in the back of the car that my mom used to have. She had an old Volkswagen Bug. Whole family is in the car. I'm in the back seat. We're driving up the side of what is known as Flat Top Hill in West Richland. It's just a little hill. There's a little dirt track that goes up to the top. And this memory of bouncing in the car, getting to the top of Flat Top and seeing the sky. And what I remember is a sun, like a massive orange sun that was like, it was huge, just this huge orange sun and this orange sky. I have this very clear memory of that, very vivid memory. But guys, I wasn't even 2 years old. Like how is that even possible? I don't think that's possible. I don't think it's possible that's an actual memory. And I've talked to my family. Nobody remembers an event like that, you know? So I think it's highly possible. I just made that up in my mind at some point. I heard about Mount St. Helens. I knew that it happened. I knew I was alive at the time. And something in my mind like created this memory. Maybe I dreamed it. I don't know. Maybe it was some other thing that happened at some point in time that was not Mount St. Helens, but it was maybe a fire or something, and I just confused it in my mind. I think all these things are possible, but to sit and insist that happened when Mount St. Helens erupted when I was barely 2 years old, it seems like that would be very arrogant. I just feel like I know far too much about memory to say that because I have a vivid memory of it, that means that's what happened. So that's just an example, but I will give people a lot of credit for being wrong, particularly about what they remember. I'm not going to infer the worst of that most of the time, but that's just me. You know, people definitely can have different reads on the situation. Sarah Powell, once a case is over, can the defense file a complaint or grievance based on the judge's actions towards them? Does Karen have a case for this? Thanks. They don't have to wait for the case to be over. The Commission on Judicial Conduct, the one that I pointed out before, they're in charge of judicial discipline. You can file a complaint anytime. You don't have to wait for the case to be over. Now, it might be prudent to wait for the case to be over because often the person that's complained about is going to be notified about the complaint. And as part of that, they may be notified about who filed the complaint. So no guarantee that it's going to be confidential. So it might be prudent to wait till that judge can no longer potentially take it out on you. As far as a civil case or something like that, a lawsuit, almost 100% no. Almost. 99.99999% no. You have no claim against judges. Judges are absolutely immune from prosecution based on their judicial acts. And the exceptions to that are so few that they hardly factor into my made up statistic. It's a 99.999. Almost never going to be able to sue a judge for something the judge did as a judge. It's just not going to happen. Why? Because judges created a doctrine of absolute judicial immunity. They said, you can't sue us when we're just being judges. That's the law. Z. Yannetti worked with Alessi on prior cases and friends. Alessi consulted for trial 1 and joined retrial. Miracle how Yannetti was first attorney, Karen called. Thank you for filling in this part of the lore. I only had, like I said, kind of a general view, and it sounds like some of it was off anyway. I didn't realize there was connection between Mr. Yannetti and Mr. Alessi. I'd love to know about the case. What case brought these universes together? I don't know much about, if anything, about like the day-to-day practice that Mr. Alessi has at DLA Piper, but I know he's part of like the global energy group or something like that. So I had always envisioned a lot of regulatory work, a lot of transactional work, not so much litigation, but probably some, but just then trying to imagine a universe where these things like, an oil producer in Venezuela needs a contract for delivery to Argentina. It's the kind of thing that DLA Piper does. And so how is that universe gonna cross with David Yannetti, the Massachusetts criminal defense attorney? I don't know. I would love to know. I would love to know the story of how. So thanks for that additional detail. That is very, very interesting and good to know. I do wonder too, why did Karen pick Yannetti? How did she come up with him? Had she heard of him? She just pick him out of the phone book, pick him out online, like the way he looked. He was the only person that answered the phone. How people pick their attorneys is often a subject of great interest to attorneys. I'd say where I am, it's mostly word of mouth. I think in a smaller community, word of mouth tends to be one of the primary ways you would choose a defense attorney. But in a bigger community, it might just be randomly in the phone book. Might be, hey, I saw this guy on the back of the bus. Photo on the back. I don't know. A lot of different ways. Miriam, my girl is smart and a baddie. I love you. Oh, thanks, Miriam. Heart right back at you. Thanks for the kind words. KIU, aka Kirstine. My sister fell out of the window from second floor to concrete. She was also hit by a motorbike. She was 3 and 5 and was clinically gone the first time. She's 59 now. I wish Karen and Innocent a fairness. That's quite a story. That is quite a story. Clinically gone to recovering and going on to lead a long and normal, healthy life. That in and of itself has to be one of those extraordinary outcomes. Not unheard of, but I would guess it was a beating the odds type of situation. That is a lot of physical trauma for a person to go through at a very early age. So, glad to hear that she survived that and has gone on to have a long, hopefully healthy life. Emotional lemonade. Has it been established what happened to the time between tow pickup 4:12 and sallyport arrival 5:30ish. Do I have those times wrong? What is the time? No, you have the times pretty spot on. 4:12 was the time on the surveillance video, the Karen Reed's dad's surveillance video when they were loading the car onto the tow truck. And then 5:31, if I remember correctly, was the time on the alleyway, driving up the alley. That particular video, 5:35 to 5:36 was the time frame on the video of loading the car into the sallyport. That's my rough recollection. So you're absolutely in the ballpark. I don't know if there's lost time or if they have just attributed it to weather. You know, the weather was bad. We see there's a lot of snow. Don't know if it's still falling at this point. I think it's starting to taper, but still some active snow. So as far as I remember from the first trial, it took them a long time because of the conditions, but maybe the tow driver will have something to say about the time it took in transit. Texas Sister, I don't care about Texas Sister 2. I don't care about the tail light or the tech data because his injuries are not from a car accident. You kind of think like I do. I mean, to me, that's the bottom line. That's the bottom line. You're going to have to show me how these injuries add up to a car accident, or I'm just going to have a really hard time believing that that's what happened. But I don't know if the jury is seeing it that way. I don't know if a jury is seeing it that way. Lisa Bishop, you make this all so much easier to digest when I'm listening and trying to work each day. I really appreciate your commentary. As a lawyer in civil litigation, I rarely see inside a courtroom. Well, thanks so much for joining us. I definitely appreciate that and appreciate the kind words as well. Yeah, civil litigation, you deal with discovery. You deal with discovery. It was kind of fun for me. Again, I hate to take everything back to Depp v. Heard, but it really was the case with everything. It was fun for me as a criminal practitioner, particularly a public defender. You spend a lot of time in the courtroom. You cut your teeth in the courtroom. It's really the bulk of what your practice is in very many ways. And so having that perspective on the trial practice and watching the civil lawyers do the trial, because I just noticed little things that stood out. There's such a different strategy to conducting a deposition, for example, than there is to questioning a witness at trial. The discovery deposition, it's exploratory. You're there to ask all kinds of questions you may not know the answer to, and then you take what you've learned at that deposition. At least this was my strategy when I did, the limited amount of civil litigation that I did. You would get the information from that deposition, and then you would investigate it. So okay, I've had a deposition, and my witness claims, yes, I paid all of the relevant taxes on this transaction. Well, now I'm going to try to substantiate that. I'm going to get discovery of your tax returns, your filings, your statements, your canceled checks, whatever, stuff like that. And I'm going to see if there's anything I can catch you in, because then that's what I'm going to focus on at trial. I'm not going to just go in and re-ask you the same things I asked at the deposition. That's like wasting the opportunity. I'm using the deposition to try to set up something that I can come smack you with when it comes to trial. So that was always fun, like watching. There's so many different just skill sets and practices and stuff like that. I bet you can write an interrogatory that I would dream. I would in my dreams, I could never write an interrogatory so good. So I appreciate that, Lisa. Thanks so much for the nice comments. That really is the goal, is just try to make the trial process itself a little bit more understandable for people that have not bathed in the fire of trial work. T-Rex Trucking and More. I'm just saying, it's been 3+ years I've been following this case, and no one's answered these core questions. 1, what if any snow? 2, Hoslong to die in cold. I don't know. I feel like we got what if any snow answered like 500,000 times in the first trial. We got how much if any snow answered by every single witness, including the ones that only were part of the case in the summer. But it's true. We never did get an answer to Hoslong to die in cold. Never got an answer to that. Maybe that's why I'm so focused on, why is John 80 degrees? Hoslong to die in cold. How much of that is the cold killed him? Hoslong, how much of that? He was already dead. I don't know. Elizabeth, enjoy your time off, Andrea. Thank you so much, Elizabeth. Appreciate your support. Debbie W., how in the world is the trial ahead of schedule? I can promise no one thought Yuri Buchanan would be on the stand for 3 full days. Yeah, that's true. Least of all him. He was not expecting that at all. He was not expecting that at all. I remember from the pretrial hearing, Hank saying 3 to 4 weeks. And we just finished week 5. So I don't know how we're ahead of schedule. Am I remembering that wrong? It's possible I'm remembering that wrong. I haven't gone back. Suppose I could. Oh, dig through all the notes and see if I can find it. How long? I don't know. I know it's in here somewhere, but I just don't remember. Don't remember exactly where. Don't remember which hearing. Evidence will take 6 to 8 weeks. It's what I wrote down from the April 1st, 2025 day. That's what they told the jurors. That was the first day of jury selection. So told them 6 to 8 weeks. We're on the end of week 5. But when did Hank say? When did she ask them? Was it at the end of the motions in limine? Yeah. I just don't remember when that came out. But I guess if the jury was told 6 to 8 weeks and we're just at the end of week 5, then we're probably close. So maybe not out of the realm of possibility that we are in fact ahead of schedule. Not like way ahead of schedule. If schedule is 6 to 8 weeks, then we're within the range of what we predicted, but at least as far as what they anticipated. Z, maybe Alessi helped Yanetti's clients with Section 1983. 1983 is such a specialized area of litigation that I would be really surprised if Mr. Alessi has dipped his toes in those waters. Part of the reason why I would love to see the context of this is because typically in a bigger firm environment like this, you're going to become more specialized. Like there's no like generalist in in a big law firm like this. It's just not structurally how it works. You end up being directed into a particular subject area and you focus on that and you learn all of the ins and outs of that and you become very, very specialized in it. People who hang up their own shingle in a small town become more generalists. You're much more like the family doctor that has to be able to handle a little bit of everything, but then once in a while, the subarachnoid hemorrhage comes up and you gotta send it off to the specialist for that. So given Alessi's environment, where he practices and what his specialty is, I'd be really shocked if he had dipped his toes into 1983, because it's a whole subspecialty of its own. But maybe, if he's used to dealing with complex litigation and complex legal and regulatory schemes, which from my perspective, energy law, extremely convoluted, complicated. Before you even take it to the international level, it's a mess. If he's used to dealing with those kinds of complexities, maybe 1983 is not that big a deal to him. That's also possible. But I would love that story. I'd love to know, what case did you guys work on? How on earth did that happen? Nick TTT, I can't stand witnesses like the last one. They attempt to hide behind the science and data, act all meek and scared on cross-examination. In reality, they are a hack like the rest, cagey and difficult. Again, I see and understand this viewpoint. I get it, and I think that's a legitimate interpretation. I'm going to tend to give her the benefit of the doubt, in part because there wasn't a huge discrepancy between the way she acted on direct and the way she acted on cross. It wasn't like Buchanan, where he knows exactly what you want and what you're asking for and will volunteer stuff and things like that on direct, but then suddenly on cross-examination, he remembers nothing, he knows nothing, he can't identify this document, and so forth. So you don't have that contrast. At least I didn't see it significantly. But it's just difficult, right? It's difficult to just to sit through. Like, the questions shouldn't be that hard. They should be pretty straightforward. I don't want to judge people without more. You know, I'm typically going to need a reason to infer that there's like malevolence behind this type of activity. It's easy enough to explain as this is a lab person who is shy and not good at talking to people, may not even like talking to people, but talking to people is part of the job that she has. But she would, by and large, prefer to be back in Boston or wherever with her microscope. That's her happy place. I can see that. But people are going to have different reads on it. So what's the jury going to think? That's what we don't know. Jury could give her the benefit of the doubt, but jury could also be like, inexcusable for the witness to be unable to answer these questions like that. Unprepared, potentially dishonest. They could be thinking that. I don't know. Z, one of Alessi's specialties is 1983 on law firm bio. Are you serious? All right, I got to pull up Robert Alessi's bio on DLA Piper. Where is he? All right. Here he is. Let's go ahead and share it, because why not? Why not? Here he is. Here's our man. Robert Alessi, partner, global vice chair of the energy sector. That's what I remember saying, being like, oh yeah, this is the guy who negotiates the contracts between Venezuela and Argentina. That's him. He may not actually negotiate them, but he's in charge of the people that negotiate him. That's him. So then we have, there it is. I see it down here. I don't think I'd read any of this. One of the smartest lawyers I have ever worked with. That's quite a recommendation. I can't say I would disagree with that. Represented the governmental entity charged with planning the rebuilding and revitalization of the World Trade Center and Lower Manhattan in the aftermath of 9/11. Now that's somebody who can manage some regulatory hurdles. Who can manage some contract negotiation. That is no small task. General civil litigation practice encompasses a wide variety of commercial matters in state and federal trial and appellate courts, including multiple state and federal court actions arising out of one of the largest bank frauds nationwide. Bank fraud, that's intriguing. Many of his trials have turned on the direct examination and cross-examination of experts, where he applies his scientific and technical background. Definitely working here. He has handled a variety of domestic and cross-border criminal matters. He has pursued and defended on behalf of clients several 1983 actions involving claims of violations of constitutional and other rights by government officials and agencies. He has also pursued and defended on behalf of clients numerous claims under the Racketeer Influenced and Corrupt Organizations Act, RICO, of 1970. What a good catch. I had no idea he had a 1983 background. That could very well be it. That could explain a lot. Me as a random criminal defense attorney, I am pretty well equipped to identify when somebody might have a Section 1983 issue. But as far as like, do you have one? How would you go about asserting it? What's your time frame and stuff like that? Well outside my my special area of knowledge. In fact, I'm going to see if I can find. Sometimes I find like interesting research, and I go and share it. Save it, stash it away to read sometime, and then of course I forget where I put it. But I had found at one point there was a resource that I think was put out by the Ninth Circuit Court of Appeals. And it was like this whole guide to 1983 actions in the Ninth Circuit. And I saved it somewhere just because, again, that type of thing. It's so specific, idiosyncratic, and it does. It varies by jurisdiction, varies by circuit. There's just all these different things to pick up on, and I don't necessarily know. Like any of that. So anyway, I can't find it offhand. I don't know where I stashed it, but I did find that. It's probably on the website for the Ninth Circuit somewhere. If you're interested in some of the ins and outs of 1983 litigation as it's carried out in the Ninth Circuit, it's a big old reading list. So you can get the feel for that if you're so inclined. Z and Alessi admitted to the U.S. Supreme Court. Fascinating. That is a good one to have. I have that one. Doesn't really mean much. It means I had to file a petition for certiorari a couple of times. Doesn't mean you've been there. Doesn't mean you've argued a case there. But it does mean he was the guy whose name was going on the letterhead if they needed to file a petition for certiorari or something like that. Arguing a case in the U.S. Supreme Court, that's what takes you up to the next level. That's why Ron Goldman is like the king of LawTube in my eyes. If you want to do a resume throwdown, nobody is going to beat the guy who won a freaking First Amendment case in the U.S. Supreme Court. Okay. It's going to be that guy. That is the most impressive accomplishment that anybody on LawTube has. Z, Bev was scared and wanted detail why Alessi involved. Yeah, see, I must have missed this. This might have been at some point during the transition. It might have been like when I was in Delphi or something like that, just paying attention just to something else. It's one of the hard things about I don't follow every case. I follow actually very few cases, in part because I want to try to deep dive, try to get as much information as I can. But cases take so long that it can be hard to do that even with just a few on your plate. So you have scheduling conflicts and stuff. We still had stuff in Kohberger. There's been all kinds of stuff in Kohberger that's happened in the last couple weeks. I've been focused on Karen Reed. Like I've gone back and watched it, but I haven't had really time to do anything with it yet. It's just kind of the trade-off, I guess, of watching things very, very closely. So very good to know. Thanks for sharing that, a little bit of information. So guys, looks like we're about wrapped up today. Just checking real quick to see if anything else has happened in court. Anyone has I'd really like to know if there's any more information about what's happened with the jury or something like that. No, it looks like there's been a memorandum in order regarding the buffer zone. This is from the Superior Court. Oh boy, let's go ahead and look at this, guys, because we might as well. Here we are. Take myself over here, but now I got to make it a little bit bigger, huh? That's hard to see. Does that work? A little bit hard to see, but this is going to be easier than going image by image. Before the court are 3 emergency petitions for review pursuant to the May 15, 2025 supplemental order regarding the buffer zone. After hearing and review of the petitioner's written submissions, the petitions of Thomas DeRosier and Jason Grant are allowed in part and denied in part, and the petition of Erica Walsh is denied. So this is all coming out of the Karen Reed case. The buffer zone generally limits demonstrations at the courthouse and within a buffer zone. Among other things, the buffer zone order prohibits within the buffer zone, quote, noisy protests, and, quote, the display of written or graphic materials that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of their duties. Specifically excluded from the scope of the buffer zone, restrictions are, quote, quiet off-site demonstrations on public property in areas and at times that do not interfere with trial participants' entrance into or exit from the courthouse and that do not interfere with the orderly administration of justice and that are not intended to influence any trial participants in the discharge of their duties. Petitioners claim that the police unlawfully applied the buffer zone order to restrict their activities outside the courthouse. Specifically, the police, 1, removed DeRosier from an area across the street from the courthouse because he was peacefully filming the courthouse's exterior. 2, did not permit Grant to stand across the street from the courthouse while holding an American flag and a sign displaying a Bible verse, 2 Corinthians 3:17. Now the Lord is the Spirit, and where the Spirit of the Lord is, there is freedom. And 3, arrested Walsh for trespassing while on a public sidewalk across the street from the courthouse because she was wearing a sweatshirt stating Criminals Control Norfolk County. So, discussion. Petitioners request that the court invalidate the buffer zone order in its entirety. Court declines to do so for the reasons given in the original buffer zone order and as revised. They seek judicial review pursuant to paragraph 5 that provides any person whose activity has been restricted may request review by a judge of the Superior Court. These claims largely turn on whether the activities at issue within the buffer zone were intended to interfere with the administration of justice or intended to influence any judge, juror, witness, or court officer in the discharge of their duties. Based on the limited record before the court, it does not appear that DeRosier's conduct in peacefully filming the courthouse's exterior from across the street, but not any jurors or other trial participants, was by itself intended to interfere with the administration of justice or influence anyone involved in the Reed trial. Nothing before the court suggests that DeRosier was being noisy, let alone protesting, demonstrating, or interfering with anything or anyone at all. Accordingly, DeRosier did not violate the buffer zone order. Grant's conduct is a closer question. Certainly, waving an American flag and displaying a Bible verse about freedom may be intended as acts of patriotism and religious expression. Such conduct gives the court pause, however, in the context of the Reed trial, where some members of the public are passionate and vocal about their desire to, in their words, quote, free the defendant. What does other people's opinions about things have to do with Grant? In addition, Grant's location across the street from the courthouse and apparently just outside of the Norfolk County Registry of Deeds, which houses the grand jury, the jury pool, and probation and other Superior Court offices, was ill-advised because, in this court's view, that area may fall within the scope of courthouse property, where all demonstrations are prohibited under the buffer zone. Across the street from the courthouse falls within the courthouse? I don't know about that. Nevertheless, assuming that Grant was not on courthouse property but within the buffer zone, the court finds no violation of the buffer zone order because the record does not show that he was acting in a manner suggesting that he intended to interfere with the administration of justice or influence a trial participant. Walsh stands on different footing. In context of the ongoing Reed trial, which has generated some public sentiment against Norfolk County officials, wearing a sweatshirt stating criminals control Norfolk County while across the street from the courthouse demonstrates an intent to interfere with the administration of justice and influence the Reed jury. His citation to Cox, a group of demonstrators parading and picketing before a courthouse where a criminal charge is pending in protest against the arrest of those charged, may be presumed to intend to influence judges, jurors, witnesses, or court officials. Because in this specific context, where Walsh was standing in close proximity to the courthouse within the line of sight of trial participants, while wearing a visible message criticizing participants from Norfolk County, including law enforcement officers, prosecutors, and the court itself, Walsh's conduct was directed towards interfering with the administration of justice and influencing any judge, juror, witness, or court officer in the discharge of their duties. Walsh violated the buffer zone order. Therefore, contrary to Walsh's argument, the officer's actions pursuant to the buffer zone order did not violate her First Amendment rights. So that is the gist of the ruling on the review of those three individuals' challenges. This seems to me to be, it's relying on the context of the Karen Reed trial and other people's thought processes and so forth to impute a perspective to Ms. Walsh. You can certainly think that criminals control Norfolk County without taking a particular position on Karen Reed's case at all. You may not know much about Karen Reed's case. It's not everybody who, is intrigued and interested in following the details of criminal court cases. You might be interested for some other reason. You might be interested because of Sandra Birchmore. A lot of, it seems to me, imputing a mental state because of, the actions and viewpoints of other people. And I'm not sure that this example, a group of demonstrators parading and picketing before a courthouse where a criminal charge is pending in protest against the arrest of those charged, may be presumed to intend to influence judges, jurors, witnesses, or court officials. Wasn't the point of that the fact that they might be seen, they might be heard? This is where we came with the issue of, the noisy protest and the away from areas where the entrances and exits are. At the times when those parties are using those entrances and exits. I kind of thought that was how we limited this, because yes, if you're picketing in front of jurors coming and going, specifically if you're picketing the specific case, this is not a free Karen Reed sign. This is criminals control Norfolk County. I just am not real satisfied with that particular inference. We can infer that she wanted the jury to do what with that information? She wanted the judge to do what with that information? Criminals can control Norfolk County, and Karen Reed could be guilty. Those things can coexist. They're not mutually exclusive. It's not our fault. The evidence tends to suggest Karen Reed did not hit John O'Keefe with a car. But I don't know, guys. I don't know what I think about this. I'm not real satisfied with that explanation. I would suspect it's almost certainly going to be appealed up. So we'll see what, if anything, happens with it and where it goes. So that's the only thing I saw that came up. Only new development, but guess that's where we're going to leave it before Tuesday. You got 5 days to go out and protest while the trial isn't going on, guys. You can take it to the Cape even if you want. Actually, yeah, it's outside the buffer zone. It wouldn't violate the buffer zone order, would it? So doesn't matter, I guess, if it's intended. Like, Yeah, I'm not recommending anybody stake out, Bev's Beach House, protest there. But lots of opportunity for First Amendment activity during the next 5 days. And what an opportunity to celebrate the freedoms that we have in America over Memorial Day weekend, where we remember the people who died so that we can have those freedoms. Texas Sister 2, Burgess education on Aperture has changed twice today. Oh boy, no link to CV or LinkedIn, but education only shows associates in computer networking. I hope somebody is tracking the changes. I really do. I hope that there is a clerk or somebody like that. That's following all this on, archiving the changes to the website, because the scramble just doesn't look good, does it? If they're changing his education and not actually removing him from the website, then has he lost his job, or are they going to stand by him? Seems like they're going to stand by him. They're going to stand by him. Maybe even take some of the fall for this terrible misunderstanding that's been disclosed over here in Massachusetts in the Karen Reed case. Complete misunderstanding. He's never said in federal court that he has qualifications he doesn't have. Any error is because of Aperture. They deeply regret it, but it doesn't mean he's not qualified. Doesn't undermine any of the work that he's done in the last 10 years for their company. I think it was 10. I don't remember how long he was with Aperture. He was a forensic examiner for 10 years. Hope somebody is tracking all that. J-Man, cool water hypothermia could explain no frostbite. That's an interesting theory. That would have to be pretty cold water, wouldn't it? It would have to be pretty cold water. Not sure what the water is normally when it comes in your faucet. Seems like it would be in the ballpark of the 55 degrees, right? It's right there. It's below the frost layer. So it's going to have that average earth core temperature, which, as I recall, is somewhere in the ballpark of 55 degrees. Yeah, if you're soaking in 55 degree water for an extended length of time, that could give you hypothermia. I could see that. Don't know how long it would take. Don't know what sort of, heat loss curve that would look like. How long would it take to get to 80 degrees sitting in 55 degree water? I don't know. But that's a theory. That's an interesting one. Hadn't thought about that. All right, guys. So I see it looks like did I miss a super chat? I see Jeff has sent me from Peter Sitchell. Last Thursday, Bev asked Alessi if the defense case will still take only a week and a half. How would that be even remotely possible? If they're editing, they're satisfied with their ability to have poked holes in the Commonwealth's case through cross-examination. So some of the things that they thought they might need to call witnesses to establish, they've decided now they don't need to. That would be one way that it would take. It would take that little time. It does seem very fast to me, but I really don't know. I'm eager to see. I'm always a little bit concerned about you definitely want to edit and you need to edit, but you can over edit. There's that risk again of you're so close to the case as the attorney, you're so familiar with the evidence, all the different versions, the things people have said, how it's evolved over time, all that stuff. And you can lose perspective on how the jury's body of knowledge differs from your body of knowledge. And you can lose sight of those details that you know intuitively, but you haven't mentioned them to the jury. So they don't necessarily take it for granted like you do. That's always a risk with the editing, is that you lose something because of that perspective. But they have a very big team. They've got a lot of resources, a lot of different ideas to be able to sort through the strategy, and clearly have some very skilled litigators on this team. So we'll see how it plays out. But the bottom line is these are strategic decisions that are being made to edit and refine. And in general, that's a good thing. Focus on what matters. You don't have to spam the jury with stuff to see what sticks. That can take away, especially if you've got really strong stuff, that can take away from the strength of what you really do have. So keep it focused. That could explain it. They've got a few strong points that they need to make, and otherwise they're satisfied with the holes that they were able to poke in the Commonwealth's case. I'm eager to see. I'm really enthusiastic about seeing the defense case. All these new experts. Just been little hints of where it could go, but yeah, I'm waiting to see what they've learned since they did this trial the first time. Well, guys, hey, I'll see you on Tuesday. Everybody have a wonderful time off. Spend some time with family. Get some time outside. Have some fun. Do some smiling. Do some laughing. If you're really into that kind of, I don't know, masochistic kind of enjoyment, watch some Phillies baseball. No, actually, the Phillies baseball has been great for the last couple of weeks. It's a roller coaster. It's been great the last couple of weeks. Had a great game. Great game last night. Great game by Luzardo. Great showing. We got a Schwarbomb. Alec Boehm is hitting again. Brandon Marsh is hitting again. These are great things to see. These give us joy in life. So when you get the opportunity to take joy out of Phillies baseball, do take that opportunity. Why not? Why not? Just try not to let that attach you too deeply to what happens after after All-Star break. Because it might not be the same team. It might not be the same game. But whatever it is that gives you joy, guys, do your best to help yourself to some of that this weekend and recharge. Do what you need to do to just keep yourself fully energized, fully engaged, enjoying the moments that you have. Every moment is a blessing, guys. Sometime like that, there's not going to be any more moments, and we never have any idea when that's going to be. So important to appreciate the moments that we have. And what a great opportunity. And another reminder, just like that, how fast things can change. Memorial Day, One day your son is a little baby that you're bathing, and the next day feels like your son could be lost in battle. Son made the ultimate sacrifice. So things can really change in an instant, and it is important to acknowledge that and appreciate that. It helps us keep things in perspective when we're dealing with world problems and corruption and government and stuff like that. Not at all to say it doesn't matter. It does matter. It matters very much. It matters very much, but we also have to take care of ourselves and make sure that we're getting what we need so that we can keep fighting that good fight, guys. So with that, have a wonderful weekend. Do enjoy yourselves. Maybe have a little barbecue. If you're so blessed, get some sunshine. Little sunshine's good for you. Wear your sunscreen. But get that vitamin D. You got to get a little bit of vitamin D. If you're in a place where you're going to be blessed with that kind of weekend. Guys, I'm going to look forward to being back here bright and early on Tuesday. I expect to be fully chipper, ready to go, completely rested. And we'll be wrapping up the Commonwealth's case before you know it. That gives me some joy. So we'll see what they got with what they have left. And Tuesday could be the end of it. We'll see. Everybody, thank you for being here. Thank you to the chat. Thank you for the support. Thank you to the mods for keeping everything's running smoothly. Thank you for all of the great insights and comments and theories and things to think about. Really just one of the wonderful parts of being able to watch a trial together in a group like this is the group mind. It's a wonderful thing to be able to dip into. Thank you for sharing all of that with us. So with that, guys, take care. Thank you all, and we'll see you back on Tuesday.